first all of you to this international conference on international law issues and challenges organized by Indian Society of International Law. You may be aware that International Society of International Law is working since 1959, and ISL, this is the abbreviation of Indian Society of International Law. So this society is very fortunate to have blessings from various judges of International Court of Justice, from Justice Nagendra Singh, various ambassadors, they are the life members of our society, and academicians, ministry, government officials, members from the bar bench, right? So diplomatic agents, so all of them, they are the members of Indian Society of International Law. And I would like to inform you that even students, they can also be the members of Indian Society of International Law. So thus our responsibility is very high, because we are required to give contribution in this particular conference, which is organized by Indian Society of International Law. So let me welcome all of you to this particular session. And this session is on international humanitarian law in contemporary conflicts, challenges and compliance. So this particular topic is very relevant in the present day context, because Russia, Ukraine, even now also they are not ready to stop their war. And in addition to this, Israel, Gaza, in addition to this, Iran is also there. And so therefore you will find that slowly and gradually, maybe reasons are different, but however the outcome is like the war situation is there. And India is having its own philosophy, and we are having our own stand pertaining to each and every armed conflict. But then it is very pertinent to think and to ponder upon this particular fact, that is, what are the contemporary conflicts and contemporary challenges to the international humanitarian law. So in this background, I would like to I would like to request first of all our Secretary General, Dr. Narinder Singh, to have few words. Please, sir.
Okay, you can announce that. I'll just give a very short. Good morning. I welcome you all to the 10th International Conference on International Law, organized by the Indian Society of International Law. And today you are discussing a very relevant topic on international humanitarian law, and at an especially important time, because this year the Geneva Conventions are now 75 years. We just 2 months ago, we celebrated the 75th anniversary of the adoption of the Geneva Conventions. And although as we just heard, conflicts continue around the world, but we hope that the Geneva Conventions, at least, they lessen the severity of war, they lessen human suffering, or the unnecessary suffering and indiscriminate damage that occurs during wartime. And we hope you have interesting discussion, you have much food for thought, and substantive exchange of ideas and perspectives. And with that, I would like to welcome our chairpersons today, Professor Rashmi Salpekar and Professor Harbachan Singh, with the mementos. Thank you, and now please take over and continue with your session.
Good morning, everyone. And welcome to the 10th International. Good morning, everyone. Good morning, everyone. Welcome to the 10th International Conference on International Law, organized by the Indian Society of International Law. We're happy to have our two chief persons here, Professor Dr. Rashmi Salpekar and Mr. Harbachan Singh. Professor Dr. Rashmi Salpekar is a professor of international law and Dean at Vivekananda School of Law and Legal Studies, VIPS. She has a PhD in International Law. She has an LLM in Master of Human Rights and Duties and MA in Sociology. She has more than 15 years of experience of teaching and research, including the experience of working as a research officer in Maharashtra State Human Rights Commission, Mumbai. She has specialization in public international law, international criminal law, international humanitarian law, international trade and commercial law, and human rights. Mr. Harbhajan Singh, now retired from an exemplary career as a solicitor and barrister, concluded his career with the United Nations in New York City in 1999. Mr. Singh received a barrister at law from the Honorable Society of Lincoln's Inn in London in 1967. Years later, he acquired a Master of Arts in International Law and Public Administration at St. John's University in New York in 1981. Regarded as a leading light in his field, he was bestowed over 24 awards and recognitions by various US congressional representatives, New York State senators, assembly members, and council members, as well as the Comptroller of New York. Since his retirement from the UN, he continued to enjoy the camaraderie with some of the heads of states and governments for a considerable time afterwards. We are happy to have both of our chief persons here. Thank you.
Thank you.
It is also to be noted that each speaker will be provided 12 minutes and a timer has been set for the same.
Okay, so who will take care of time? You people?
The two volunteers there.
Acha, you are here. Okay, so what you do that just before 2 minutes, you can just hint. Okay? Yeah. Okay, thank you so much. So I was not aware that you are going to make introduction. Otherwise, I would have made introduction of our theme later on. So it's fine. So let's start with this particular session. And we are again very fortunate. Can you just keep our session on the slide? Who is taking care of this slide? The first one. This is not our session. No? Session 1. We want on the screen our session. Session 1. उसके पहले सेशन 1 चाहिए. दिस इज सेशन. हाँ, प्लीज. So we are very fortunate to have guidance. We will take guidance from Mr. Harbhajan Singh, who is having extensive experience working with United Nations headquarters in administration and management. So welcome you, sir, and we are happy that you are with us. So with this, let's begin and let's have all the thoughts of our panelists. So I'm following the order which the organizers have given me. Do we have Sarthak Gupta? No. Gurmeet Nehra? Yes. So I welcome Mr. Gurmeet Nehra. He is from Indian Law Institute and he will be speaking on Israel's war on Gaza. Please. Yes, please, please.
I welcome all of you and very good morning to the panel and my fellow co-speakers. So this present Israel-Gaza war was followed by the humanitarian considerations and the war situation which was already there. The world was facing in Russia-Ukraine war. So after that, as we know that this after the October 7 attack of Hamas, that was Operation Al-Aqsa flood. So there was some hostage taking and attack made on Israeli civilians by the Hamas in Israel area. So with this, the Israel responded to Operation Swords of Iron. So they want to remove the host. So this was the twofold purpose of Israeli forces with which they began this operation was to take back their hostages and to remove the hostile forces from Hamas, which was working against Israel. So basically, the motive was under the humanitarian consideration, with which this operation started. But after that, since the operation is prolonging and there are very the proportionality of the use of force is under consideration. So this Israel-Gaza crisis brought twofold consideration under international law under Article 51 and IHL consideration, international humanitarian law consideration before us. So to begin with, my first proposition is regarding Article 51 of the Charter. So the Israel, they mentioned that they were under attack and they were acting under the right to self-defense provided under the Article 51 of the UN Charter. So the UN Charter provided for the this right to self-defense, but the basic three corollaries under international law is the principle of necessity, principle of immediacy, and principle of proportionality. So the principle of necessity comes from the Caroline case from the beginning. So Caroline case says that when the overwhelming necessity is there, leaving no choice of deliberation in that particular situation, force can be used and under the principle of necessity. So if we analyze the Israel's action under the principle of necessity, so we find that their civilians were taken hostage by the Hamas. So this give them a valid necessity to act under self-defense, and this was an overwhelming necessity situation. And second is the principle of immediacy. Principle of immediacy, because the every passing moment, the life of these people were in danger who was taken hostage by the Israel by the Hamas. So the principle of immediacy, it was well. I mean, their action as a use of force is very well under the principle of immediacy. But I mean, the third test, which is very much crucial, the principle of proportionality. The principle of proportionality says the use of force can be made under Article 51 of the UN Charter uh, to just avert an attack or to stop the armed attack which is made to justify the self-defense situation. But we are seeing that lot of attack has been made on civilians, and the Israel attack is causing casualty. I mean, is causing problem to more than 2 lakh Gaza civilians, and they were not allowed humanitarian aids, food, or water to them. So basically, this is the seizure of Gaza and the starvation war which is going on there in the Gaza situation. So under if we come to from Article 51 consideration to IHL consideration, we analyze this situation under IHL, International Humanitarian Law. So under IHL, reprisals are not permitted. Reprisal against civilians are prohibited as a means of warfare under additional protocol, Geneva Convention, Article 51.6 and 51 subclause 8. So this what I as a researcher feel that this is a apart from the self-defense situation, this is going as a there's such a heavy use of force, and the stopping of the food, water, and other aids, other I mean humanitarian aids to the civilians amount to a reprisal situation where they are punishing civilians also against which is not permissible under IHL. And IHL obligates that if any party violates its obligation, then it does not release the other party from the obligation. Not, I mean, the obligation to not to attack the civilians, not to make reprisals stays. So Israel as a party, they have to respect the international law, the IHL. And one more consideration which in under international law comes before us, that the situation, the Gaza is an occupied territory. So some of the authors under international law, they say that attack can be, I mean, this is the self-determination which the Palestinian people is fighting against. And I mean, so once terrorist is others freedom fighter, so that kind of situation. But I feel that right to self-defense can be exercised against non-state actors also. So in that proposition, the anticipatory self-defense, the expanded version which is coming up of self-defense, Article 51, so that allows non action against non-state actors. So non-state actors like Hamas can be acted against, but it has to be acted under proportionate measures. And the first main duty is with the Security Council. Security Council has to be taken into confidence, and under this situation, there is need to be take a coercive action by the under the Security Council resolution. But as we have seen, we were seeing in this situation that Security Council, Secretary General of United Nations, everyone was making requests to the Israel to exercise restraints and to have a humanitarian consideration to the situation. But Israel is also making not heeding to the request. So some of the key resolution passed by the Security Council, one I would like to mention is 2712 of 2024. This Security Council resolution asked for the release of hostages, and the Security Council resolution 2720 of 2024, they specifically mentioned about the rapidly worsening humanitarian situation in Gaza, and asked all parties to request to respect the humanitarian law and human rights of the civilians. So the Security Council in these resolution, and another resolution is the Security Council resolution 2735 of 2024. This also condemned the military action in civilian dominated areas, and it specifically condemned the attack on schools, hospitals, and refugee camps. So, the Security Council in 2735 resolution, 2728 resolution, they specifically asked for the immediate ceasefire, release of hostages. But I mean, we are not seeing the any de-escalation in the situation, and the situation is worsening day by day. The ICJ under the case was come before ICJ under the for the provisional measures under the Genocide Convention. So in that particular decision, the earlier no provisional measures were issued by the ICJ, but it modified the January 26 decision, or by the decision of 20 May 24 of this year, and they issued provisional measures. And ICJ particularly observed that the Rafah situation is a situation, and more than 8 lakh people are displaced. So ICJ ordered Israel to immediately halt the military operation in Rafah. And in this situation, so ICJ re-emphasized on the unhindered humanitarian access, and basic amenities need to be provided to the Palestinians. What I want to submit in this my paper, that use of force or war is not a situation, and it does not help anyone in the long run situation, because we are seeing that this conflict is broadening, and Hezbollah also entered in the conflict, and then Lebanon, this spread to Lebanon, and Iran is also getting involved in this. So my submission to this Israel war on Gaza is that the use of force war does not help anyone in the long term situation, and it has to be the peaceful settlement of dispute that can bring lasting peace to the area. So I mean, there is no recourse to the this can help. So under chapter 6, peaceful recourse or some diplomatic channels need to be explored. This is my humble submission. Thank you.
Thank you so much. Shall we take questions right now, or after having all the presentations we can take?
Let's hear everyone first.
Question. Let's hear everyone first. Okay. So you please be with us, and then we will take up questions after all the presentations. Thank you. Please.
Thank you, ma'am.
Yes, so just now we have listened the thoughts of Dr. Gurmeet Nehra, and he emphasized on the principles of international humanitarian law, mainly principle of proportionality and as also principle of distinctiveness, and he focused mainly on the situation of Israel Gaza. He referred mainly 3 resolutions passed by Security Council, and further he ended his presentation by giving a suggestion that use of force will not help to correct the situation in the long run. So with this, now I would like to call the next speaker, Ms. Savitha Suresh from Delhi Metropolitan Education, Noida. And she is going to speak on digital silence, the effects of internet censorship on conflict reporting. Yes, please. I hope this is the right title. It's okay, not an issue. Whatever your title is, I will note down it. No, actually, first 2 are not there. After Gurmeet Nehra, she is Savitha Suresh only. मैं इसको नीचे कर सकती हूँ सर? 1 second, I will take just 1 second. So let me welcome Dean VIT Law School, Professor Benaji Chakka, and he is also Executive Council member of Indian Society of International Law. So he's an expert in international humanitarian law, and he's an expert on many other topics also. But as the session is IHL, so therefore I am highlighting his expertise in this session. Welcome, sir.
May I begin?
Yes, please.
Okay, good morning everyone. I'm Savita Suresh. Today I'm presenting a paper titled Digital Silence, The Effects of Internet Censorship on Conflict Reporting. Now this is a paper that is co-authored with Subramaniam H. He was unable to be here today. Okay, so I'll start by saying that the internet originally began as a community for the advancement of technology and business. Is that better? Yes. But with the advent of social media, it has turned into a complete social, economic, and political arena. And it has, I'm so sorry, please excuse me. And today, access to internet is considered a part of fundamental human rights, basic human rights at the international level as well as at the national level. On the international level, it is protected under the ICCPR. On the national level, it's included within the ambit of Article 19(1)(a) of the Constitution. So the main question that we've asked in this paper is whether this fundamental or basic human right to access to internet extends to conflict zones. To study this, we've taken two examples. The first is the Russia-Ukraine war, and the second is the conflict in Manipur in 2023. I'll start by introducing certain types or methods of censorship on the internet. So you have two major types of censorship on the internet. The first is a complete blackout, and the second is a partial blackout. Now, a complete blackout includes total suspension of all internet, mobile, and broadband services. A partial blackout can range from things like blocking, where the state does not have jurisdiction to limit, so it resorts to blocking certain websites entirely, to take down where the state does have the jurisdiction to declare content either illegal or inappropriate and require that the service providers themselves take it down. Russia and India both have engaged in blocking, takedowns, and other methods like filtering, surveillance, and search result removals. There are I'll move to the situation in Russia, with your permission. So the legal framework that applies on the international stage is essentially a combination of international humanitarian law, or the law of armed conflict, international human rights law, and the international communication systems law. These collectively are strong on paper and do protect and preserve the fundamental right to access to internet. And there's a 1996 ICJ advisory opinion called the Threat or Use of Nuclear Weapons, which very specifically says that any kind of attack that is premised on military necessity must distinguish between a civilian population and active combatants. Now, this is the same theory that we apply when we talk about cutting off internet access. The Russian attack on Ukrainian infrastructure is not an attack that is premised on military necessity. It's not an attack that is solely premised on limiting information spreading about the movements of their military. The Russian attack on, or the Russian cyber attacks on Ukrainian infrastructure since the start of the war have been to cut off, or targeted to cut off, the civilian population entirely from their own government. I'm sorry. Since March of 2022, Russia has perpetuated these cyber attacks in order to do three things. The first is gain complete informational control. This was achieved in July of 2023 when, after 3 days of continuous shelling, Russian hackers redirected all the communication systems in the occupied territories of Ukraine to the Russian infrastructure, thereby allowing them to censor everything that the population living in occupied Ukraine was able to receive and access. The second is, under their federal law, by blocking access to certain content. Now, although Russia does not have a national law that specifically limits free speech, Their federal law allows them to limit free speech on the premise of defense or security of state or maintenance of constitutional morality. In July 2023, Russia utilized this law to block access to applications like Twitter, YouTube, Facebook, Instagram on the premise that they were perpetuating terrorism and violence, once again, in the occupied territories. I'm so sorry, please excuse me. And lastly, in November 2022, Russia after gaining the complete informational or control over all of the information in these occupied territories, has then perpetuated multiple attacks on the existing Ukrainian infrastructure. The war began in March of 2022, and by November 2022, over 60% of mobile operator stations in Ukraine had been permanently disabled, and over 4,000 mobile operator stations had been destroyed, and 18 TV and radio stations had been completely demolished. Today, in Russia-controlled Ukraine, 4,457 different websites are blocked. Of these, 3,617 are news-related websites, and 351 are counter-propaganda websites, and about 25 of them are official government domains, including the office of the President of Ukraine. So, in a sense, Russia's actions in Ukraine are not limited to military necessity, are not premised on the principles of proportionality as is required under the law of armed conflict, but are specifically targeting civilians and civilian infrastructure in an effort to control the information that is flowing out of Ukraine completely, in an effort to segregate the civilian population in occupied territories. It's a direct attack on a civilian populace and constitutes a war crime under the Geneva Convention as well as the First Additional Protocol. With your permission, I'll move to the Indian situation. Okay, so Indian censorship law is premised on three things.
Would you like to have water? Can you please send me?
Yes, please. I'm sorry. Premised on three factors. First is criminalization or threat of criminalization. This is achieved through speech restrictive provisions in laws like the Indian Penal Code, UAPA, AFSA. The second is direct censorship and control. This was originally achieved through the Press and Books Registration Act of 1867, the Vernacular Press Act of 1878, and although these have now been repealed, the principles under them have been carried forward into independent India. The third is the creation of a propaganda machinery backed by statute. Now, these are all British era legislations or colonial era legislations that we have carried forward into independent India and that are originally applicable on the freedom of speech and expression under 19(1)A and are today applicable on the right of access to internet as well. The primary justification behind cutting off access to internet in any conflict area is that it is necessary for the preservation of law and order, or for the preservation of public order, security of state. Now, a 2023 IFF and Human Rights Watch study found that cutting off internet access in a conflict zone does not help or assist in the law and order situation. Largely, restricting internet access in these zones is premised on vague, tenuous, and arbitrary considerations that have little to no understanding of the actual law and order scenario. And rather than helping or enabling public order, they complicate matters worse by cutting off the populace in that area, by restricting the ability of activists and journalists to share real information in real time, and by creating a bubble where baseless rumors can grow. And lastly, they restrict your ability to hold the state accountable for abuses that are committed in that war zone, because there isn't active reporting in real time and there isn't accurate documentation of it. So this is a violation of our Article 19(1)A right. This is also a violation of the Supreme Court's guidelines in Anuradha Bachchan versus Union of India, as well as the requirements under the 2017 Telecom Suppression Order rules. It's I'll deal specifically with the issue in Manipur. The conflict in Manipur began on 3rd 3rd of May, sorry, and on 4th of May, the union government imposed a shutdown across 8 different districts. Now, the shutdown lasted largely till July, when it was lifted partially, but the complete internet blackout across 8 districts lasted throughout these 4 or 5 months. Now, within the first 14 days or within the first fortnight of this shutdown, this blackout, in Manipur, over 63,000 people were internally displaced. Over 178 refugee camps were set up across the state. Over 10,000 police and paramilitary forces were deployed in the state. And despite this, we've seen videos, we've seen evidence after the fact, months after the fact, of the abuses and the violence that was committed in the state. So to say that shutting down the internet or cutting off access has in any way aided in maintaining public order is patently false. So it's on this premise that we answer the question we originally asked, which is that yes, we do believe that access to internet should be a fundamental right in conflict zones. We also believe that this is a right that is already existing on the statute books, but the problem is not with the creation of the law, but rather with the enforcement mechanism for the law. So we've made certain recommendations on both the international level and the national level for effectively implementing these laws. On the international level, we'd recommend 2 things. One, we'd recommend that a cyber attack be specifically included in the definition of use of force under the UN Charter, and that this amendment to the UN Charter be made binding on all state parties, so that the Security Council would be able to treat a cyber attack as an act of war. And second, we'd recommend the constitution of a monitoring agency at the international level with revolving membership, where the state being investigated would be forced to sit out and the decision would be made binding. And this committee should include experts in the field, and it should be allowed to present yearly reports to the General Assembly the same way the Human Rights Committee does. And it should be allowed to investigate both cyber attacks as well as make rules for preserving internet freedom. On the national level, we'd recommend there is the provision for a review committee under the Telecom Suppression Order rules of 2017. This review committee is supposed to review every suspension order that is passed within a period of 5 days. We'd recommend a change in the composition of this committee to include more civil society actors and members of the opposition to make the committee more balanced. We'd also recommend that such committees be set up at the district level in every state, independently of the existing state machinery, in order to allow them to function more independently and impartially, similar to the structure of the CBC or the Lokayukta in the states right now. Thank you so much.
Thank you so much, Ms. Savitha. Savitha, she highlighted access to internet as one of the fundamental right and freedom for all. And she highlighted mainly 2 situations, international, national. In international, she highlighted Russian situation, and in India, she highlighted the situation of Manipur. And she highlighted her hypothesis, which she was dealing with. It was like just by restraining the internet facilities, you won't be able to correct the situation. And ultimately, as per her presentation and in her paper, she proved it also that how it is not required. In Indian situation, she referred the Human Rights Watch report, and regarding Russian situation, Russia and Ukraine, I think she has referred all the sources, like whatever has been published by Russia and Ukraine, right? So these are the sources which seems to be that they have used, both of the researchers, right? Yes. So thank you so much for such a nice presentation. And with this, I wanted to go ahead with the next speaker, Mr. Shankar Girija Velayudhan. Yeah, University of Mumbai. Please welcome. And he is going to speak on ethical dimensions of warfare, lessons from Chanakya's Arthashastra for international humanitarian law. Please. I request all of you that kindly note down your questions and the points of observation so that we can discuss it after all the presentations.
Yes. Good morning, everyone. Thank you so much for giving me this opportunity. Today I will be focusing on ethical dimensions of warfare, lessons from Chanakya Arthashastra for international humanitarian law. Before beginning with that, I would like to emphasize some lines from Arthashastra which talks about war. Arthashastra's book, chapter number 2, uh, book number 2, chapter 10, 6th, 7th page number, stanza 10. One can lose a war as easily as one can win. War is inherently unpredictable. War is also expensive. Avoid war. Try upaya, that is 4 strategies. Then sadgunyas, 6 forms of non-war pressure. Understand the opponent and seek to outwit him. When everything fails, resort to military force. Thus, it focuses that Chanakya always emphasized that war should be avoided, but at the same time, he is also seen as a pragmatic person who always wanted to win. But we need to make a note that he never went for expansion beyond Southeast Asia. War has always long been considered one of mankind's greatest curses. In the never ending pursuit of becoming a superpower, states often neglect the well being of their citizens, forgetting that a country is fundamentally made up of people. Country leaders are frequently willing to sacrifice their own citizens for the sake of conflict. In the world marked by anarchy, while completely eliminating war may be impossible, we can certainly aim to reduce its intensity and mitigate its negative consequences. This requires the establishment of strict rules of war anchored by a strong ethical framework. Contrary to the belief that ancient history offers little in the way of lessons, Chanakya over 2400 years ago provided rules of war that remain relevant and applicable to contemporary armed conflict. Known as Vishnugupta and Kautilya, he was a learned Brahmin, political strategist, and counselor to the Emperor Chandragupta Maurya. Despite being born in an era which was obsessed with conquest and expansion of empires, Chanakya promoted ethical guidelines for warfare, demonstrating remarkable foresight. Chanakya always adopted a humanitarian approach towards defeated peoples, emphasizing particularly practicality over idealism. Notably, he never sought to expand his kingdom beyond Southeast Asia. His writings on statecraft, military strategy, governance, and foreign policy are remarkable. And he talked about 3 types of war: Prakasha Yuddha, Kuta Yuddha, and Sunnima Yuddha. Prakasha Yuddha basically is open and rule based war, whereas Kuta Yuddha talks about unjust war, and Sunnima Yuddha talks about silent fighting. He always approached the type of war on the basis of the circumstances and the situation. Throughout his teachings, he promoted key ethical principles of warfare such as humanity, compassion, distinction, and proportionality, at a time when these ideals were often overlooked. Chanakya is often mischaracterized as an advocate of unethical and immoral practices, particularly the notion the end justifies the mean. In reality, he did not promote or engage in unethical methods of warfare for personal benefit, except in instances where the state faced extreme danger. Scholars like R.P. Kangle notes that the Buddhist Lankavat Sutra refers to Kautilya as Rishi, while Arya Sutra, author of the Jatakmala, parades his knowledge of Arthashastra. Additionally, Jain scholar Somadeva respectfully refers to him as Nyaya Vidya. So when we talk about Chanakya's Arthashastra, ethical principles of warfare under the Arthashastra, Chanakya advocated several crucial principles of warfare. Core to the concept was dharma, which compels the rules to conduct war with moral integrity and strategic vision. He stressed the importance of protection of civilians and proportionality in the use of force. He also emphasized that the war should not be fought for mere conquest or realization, but should be fought to ensure stability and restore peace. At the same time, the key principles he focused was negotiations. Chanakya advocated for the diplomacy as the primary means of conflict resolution, similar to the UN charters. Ban on unlisted weapons. The Arthashastra prohibited the use of unlisted weapons and also mandatorized that the symbol of the king should be printed on the embarked on the unlisted weapons to protect civilians, paralleling to the international humanitarian laws restrictions on certain weapons. Distinction. Chanakya stressed the importance of protecting non-combatants, aligning with IHL's principles of distinction. Also, protection of prisoners, emphasizing human treatment of prisoners, treatment of the sick and the wounded. Chanakya called for compassion towards the incapacitated, echoing IHL's mandates. Prohibition of attack on horseday combat. Horseday combat, as stated under contemporary IHL, is a French term that refers to persons who cannot take part in war as they are injured. Thus, it is prohibited attack on soldiers who are horseday combat, those who are no longer participating in war. Even Arthashastra states that the categories of people not be harmed when the enemy fort or camp is attacked. Patila, those who have fallen down. Paranmukh, those turning their backs on the fight. Adipanna, those who surrender. Muktakesa, those who hear or loss as mark submission. Mukta Sastra, those who have abandoned their weapons. Bhayavirupa, those whose appearance is changed through fear. Ayudhyamana, those who are not taking part in the fight. He also talked about command responsibility. Chanakya held military leaders accountable for their troops' conduct, reflecting IHL's command responsibility doctrine. At the same time, he always focused on dharma-based governance. Chanakya promoted just governance in occupied territories, paralleling IHL's respect. Now we will see the comparison of ethical dimensions of warfare with Arthashastra and the international humanitarian law. So the similarities in terms of the concept of proportionality and necessity, both Chanakya and IHL recognizes the use of force in war should be measured and not result in excessive harm. Although Chanakya's focus is more on pragmatic statecraft than on universal humanitarian principles. The difference is IHL explicitly centers civilian protection within the proportionality principle, while Chanakya's concern with restraint is more strategic, aimed at preserving the state's long-term interests. Nonetheless, it overlaps suggests that Chanakya's teachings could enhance the moral foundation of contemporary IHL. Whereas the distinction between combats and non-combatants, while both system stresses protecting civilians, IHL applies the principle of universality, whereas Chanakya's guidelines are more context specific. When we talk about treatment of prisoners of war, both emphasize human treatment, but IHL extends protection to all prisoners of wars, while Chanakya focus is more on hierarchical, favoring higher status captives. Protection of the sick and wounded. Both frameworks advocate for the human treatment of incapacitated individuals, with Chanakya emphasizing strategic benefits alongside ethical consideration. Ban on the use of certain weapons. While IHL codifies prohibitions on specific weapons, Chanakya's guidelines is more general, focusing on maintaining ethical conduct in warfare. Some of the recommendations: prohibition of certain weapons. It's the extended current bans to address ethical concerns should be extended to surrounding new technologies like cyber war. There should be improved protection for non-combatants, strengthening enforcement systems to protect civilians during asymmetrical warfare, reinforcing proportionality and necessity, emphasizing Chanakya's approach to ensure military actions are ethically grounded, human treatment of prisoners of war. Shaping prisoner reintegration practices around Chanakya's human principles are necessary. Creation of a supranational enforcement authority. Enforcement remain a significant challenge despite having robust principles of international humanitarian law. For the violations of ethical conduct in warfare, Chanakya adopted a well-governed retaliation system. There is a dire need for enforcement agency that is independent, unbiased, transparent and accountable. Enforcement of IHL currently depends on international bodies like the ICC and ICJ and its member states. However, these bodies lack a strong enforcement system and are accused of being biased. Adherence to IHL principles can be achieved only through an unbiased supranational enforcement agency that has the power to supervise, investigate, and sanction violations. In the conclusion, Chanakya is often considered a cold-blooded strategist, but when we read Arthashastra, we get to know a different side of Chanakya, who always followed and promoted ethical principles of warfare, emphasizing compassion, duty, and restraint. His work acts as an ethical framework for warfare, the same as today's IHL. Despite him being known as a political foxy, he emphasized the importance of following proportionality, human treatment of prisoners, distinction between combatants and non-combatants, and protection of the sick and wounded, as enshrined in the Geneva Conventions and additional protocols. He also prohibited the use of unlisted weapons and always believed that conflicts can resolve through negotiations, the same as modern IHL, which bans unnecessary injury and suffering of humans. Thus, Chanakya's ethical principles of warfare were much more ahead of their time because he always aimed and visioned for long stability and peace by promoting restraint and ethical conduct. Synthesis of Chanakya's ethics of warfare and modern IHL can enhance the moral framework of warfare, especially governing the asymmetrical warfare technology. This approach can only be effective when an effective enforcement mechanism safeguards the significance and productiveness of IHL. Thank you.
Thank you, Mr. Shivranjan. So he has made historical research and he compared with international humanitarian law, and in his historical research he referred mainly Kautilya's Arthashastra. So generally in international humanitarian law we do refer our history or like epics and etc. So generally we relate it with Mahabharata. However, you have made a very exhaustive research on Kautilya, and you have highlighted various features also which he has highlighted in his work. And the main thing which you have highlighted, that is what Kautilya said, that avoid war, and you are required to, means if you wanted to do war, then it is only for bringing stability and also to ensure peace in that particular area, and not only to realize that how we are powerful in comparison to other party. So that aim which he has given in his work. So thank you so much, Mr. Shivranjan. So with this we are moving towards the next speaker, and he is Dr. Sri Chokalingam. Yes. And he is from B.S. Abdur Rahman Crescent Institute of Science and Technology. He is going to speak on international humanitarian law and protection of the civilians in the armed conflict in Gaza Strip, a critical study. Yes.
Very good morning to one and all present here. I am Professor Chokalingam, Dean, Crescent School of Law, Chennai. First of all, I thank our ISIL for giving me this opportunity. I wish to present upon the humanitarian law concept, especially with regard to the protection of civilians. As we are well aware, the very object of the UN is to save the succeeding generation from the scourge of war. That was the very object with which the United Nations was established in 1945. Almost 79 years have passed. Fortunately, on many occasions, the UN, especially through the Security Council, was able to achieve its object. But, however, as a part of the international law, we have developed international humanitarian law also with the solemn object of protecting the commoners, especially the civilians. But unfortunately, in any armed conflict, those who are ultimately suffering is none other than the common people who may not have any control over the conflict. So with that solemn objective of protecting the civilians, the international humanitarian law was developed through the various Geneva Conventions and also the protocol. But my focus as on today is about the situation of the civilians in Gaza especially. Of course, we know very well when Hamas started attacking Israel, especially the civilians of Israel, on October 7th, around 1,200 people were killed and around 400 people, Israelis, were abducted. As a result of which, the government of Israel started attacking Gaza. Almost during this last 1 year, more than 44,000 people have lost their life. But as per our international law as such, the primary responsibility to save people rests with the Security Council. But unfortunately, whenever there is conflict of interest among the powers which are having veto, US, UK, Russia, China, and France, whenever there is conflict of interest, the Security Council is unable to take appropriate action. Of course, as pointed out by Gurmeet Mehra, the Security Council has already passed a resolution to protect the interest of civilians. But when one particular nation is taking armed action, not only against the non-state actors, but also against civilians, because during conflict it will be very difficult to identify civilians who are combatants. So that is also there. But when indiscriminate action is being taken by one nation, the Security Council is virtually unable to protect the interest of the civilian. That is what actually going on. So what the international community has to do in this situation? Because once again I am reminding, the primary responsibility rests with the Security Council. But so far, the Security Council, of course, even recently the Council is going on deliberating about the actions that have to be taken to save the people. But still, no effective measures have been taken by the Security Council. But during January 24 also, our reputed International Court of Justice, in its interim order, directed the countries to take care of the interest of the civilians. It's an interim order. But the interim order, of course, is more followed in its violation, and the conflict is still going on. And our country is also taking so much effort, and the idea of the nation very often is to reform the United Nations. Every nation is talking about reforming the United Nations. India is also supporting. Of course, most of the major powers may also support our contention. The Security Council has to be, the composition of the Security Council has to be reformed. But we all know very well, any reform at the UN level is possible only with the support of all the 5 permanent members. Otherwise, the charter can never be amended. If the charter is not if the UN charter is not amended, then naturally, once again, all the 5 veto powers will be there. When any one nation is obstructing any effective measures by the UN, then it will be impossible for the international community. So we are facing, this is the reality today. But as a student of international law, I can suggest only 2 measures, because we know very well, when there is no consensus among the veto power yielding nations, the UN can do only one thing, as it happened in 1950 in Korean conflict, when the Security Council was not in a position to take effective measures. The General Assembly has come into picture, and the General Assembly was in a position to pass a resolution, the famous resolution, Uniting for Peace resolution of 1950, and the General Assembly was in a position to protect the people of Korea. So, of course, it may be a gigantic task, because without the support of the major powers like US and Russia, it will be very difficult at the international level. We understand. But when we have no other option, it is for the General Assembly to take effective measures to safeguard the interest of the civilians. And of course, my one more suggestion, in case of the recent ongoing conflict between Israel, Palestine, of course, the crux of the issue is Israel and Palestine. So, as the major powers suggested, the only option is two-state theory, because everyone may accept, but maybe for achieving this two-state concept, I hope still we have a very long way to go. But anyhow, it is the responsibility of the international community to safeguard the interest of any human being wherever they are. Thank you very much for the opportunity given to me.
Thank you so much, Professor Chokalinga. And you have also highlighted the situation that is Israel-Gaza. However, your approach was different from the earlier speaker. And in your presentation, you highlighted the role of Security Council. And according to you, it is the primary responsibility of Security Council to protect civilians from all these kind of armed conflicts. And according to you, once again, we are moving towards Uniting for Peace Resolution 1950. So after adopting and executing this Uniting for Peace Resolution 1950, we are aware about their consequences also. So this time, if again we will go for this kind of resolution, then again we are required to see that what will be its consequences. So thank you so much for giving a different perspective to this ongoing situation, and also different suggestion. So with this, I'm moving forward with the next speaker, and he is Mr. Amit Paul. And he's going to speak on the Siachen Glacier impasse, a result of the cartographics distortion of the ceasefire line along with line of control by third parties. Yes. Welcome, Mr. Amit.
Good afternoon. So before I start, I would just like to give you a brief background on this. On 20th of August 2020, the government of Pakistan came out with a new political map of Pakistan, in which they have actually extended the line of control from a point which we call as NJ 9842, and it goes all the way up to the Karakoram Pass now. Now this line is of importance for us, because this is actually the cause for what I call as the Siachen Glacier impasse. And in the paper, I've tried to show that this line has no legal, factual, historical, or equitable basis. So in international law, before I take you to the cartographic distortions, I mean, international law, historically, maps do not have a very strong probative value as far as territory is concerned. They're only considered as secondary and secondary sources. But the frontier cases and the temple case in the 50s showed that the maps, if they are part of a treaty, then they do provide strong evidence of claim of territories. And also, if maps have been agreed to by parties and if they've been used continuously, then in that situation, it is very difficult for parties to resign. What is important here as far as the ceasefire line and the line joining LOC, unilateral extension of the LOC is concerned, is that this particular line came into existence in 1949 as a result of the Karachi ceasefire agreement. So after we gained independence, I'm going to take you through the slides and show you the actual distortions on the basis of documents which I have culled down. But before that, this is important. So in 1947, when we fought our first war with Pakistan, it culminated into a ceasefire in 1949, and the Karachi ceasefire agreement was signed on 27th of July 1949. Now that agreement envisaged that the ceasefire line will move from a point known as Chalunka, which is in Jammu and Kashmir. From Chalunka, it will go thence north to the glaciers. This agreement did not mention any terminal point of the line. This was a perfectly valid agreement which delimited the ceasefire line completely and said that the line shall go thence north to the glaciers. So the line was to extend all the way north up to the glaciers. Now, unfortunately, when the demarcation of this line took place, obviously at that point of time the resources were limited, the terrain was hostile. At 18,000, 20,000 feet, both India and Pakistan did not have the resources to actually demarcate the line. So the demarcation stopped at a particular point. Now that point at which the demarcation stopped is called as NJ 9842. Now once the demarcation stopped at that point, the delineation of the line in the maps also stopped at that point. So even though the delimitation of the line as far as the agreement was concerned was complete, the demarcation and the delineation was incomplete. Now, it is not something that this was disputed by both India and Pakistan. In fact, both India and Pakistan agreed on it. And from 1950 till 1983, there was absolutely no dispute. There is not one map which was produced in Pakistan officially which showed the existence of this line. There was not one map in India which was produced which officially showed the existence of this particular line. So therefore, there is no dispute inter se between the parties. Then the question arises, how did the dispute arise? The disputes started arising because of distortions which took place in history. What actually happened is that as soon as independence took place in 1950 or the war ended, people started writing books on Jammu and Kashmir and scholars started doing their own research. Now in those books, when they started showing the map of Jammu and Kashmir, which was purely for representational purposes, they showed this line and extended it wherever they wanted to on the Jammu and Kashmir border. Now the most commonly identified point on this border was the Karakoram Pass, because this was a point on which India and China had established their presence already. So it's like something, what actually happened was in 1950, somebody wrote a book and he said that, look, this line is hanging in the air, let me just extend it here. Somebody said, let me just extend it on the left. Somebody said, let me extend it on the right. But this was all happening in third-party books. As far as America is concerned, the position was that the Americans also terminated this line exactly as envisaged in the ceasefire agreement. So they also did not extend this line. Officially, this was not happening. What then happened is that in 1967, the Americans came out with a map which is called as the Air Defense Information Zone map. Again, in international law, this map does not confer any territorial rights. It's simply a map produced by a sovereign state to indicate to the pilots who are flying over there as to which region or which country from where they have to seek their instructions. So this is called a ADIS line, and it's purely a unilateral act. Now in that map, the Americans extended this line from NJ 9842 to the Karakoram Pass. Now once that happened, then a meeting took place in the State Department in 1968. Now at this point of time, you must understand that there was a lot of confusion as far as maps of Jammu and Kashmir were concerned, because Jammu and Kashmir was a state in which what was happening, we were claiming the entire state, as we rightly do. Some of the state was being claimed by Pakistan. There was a certain area from Pakistan which had been ceded to China in 1963. So therefore, the maps were a complete hodgepodge. And India was pressing the United States that, look, you must sort out these maps. Please stop showing Jammu and Kashmir in dispute in the maps. So in 1968, a meeting took place in the United States in which a unilateral decision was taken by the geographer. His name was Robert Hodgson. And he said that, look, this line is hanging in the air. This is exactly what he said, that this line is hanging in the air, doesn't give me a feeling of completeness. So let's complete it. And then everybody said, look, how do we complete it? He said, look, let's join it to the Karakoram Pass. So he joined it to the Karakoram Pass. So this became the official American policy that, look, now let's extend this line to the Karakoram Pass. It's important because this extension was neither envisaged in the agreement between India and Pakistan. It did not have the imprimatur of the United Nations Commission for India and Pakistan, which was constituted for mediating between the two. It was just a unilateral extension which took place in the United States. But once this happened in 1968, all official American maps started showing this line. Once that happened, all international cartographers, Times Atlas of the World, Reader's Digest Atlas of the World also started showing this line. Now, once that started happening, the logical corollary was that mountaineers who saw this line and who wanted to explore the Karakorams, when they found a peak which was on the Pakistani side, they used to go to the government of Pakistan. Naturally, when there is a line, and if I want to explore a peak here, and if this line shows that peak lies in Pakistan, I will approach the government of Pakistan. This made the Pakistanis very happy. They felt that we are sitting here and everybody is coming and asking for permission. We have nothing to do with the area, but they started giving those permissions. When India came to know that this was happening, this was in 1978 through Colonel Kumar, then we sent our own military expeditions, etc. And then we preempted Pakistan and occupied what we call as the Saltoro Heights, which overlook the Siachen Glacier. So that is how the Saltoro Heights are with us, and Pakistan can't even look into the Siachen Glacier. But that's the military aspect. On the cartographic side, we asked Pakistan that, look, you are claiming this line, because they claimed this line for the first time in 1983. On 20th August 1983, they sent us a letter saying that, look, this line belongs to us and you please stay away from this. We asked them, how do you claim this line? Which document? Which legal document? There is none. Which map? There is none. But they yet they laid claim to that line. So what we did was that the current External Affairs Minister was the first secretary in the Indian Embassy, Dr. Jaishankar, at that point of time. And he wrote a letter in 1985 to the United States saying that, look, your maps have created a lot of confusion. Please remove this line from your maps. Interestingly, in 1987, the Americans removed the line from their maps. But the line continues to exist in the Pakistani maps. And that line has resulted in a conflict which we know as the Siachen Glacier conflict. So that's what has come out from the paper. And I'm just going to now quickly show you the distortions. So to understand, Siachen is this particular triangle in Jammu and Kashmir. So it's on the northern side of the state of Jammu and Kashmir. And as I mentioned, on the eastern side is the Karakoram mountain range, and on the western side is the Saltoro Ridge. So the Siachen Glacier is in between. It's an inverted V between the Karakoram Ridge and the Saltoro Ridge. And it's also the source of river Dubra. Yeah, so this, the ceasefire line and the line of control actually ended at this point, which is called as NJ 9842. And as I had mentioned, in that agreement, it actually said that the line should go north from here. So if the line had to go anywhere, it would have gone north. If it went north, following the mountainous, using international principles of making lines, boundaries in mountains, you can't blast through the mountains. So therefore, you have to follow the natural contours of the mountains. So if it would have gone north following the mountains, then the entire region would have come to us. So very cleverly this thing was done, and this is the line which Pakistan claimed, and which you will now find is there in their political map of 2020 also. This is the line joining NJ 9842 to the Karakoram Pass, and which my hypothesis is that is completely incorrect. So this is the agreement, this is the Karachi ceasefire agreement of 1949, where I mentioned that the line shows that which says that the line should go from Chalunka on the Shiok River Khor, thence north to the glaciers. This portion of the ceasefire line shall be demarcated in detail on the basis of the factual position so and so. This demarcation never took place. So this is very clear. It does not mention NJ 9842. It mentions the line has to go north through the glaciers. When they were demarcating to the glaciers, they stopped at a point, and that point is called as NJ 9842. So if this demarcation were to be done even today, then we have to go north, and that the Siachen Glacier, in any case, then as per law, international law, any jurisprudence falls within the Indian side. This is the actual ceasefire line. This is the map of the United Nations, which was agreed to between India and Pakistan. And that agreement actually takes the character of a treaty, because it's an international agreement signed between India and Pakistan, brokered by the United Nations on 27th of July 1949. This is what we signed off. As I mentioned, Pakistan also never had any confusion. This is a map produced in Pakistan in 1949. So they published 3 maps, one in 1949, one in 54, and one in 55, showing the ceasefire line. They have changed the orientation of the line, but nevertheless, they have not extended the line to the Karakoram Pass. So this change of orientation is also very clever, because in 1984, the argument which took place is that the orientation of the line is like that, and when you follow the previous course of direction, it goes to the Karakoram Pass. That is why you need to remember that the original map actually showed a complete north. It does not show this orientation. But nevertheless, Pakistani also never extended the line. Again, there was no confusion between any of the people, even in 1950s, at that point of time, that the line has to go north. Now, this was a book written in Kashmir in 1954 by Mahognay Hall, and this map was produced in the New York Times by Richard Trumbull. Now, if you see this map, in this map, what they have done is they have extended, they've stopped the ceasefire line here. They have not extended it to Karakoram Pass, but they have taken it north as per the agreement. So this is the only map that you will see in which the line has been extended the way it should have been actually extended on paper. Practically, obviously, it will meander, but on paper, this is the only map you will see which shows this line.
12 minutes complete.
Yeah. So these are some of the books. I'll just take 2 minutes to take you to the maps. So these are some of the books which were published during that time. In 1954, this is a book which is published which shows the line correctly. And as I mentioned that everybody was doing his own thing at that point of time. This is a book published in 1962 in which he joins the line to the map. Karakoram Pass, there is no sanction for this. This is the Times Atlas of 1959. The Times Atlas also, instead of terminating the line here, joins it with the Karakoram Pass for some reason which they only can tell. This was the map published by the government of Pakistan in 1963, again not joining the line with the Karakoram Pass which they have joined now. This was a map published in 1964 in Pakistan Affairs, again by the government of Pakistan, in which also the line has not been joined. It is still terminated at NJ9842. This is the Air Defense Information Zone map which I had pointed out that the Americans made in 1967. So now you see that they have made an ADIZ line which goes all the way to the Karakoram. This was the first map in which this line was made by the Americans. This was the official position of the State Department. Till September 1968, any official American map terminated the ceasefire line at this point of time. These are the minutes of the meeting which took place in 1968, which I said Robert Hodgson decided that let's join the line to the Karakoram Pass. So in the minutes he says that the boundary, the choice will be determined by the purpose and extended to the Karakoram Pass so that both states are closed off. The phrase used is closed off. So he just said that let's close it off. After that, the American maps started showing this line. So I showed you one American map before 1968. All those maps don't have this line. All maps after Hodgson's meeting have this line. So therefore, whenever you see this shape of Pakistan, this is also the map of Pakistan which was produced in 1973, all United Nations documents, every place has this. Now in this map, if you see this line is actually the same Hodgson's line. This line never should have been there. Actually, this map should have ended at this point of time. But whenever you see this shape of Pakistan, you should remember that the eastern portion of that line has no legal value. It's a mistake made by somebody which carried on. This is the map of the LOC. So what I did here was I superimposed the line of control with the ceasefire line. This is the line of control, this is the ceasefire line, and both still end at NJ9842. They do not extend further. In 1977, a book was written in Melbourne, and he also extended the line, but see how he writes a question mark, because he also didn't find the basis for this line. So this was a book written in Melbourne, the India-Pakistan boundary in Kashmir, and he puts a question mark here because he must have also tried to search for the source and he never found this line. So this is the letter written by Dr. Jaishankar to the Americans saying that, look, what nonsense are you doing? Please remove this line. After that, the Americans realized that there was a mistake and they corrected it again and they terminated the line here. And the Americans corrected the map. So the official American map now ends at this point of time, but the line continues to remain in the map of Pakistan. So this is the latest 2020 map of Pakistan in which they have again shown this line. So the whole idea of this paper was to trace the origin and genesis of this line and show that apart from everything, all historical differences on Kashmir, whatever may be, you can argue them ad nauseum. But this line, you cannot justify it on the basis of law, jurisprudence, equity, or any other canon of justice. Thank you.
Thank you so much, Mr. Amit Paul. And it is very interesting paper, and you have brought so many maps, and then you have convinced us like how that the map which Pakistan is using, how it is not correct. And as US can correct their map, so I think one day Pakistan will definitely correct their map. So thank you so much for your extensive research which you have presented. So even though you have not followed the timeline, but however, you have given us a beautiful portrait of the line of control and other things also. Thank you so much. Now with this, we are moving towards next presenter. He is Mr. Aditya Bhura, and he is from Amity Law School, Kolkata. Okay. You please introduce, because in program schedule only one name is written, that's why. And the paper's name is Prosecuting Cyber Attacks on Critical Infrastructure as War Crimes, Legal Challenges and Pathways under International Humanitarian Law.
Good morning, one and all present here. I'm Aditya Bhura, a year 4 law student at Amity Law School, Kolkata, and this is my co-presenter, Shubham More. He's from NLIU Bhopal, and the title of the presentation is Prosecuting Cyber Attacks on Critical Infrastructure as War Crimes, Legal Challenges and Pathways under International Humanitarian Law.
I'll briefly introduce the topic. Cyber warfare, defined as the use of digital attacks by one nation to disrupt another's vital computer systems, has become an integral part of modern conflict. With growing reliance on technology and the internet, cyber operations now target military, infrastructure, and civilian networks using sophisticated malware, ransomware, and hacking techniques. The global interconnectedness of the internet allows for rapid, widespread attacks, reshaping the traditional power dynamics and enabling smaller nations to challenge larger forces. State-sponsored groups, non-state actors, and cyber criminals have all entered this battlefield, complicating the landscape of modern warfare. These operations are not just about disruptions. They involve espionage, propaganda, and even influencing political outcomes. Increasingly, cyber attacks on critical infrastructure such as energy, healthcare, and transportations are becoming more frequent and severe, particularly in geopolitical tensions like the conflict in Ukraine, which with the attacks we saw in 2022. To combat these rising threats, many scholars call for a binding global cyber treaty, one that establishes cyber protections and responsibilities, addressing the gaps in current laws and ensuring the security of our connected world. Now, moving on to what critical infrastructures essentially are. They refer to essential systems that uphold our society's core functions, from energy and water supply to healthcare and transportation. These systems are the backbone of public health, safety, and economic stability. However, in today's digital age, critical infrastructure is increasingly vulnerable to cyber threats, which can disrupt services, steal sensitive information, and even threaten national security. Cyber attacks targeting sectors like energy, water, or healthcare can have severe consequences, affecting public safety and creating a ripple effect across interconnected systems. Despite their importance, however, protecting critical infrastructure poses significant challenges, particularly when prosecuting cyber attacks as war crimes. The legal framework, including the Rome Statute, lack clear guidelines on cyber war crimes, making it difficult to classify and prosecute these incidents. Moreover, the anonymous nature of cyber operations complicates the attributions of these attacks and attributing accountability.
Now, to give you a brief idea of the literature review that we have conducted all too far, this particular topic has been covered time and again, and thereby to give you a brief idea on the same, first aspect that we'll deal with is cyber warfare and international humanitarian law. So, cyber warfare is rapidly becoming a significant element of contemporary conflict, thereby posing unique challenges to international law, particularly international humanitarian law. Scholars and legal experts have highlighted time and again how the rise of cyber operations targeting both military and civilian infrastructure has blurred the lines or the traditional lines of warfare. Cyber warfare, defined as the use of digital technology to disrupt, damage, or destroy the systems, networks, and data, ranges from espionage to full-blown attacks on critical infrastructure like power grids and healthcare systems. So we refer to the Talent Manual 2.0, which is also a landmark document in this field, which provides comprehensive guidance on applying IHL principles thereon, such as distinction, proportionality, and military necessity, which my co-president will also be dealing with later on, to cyber operations in itself. However, despite its very depth, it remains non-binding and acknowledges the fact that the significant legal ambiguities do exist. One major challenge in applying IHL is distinguishing between military and civilian objects, especially with the rise of dual-use infrastructure. For instance, if we were to refer to a cyber attack on a telecommunications network, if that were to happen, then it might be justified as a military necessity. However, that will also severely impact the civilians as well, thereby raising serious legal concerns. Dealing with the challenges in applying IHL over here. One of the primary challenges that have been highlighted time and again in the literature is the application of principle of distinction, which essentially requires the concerned parties to distinguish military objectives and civilian objectives in warfare. Schmidt and Merzer have time and again, of course, argued that the non-kinetic nature of cyber operations often complicate the assessment of proportionality, which is again another IHL principle, as the damage caused may not be immediately apparent and can have cascading effects over time. Further on, dealing with critical infrastructure in armed conflicts. So when we refer to critical infrastructure or CI, safeguarding such systems amid armed conflicts has become a pressing issue. And why so? Because these refer to essential systems like energy grids, water supply resources, so on and so forth. So any disruption or disruption in these can cause catastrophic humanitarian consequences, affecting civilians disproportionately. Thereby, scholars again have emphasized the devastating effects of cyber attacks in CI. So if we were to refer to the 2015 attack in Ukraine, the cyber grids, that is. So the very cyber attack left thousands powerless in the electricity in the dead of winter itself, showcasing how cyber warfare can severely affect human being. Similarly, if we were to refer to the 2017 NotPetya attack, which again, that also targeted Ukraine again, had global ramifications because it affected companies outside Ukraine as well, thereby showcasing that, in the interconnected nature that we today live in, affecting or rather attacks on one region can go on to affect the global world at large, of course. And this particular dealing with cyber warfare, these have major consequences. So current legal frameworks, including the Geneva Conventions also, were not designed to address such non-physical attacks, and thereby they create a grey area or a legal grey area at this current juncture. So scholars have called for reforms to address these unique challenges posed by cyber attacks on CI. Coming to the attribution challenges, the principle of attribution is at the core of prosecuting cyber attacks. Under IHL, determining whether a state or a non-state actor is responsible for an attack is paramount. However, cyber attacks, they introduce a unique complexity. And why so? Because they're often conducted anonymously, and we do not know where exactly they have originated from. And thereby it makes it difficult to pinpoint the responsible party in this place. The International Law Commission's articles on state responsibility and the Talent Manual, again, offer guidance on attribution. However, even with these frameworks proving effective control or direct involvement of states, it is hard, especially when non-state actors are involved. So my co-presenter shall deal with it.
Sure. So I'll be dealing with the legal and procedural difficulties we experience while prosecuting these cyber attacks under IHL. So the reliance on cyber systems within our critical infrastructure has grown exponentially over the years. With that rise, we've seen cyber attacks become a significant component of modern conflicts, challenging international humanitarian law in unprecedented ways. We shall deal with legal and procedural difficulties in prosecuting cyber attacks under IHL, broken down into three critical areas. Firstly, attribution challenges, as my co-presenter dealt, and evidence collection, and lastly, jurisdictional issues. So the principle of attribution is at the core of prosecuting these cyber attacks. Under IHL, determining whether a state or non-state actor is responsible for an attack is paramount. However, cyber attacks introduce a unique complexity. They're often conducted anonymously using proxies or decentralized networks, making it difficult to pinpoint a responsible party. Even with the established frameworks, proving effective control or direct involvement of states, especially when non-state actors are involved, is a considerable challenge. For example, in the case of Nicaragua versus the United States, in the judgment, it was established that mere support does not equal state responsibility. Similarly, in the cyber realm, merely providing cyber tools or intelligence might not be enough to hold a state accountable. This leads to severe gaps in prosecuting such attacks, where clear attribution is critical but difficult to establish. When it comes to then gathering evidence in such a situation, cyber attacks are uniquely challenging. The volatile nature of digital evidence, which is easily altered, deleted, or even masked, often means that investigators struggle to gather reliable or admissible proof. Unlike traditional war crimes, where physical evidence might be more straightforward to collect, cyber attacks require advanced technical expertise to trace their origins and understand their full impact. Moreover, as cyber attacks frequently cross borders, varying national laws complicate evidence collection because the procedures also differ. The challenges of ensuring consistency across jurisdiction only adds to this complexity, making it harder to prosecute cyber attacks under IHL. Moving on to jurisdiction, as we dealt with in collection of evidence as well. Jurisdiction is another major hurdle in prosecuting cyber attacks. These attacks often transcend national borders, leading to disputes over which state has the legal to prosecute. While universal jurisdiction has been applied in cases of war crimes, cyber attacks, especially when conducted by non-state actors or across multiple states, complicate this principle. Furthermore, IHL was primarily designed for physical conflicts, and applying its principles to cyber warfare present a new challenge. Many states have different interpretation of cybercrime laws, making international cooperation difficult, thus creating a vacuum for effective prosecution of such attacks.
Now I shall move on to the policy recommendations that the authors herein propose for the same. So the rise of cyber warfare, these want to present unprecedented challenges, as we have time and again merged up, right? For the two. So as we know, these infrastructures, whether power grids, water supplies, whatsoever, they're essential for societal function. So attacks on them, especially in the times of conflict, can have catastrophic consequences. So let me just walk you through some of the forward-thinking policy solutions that we have perhaps proposed as of yet. So the first would be the establishment of a global cyber peacekeeping force, or the GCPF. So what does it do is, it will function under United Nations perhaps, or a new multilateral treaty, cybersecurity body, and it does serve as an independent entity responsible for monitoring, mitigating, and responding to cyber attacks during armed conflicts. The GCPF would also deploy cyber experts and or digital peacekeepers who would hold advanced defensive mechanisms that would be capable enough to responding in real-time attacks, which would perhaps aim to target the CIs, such as power grids, health infrastructure, and the like. They also function as a neutral body capable of mediating whensoever necessary, thereby keeping themselves between the warring parties so as to ensure or rather prevent risks of escalation altogether. Next, we would like to propose the real-time attribution technology, or the RAT, wherein this would use blockchain, AI, and global sensors to trace cyber attacks instantly, because we know that blockchain itself as a body can bring in or rather trace, especially where exactly the motion was set forward or the attack was set in. So that can be used effectively. So this would of course standardize evidence collection and allow for swift legal action. By reducing ambiguity, RAT would significantly improve accountability in cyber warfare cases, making it easier to hold people accountable whensoever. Next, we propose the establishment of cyber sanctuaries. So these are digital zones where critical infrastructure like hospitals and energy systems would receive enhanced protection under international law. Why do we do so? It's because similar to humanitarian corridors, like we have seen time and again, in physical warfare, these sanctuaries would be off limits to cyber attacks, and any violation whatsoever would be classified as a war crime. By clearly defining these protected zones, we would send a strong message that certain attacks are unacceptable in any conflict whatsoever. Next, we propose a cyber resilience as a legal obligation. So this would become a legal obligation under the IHL itself, thereby compelling governments and private entities to ensure that the critical infrastructure can withstand cyber attacks and recover quickly. Failure to meet these obligations would result in sanctions or legal repercussions, ensuring that nations prioritize cybersecurity for critical infrastructure. Then we also propose public-private partnerships through cyber defense accords. Why do we do so? It's because they would, number one, be developed between governments and private companies. So you'd also receive the funding from the private companies, which the government otherwise, or rather technology which the government otherwise would not have received. And this would encourage real-time cybersecurity information sharing, aligning private capabilities with national defense strategies. So governments could offer incentives, let's say tax breaks or the likes, so that private bodies also come forward to participate in the same. And this would go on to create a cohesive defense network that spans public and private entities. Finally, second last, is that we bring in the concept of proactive digital, or rather cyber humanitarianism, which involves establishing the DERP, or the Digital Emergency Response Programs. So cyber first responders will be deployed during conflicts to protect and restore critical infrastructure. These responders, akin to humanitarian aid workers, would safeguard essential services such as healthcare and communication, minimizing disruptions and reducing civilian harm. By funding this through bodies, let's say by the World Bank or the ITU, even nations which have less funding per se, rather cannot afford the same, can perhaps go for rapid development of the same. And finally, we propose a multi-layered global defense framework, which is divided into 4 parts altogether. So the first being locally, wherein the individual operators would adopt best cybersecurity practices and redundancy systems. Nationally, the governments would integrate these critical infrastructure protection into national security strategies, thereby establishing specialized cyber units. Regionally, these regional bodies would create alliances which would coordinate defense efforts through cybersecurity agreements, and globally, these treaties and coalitions would be rather set standards for the protection of critical infrastructure across borders, facilitating rapid response to cyber incidents. Thereby, to conclude, it's clear that cyber warfare is reshaping the landscape of conflict in current times, and thereby our legal frameworks under IHL are not enough to keep up, and thereby new laws or strategies have to be implemented so that we can tackle them in due course of time. As we have proposed, particularly the GCPF or the RAT technologies, we believe that these can actually chart out a way ahead, and alongside the same, the rest of the same can follow on. And by bringing in these recommendations, the international community can uphold humanitarian principles and minimize the devastating impacts of cyber warfare on civilian populations. Now more than ever, collaboration between states, private entities, and international organizations is vital to building a secure and resilient cyber defense system. Thank you.
Thank you so much, Mr. Aditya Pura and Shubham More. So you have highlighted once again that how the infrastructure is very vulnerable, and you folk mainly highlighted the vulnerability of infrastructure like relating to power grids and so. And according to you, it can be a target for military purpose, but however, even civilians, they are also getting vulnerable because attacking on these kind of infrastructure thing. So thank you so much for your exhaustive research, and wonderfully you have presented. Thank you very much. Now I would like to move on. The next speaker, she is Miss Rupal. Yes, Miss Rupal Malik and Professor Dr. Benaji Chakka. And the name of the paper is The Quantum in the Attribution of Responsibility for the Acts of Non-State Actors in Cyberspace. Yes.
Good morning, everyone. Brief background has already been laid down by previous speakers for cyberspace and cyber warfare, but I'll be speaking about the challenges in the attribution of responsibility to the non-state actors for their activities or cyber attacks in the cyberspace. With digital age transforming the global landscape, cyberspace has become an ideal platform, ideal domain for state as well as non-state actors to conduct hostile activities, aggression and warfare with minimal repercussions. Consequently, it has become a battleground for geopolitical and geo-economic conflicts, significantly affecting global security, international law in general, and international humanitarian law in particular. In such environment, non-state actors, NSAs, have emerged as pivotal players, from hacktivists to cybercrime syndicates to state-sponsored hackers. They have been exploiting the borderless boundaries and areas of cyberspace to conduct cyber warfare. Now the problem here lies in the attribution of responsibility to non-state actors for their cyber operations and cyber attacks, as well as attribution of responsibility to states for the acts of non-state actors within cyber domain. The legal issue here involves is twofold. Primarily to distinguish between the activities, whether it will amount to civilian or combatant activities by non-state actors. Secondly, the nature of non-state actors in itself is in question. How we will determine whether the non-state actors are acting within the civilian status or as combatant. So, public international law and IHL in particular, they face significant limitations in addressing cyber operations involving non-state actors. However, the basic principles, we cannot, the threshold of basic principles cannot be overreached, and we cannot, either state or non-state actors through their activities, even in cyberspace, cannot breach these principles and cannot overgrow these principles. In this backdrop, three issues are very pertinent. First is participation of non-state actors in armed conflicts. Second is the organizational structure of non-state actors. And third is the extension of right of self-defense against cyber attacks from non-state actors. With respect to participation of non-state actors, if they are to be qualified as civilians or as active combatants, the determination of status of non-state actors has legal consequences as such. In this regard, the Article 4A Clause 2 of Third Geneva Convention is very important, as it outlines the predominant condition whereby any non-state actors can qualify as combatant for which are belonging to conflicting parties. On the other hand, as civilians also, if non-state actors, whether through digital or kinetic means, they are taking direct part in hostilities, they will ultimately lose their protection of being civilian. Moreover, Article 47 of Additional Protocol 1 also denies protection to non-state actors as mercenaries, since they are not acting for private gains, and they are acting for an agenda which has been a part of broad conflict. And with respect to organizational structure, as most of the hacker groups, they have virtual presence and virtual structure, and they do not have the internal structure and disciplinary system which has been mandated by Article 43 of Additional Protocol 1, which qualifies them to be combatant or the regular, give them status equivalent to regular military armed forces of the state. With hackers, and their structure and criteria is not clear. They are having virtual presence. There is no internal structure and there is no disciplinary system. However, their unifying military actions, they meets the criteria which has been outlined in Article 1 of Additional Protocol 2. To classify the threshold of non-international armed conflict, if in case non-state actors are acting towards a unifying military action, or they are acting towards a particular object. With respect to right of self-defense, that is in exception to Article 2 Clause 4 of United Nations Charter, traditionally it was used against regular armed forces of the state as well as the group which were controlled by the state parties. But recently, after 9/11 attack by USA, this practice has experienced a significant shift when US has used right of self-defense against Al-Qaeda and Taliban for harboring the NSA's group as well. So the principle of due diligence also comes in the picture, whereby the United Nations Security Council also supported US response, broadening the interpretation of right of self-defense. Also, the principle of due diligence, which obligates the state parties to monitor and prevent the use of their territories for cyber attacks, and extending the harboring principle to include virtual spaces as well. These three conditions which we have discussed basically qualify the acts of non-state actors to be active combatants, and hence making them responsible for their acts. Moreover, extending the responsibility for the acts of non-state actor to states, we already have, if the control principle, if NSAs are directly controlled or they are directed by the state will be responsible for their actions. Moreover, they can be considered de facto organs of the states also if they are dependent on the state or if they act under the strict control of the state. In this context, Article 8 of the Articles on the Responsibility of State for internationally wrongful acts also attribute responsibility to the state for the acts of non-state actors. if they act under the control of state, either on the instruction of the state or on the direction of the state, or if the due diligence of the state is involved, if the state is harboring the activities of non-state actors and not taking due diligence care to prevent such activities. But such responsibility requires state cooperation. That is not welcomed always, as has happened in 2007 cyber attacks in Estonia, where the request for assistance to Russia was denied despite existing legal arrangement. In such context, what can be done? The key legal principles of international law, principle of state sovereignty, state responsibility, us ad bellum, and the fundamental principles of international humanitarian law, distinction, proportionality, military necessity, they are very important for attribution of responsibility in cyber attacks for the involvement of non-state actors. These principles cannot be compromised. Whether the attacks are happening through digital means or through kinetic forces, we cannot compromise the threshold of the principles which has already been established, but their relevance and applicability and binding nature remains undisputed. Therefore, these norms are required to be considered and integrated into security and cyber strategies of the states. Thank you so much.
Thank you so much, Ms. Rupal. And there were mainly two concepts in your paper. One is cyber attack and another is non-state actors. So actually international law is having a challenge from both individually, and now you have given a paper in which collectively also you prove that yes, how it is very challenging. And but ultimately, according to your findings, the basic principles we are required to follow, and we must not compromise with those basic principles. So even though they are individually also challenges and collectively also it is a challenge, but it is altogether the basic principles of international law which we are required to follow. Thank you so much for your inputs. And I think we have covered all the speakers. Do we have Mr. Sarthak Gupta? No. Okay. So I have covered all the speakers. Yes. Right. So shall we take question answers, or would you like to give your?
Maybe I should just summarize
Sure.
a little bit.
Sure. Right. Okay. So our chairperson, Mr. Harbachan Singh, he will give his observations and comments, and then we will be having question answer session. Okay.
It has been such a wonderful morning listening to all the exposures, the learned opinions, research, and your estimations, forecasts of what kind of wars and the humanitarian consequences of wars and the culpabilities of those engaging in aggressive wars will take place. You have covered all areas of land, sea, aviation, and cyber wars. Laudable efforts, laudable in research. They are all worthy of the publication that they all appear in. I congratulate everybody for such a wonderful depth and expansion that you have covered these subjects in. We have to now relate the advent of robots to these war situations. Whether they are beneficial to mankind, humankind, or they have complicated matters more than they have solved them. All this time, the aggressor was the one who had the biggest muscle. However, that is changing. Now it is the aggressor can be a person, can be a country which has most intellectual power and the capacity to translate that power into various forms of warfare. And these warfares these days are turning from hand-to-hand combats into proxy wars. The world is using third parties and satellites to engage in wars. So it has really complicated wars in a very substantial manner. Human feelings, the care and welfare of the weak, the women, the children, are not getting the attention that was always given. Even during religious wars, they were given respect. But these things are now beginning to fall into the cracks. And it is our duty to point it out and to ensure that these weak people, members of our society, deserve and receive their proper protections. Chemical weapons. This is another area of very dangerous warfare manner. Weapons of mass destruction. A clear example is that of where Saddam Hussein, for example, was accused of using weapons of mass destruction or chemical weapons. Unfortunately, there was an element of some political intervention in that, and due to some error in the report that was given to the Security Council, presented by especially the United States, there was some accusation that Saddam Hussein did in fact possess these weapons. But eventually, as investigations pursued, and even the United States acknowledged that there was some error, and they were not sure that there were articles of mass destruction or so. And as a result, there was, because of this, the United States then came to the Security Council and asked that unless Saddam Hussein declares a ceasefire, we will destroy Iraq. Saddam Hussein agreed to the ceasefire, and as a result, one of the conditions was that he will return everything that he plundered from Kuwait when he occupied Kuwait. And that was one of the conditions he had agreed upon. And the Security Council passed a resolution on that basis, and the UN was then assigned the duty to get all these things from Saddam Hussein. And I was assigned the duty as a team leader from the United Nations by the Security Council to go and get this property from him and return it to Kuwait. So we set up a mission in Saudi Arabia and asked him to give us a list of all the things that he brought And we started with gold bricks from all the banks. And we were able to account for every brick. And they were returned. Hospital equipment, followed by museum pieces, cars and trucks and buses in showrooms, ships, yachts, aircraft, everything. Hospital equipment. And strangely, he did not just load everything into the truck and bring it over. He took a proper accounts of things that he brought over. And I'll give you an example. I asked Kuwait to give us, the UN, a list of all the books that they had lost from all their libraries. And they gave me a list of 1100 pages. Separately, I asked Saddam Hussein for a list of all the books that he had brought them from over. And he gave me a 1500 page list, which was so 400 pages extra. I then called Kuwait and asked them, told them, I give you one more chance to revise your list. If there is, you make sure you haven't forgotten anything, because that's what you're going to get. And they revised, they added another half a page. And at that point, I then gave Kuwait a list of Saddam Hussein and said, this is the list that he has brought, or books that he has brought. And after going through the list, they were so impressed and shocked that there were so many books that they had with them, of which they had no records themselves. And as soon as they saw that list, they said to me, please disregard our list and give us all the books which Saddam list has prepared, and we will accept, we will sign it blindly. So that was an example of a situation of how things took place. So it was a very successful, return of property. It took us 2 years. And of course, there were some items, money was not completely available. And he said, while I occupied Kuwait for several months, I had to pay salaries, and so you minus all the salaries and you account for it. So that was true. UN Security Council controls the parties to the conflict, and you see, now if we may talk about UN Security Council. India has been seeking the role of seeking a seat in the Security Council with a veto power. Whereas all these years, for the last 24 years, the 5 major powers have always been intermittently saying, yes, we agree India should be have a permanent seat. But there were always two unclear provisions. Getting a permanent seat is not the same as getting power to veto. Veto power is more important than the permanent seat, because every few years India gets to sit on the Security Council by rotation. And that is where we have always not been successful so far. Almost 24 years. Security Council veto powers came because of the conclusion of the Second World War. These 5 countries rewarded themselves with these powers because they were the victors of the Second World War, and they do not want to. Right now they have 1/5 power, 5 of them. They say, and correctly so, that if we give India a power, veto power, then our power will be reduced to 1/6, not it. So that is what is the problem. And I think it is overdue, long overdue, that India should get a veto power. But what has happened is that Brazil, Germany, Japan, all these countries are seeking the same power. And that is the unfortunate part, and that is a stalemate. So that's where we are as regards the Security Council. We have covered space wars, religious wars. We have a lot to learn from religious wars to see how the philosophies of war were conducted then, and how they can help to improve our laws on wars, because in Geneva we are going to have a convention. A convention is in the works to revise the punishments meted out to prisoners or otherwise, what protection that they ought to be given, even as prisoners of war. So then again, the situations regarding to internal wars within a state and international wars, they are two different things. And the punishments that the innocent suffer, they have to be evaluated and ensured their safety and security must be preserved. Security Council and there is the World Court, for example. The World Court cannot pass a judgment on countries unless they accept they are willing to accept the results of the outcome of the and Security Council has, although they control the war situations in the world, yet their role is different from that of a world court. World Court goes by consent, Security Council does not. They go by their deliberation and so, and we have to always remember when there are wars or problems. In UN, we treat sometimes small countries as having big problems, and we also classify big countries having small problems for the UN. For example, Israel, small country relatively, and yet the problems that it has engaged the world in is phenomenal. The world is, engaged so deeply that a lot of time, support, and financial resources on a daily basis, phenomenal amounts are being spent by United States and other allies, the NATO's and so forth. So all these things are engaged. All these things play a very important part in these world wars and culpabilities for criminal activities on humanitarian. So let me conclude there, and thank you very much.
Thank you so much, sir, for your. In fact, you have summarized, and you have given a great contribution to this panel. So, with this, with your permission, now I would like to open the floor for question answers and your comments, your observations. Yes, please.
I am Commodore P.K. Goel. I was
Retired Judge Advocate General of the Navy. No, I don't. My question and observation to Professor C. Chokalingam is, whereas the IHL prohibits and give protection to the civilians, but there is a concept of collateral damages, and that concept must be understood, because when you fire on military objectives as given in Additional Protocol 1, there are bound to be some collateral damages for the civilian objects and civilian personnel, and that has to be accepted. And as an example, in 71 war, when Indian Navy bombarded Karachi Harbour, there were many civilian objectives and civilians which were killed and damaged. And although the Pakistan objected to that, but our response was that this is permissible in the international humanitarian law. So my observation to that aspect should be taken into consideration into the Gaza country. Thank you.
Would you like to respond?
Thank you very much. It's a very nice question raised by our respected observer. Yes, we have a wonderful law, humanitarian law. The law is there to protect, especially through the conventions. The law is there to protect the commoners, the civilians, especially children, women, aged people. But in cases of conflict like the one which is going on in Gaza, it is very difficult for a nation like Israel to differentiate between those who are the actual combatants and those who are shielding the combatants. So in the name of attacking the combatants, one nation may use indiscriminate force, maybe disproportionately. It may be that. Then, what's the remedy? What's the remedy? Suppose any member nation at the UN level is using force, though the United Nations Charter permits the use of force for the purpose of defense. Nothing in the Charter prevents any nation from using force for defense. But at the same time, when any nation is using force disproportionately, then it is for the Security Council to interfere. That is why I have specifically mentioned, when there is conflict of interest among the nations, especially those who are having veto power, as pointed out by our respected officers, when there is conflict of interest among the veto power wielding nations, because when the very veto power was conferred upon these five powers in the year 1945, immediately after World War II, for the sole reason that at that time international community was of the opinion that these five nations had the major responsibility or primary responsibility of protecting international peace and security. That is the reason this veto power was conferred upon those nations. But later developments among the veto power yielding nations, conflict of interest is there. So practically the Security Council is unable to take active measures in protecting the interest of the commoners, civilians. The only option, because as pointed out, over long due is the reform of the Security Council. But whatever the efforts taken at the international level by the international community, any reform at the UN level is possible only with the support of these five veto power wielding nations. That is the crux of the issue. That is why out of these 193 nations, even 192 nations may be of protecting the interest of the civilians. Suppose if one nation is not for it, then no other option except the international community has to simply sit and watch. That is the reality. But it is for the experts in the field of international law to deliberate to protect the interest of it. This is my humble submission. Thank you.
Thank you so much. So, his observation was about collateral damages, that it will bound to take place. But however, international law is silent that how far you will accept the collateral damages. So, for that matter, again, we are required to take help of principle of proportionality, and thereby we are required to see that how far we can say that yes, these are the collateral damages. Any other observation, question? Professor Banerjee, would you like to add something?
Thank you very much, Mrs. Chairperson. Thank you for giving me the opportunity, and I appreciate all the papers and paper presenters, and they have done a good, tremendous amount of job. And but only thing is that we have to have some critical assessment on what and how the laws are going to be applied, and we need to have the clear demarcation between the international law principles, particularly when youngsters are dealing with international humanitarian law under the rubric of use in bello. We should not crisscross into the use ad bellum. We have to have that clear demarcation. And if you ask me that was it relevant, or maybe is it relevant to today's future warfare, which majority of the warfare are conducted in cyber warfares, or maybe autonomous weapon system, and all these things, how are we going to respect the principles of international law? May be true, but we should not forget that kind of demarcation. So most of the presentations I was observing that our youngsters are crisscrossing through that and all the principles. Of course, it's very ambitious things, it's good. I appreciate the futuristic and ambitious things. But when it comes to the application of the basic principles of international law, we have to be very clear and we have to be very specific to that particular principles of international law. Let me take one particular point. When we talk about that cyber attacks, when it happens, does it really amount to a use of force against the state? So how are we going to just look at it in Article 2, Clause 4 of the UN Charter? That's the specific questions we have to ask. Now, if you see that the attack on the particular state or vital installations by a private and non-state actor, can you consider that? But that's still doubt in today's context. Let's take the examples of the 9/11. 9/11, we have a certain specific perplexities. What's the perplexity is that when the non-state actors have attacked some vital installations, and aftermath of that, the state has unleashed that kind of war against terror, and they committed, the entire international humanitarian law has been distorted. And that we have to understand. From that particular distortion, we should learn the lessons and make sure that the existing international humanitarian law, how far it is going to help us to understand the very essence of the fundamental principles of international law. So that's one main point which we have to have it. And when we are dealing with that non-state actors, particularly during the time of cyber warfare, how are we going to bring and attribute the state responsibility is the question. Now, our youngsters have mentioned that Nicaragua case, that's one of the, we consider that one of the customary principles of international law. It's the basic foundation of international law. That's true. But now let's look at that, who are the actors? Now, our colleague Rupal has mentioned a particular the kind of situation. If an armed non-state actor unleashes kind of violence against the protected categories of the people, you may attribute the responsibility for them, because the common Article 1 of the Geneva Convention and even Article 3 of the 4 Geneva Convention specifically speaks about that all the contracting parties have an obligation to minimum apply all the IHL principles. Now, when you look at that particular thing, now today, the non-state actors involved in the cyber warfare are different categories of the people. Who are they? It is capitalistic global tech conglomerates. They are not individuals. If you look at the 9/11, when a combatant is not wearing the uniform in accordance with the Third Geneva Convention, Article 4, countries like United States of America and Allied Forces, they said that they are illegal combatant, unprivileged combatant, and they are unlawful combatant. The nomenclatures have been given. And why they have given the nomenclature? They want to undermine the very protections offered by the four Geneva Conventions, particularly the third Geneva Conventions, the protection of the victims of the armed conflict, that is hors de combat, that is prisoners of the war. They want to eliminate the entire protection mechanism. That is why they have given the nomenclature of unlawful, illegal, unprivileged combatants, and they have given incarceration, and all these violations we have seen. Now when it comes to the global tech conglomerates, how are we going to prosecute them? They are challenging the state. So this is the one conundrum we see. And coming to excuse me, coming to last point, which we talk about, that how this tech conglomerates are now trying to destabilize the state by attacking the vital installations. Now we talk about that application of IHL for the purposes of protecting and prohibition of certain arms and weapons under the means and methods of warfare. Under the means and the methods of warfare, it's very clear. There are so many conventions we have, and that particular conventions we will have to think and rethink and see whether cyber warfare and the weapons which are being used, whether we are going to bring under the rubric of the means and methods of warfare, which we have the 3-4 cardinal principles of the IHL. So we have to have that particular brainstorming rather than going for suggesting new mechanism, new treaty. Very ambitiously we are talking about global forces, global multilateral treaties. Today it doesn't work at all. I'm not talking very pessimistically. The reason being, today it's a fractured world, and there is no multilateralism. Bipolarity and unipolarity is existed in the world, and we are not able to stop the wars which have been going on last 2.5 and 3 years. But how do we expect that a new treaty, new multilateral organizations and are going to implement the obligations of international is a big question mark. So that's why we have to look at it when we talk about that IHL and international law. And last but not the least, I just appreciate Amit Paul has done a tremendous amount of job. I appreciate that one. Now particularly India is riddled with so many territorial disputes across the borders, and India and international law, we have not done any work at all. Seriously speaking, we have so many scholars, and we have the scholars, so much of scholarship is going on in India and across the world, but we have not. This is one of the areas where so this is the problem is that here our international lawyers, our students of international law, they're looking for the fancy thing, but we are not going to that the territorial disputes which have been India is fighting ever since it started its independent in 1947. It's a very wonderful thing, and after late you have come out with a good exposition of the charts. I think we all of us done. I was really impressed about your presentation and the way we are now. We need to look at it, these things, how we are going to bring the new principles of international law, existing principles of international law, to resolve the disputes. Okay, and another last one, that is a Kautilya's Ardhasastra. I'll only take 1 minute. That is, the youngster has done a tremendous amount of job. Only we have to see very critically, not saying that IHL principles are there in Ardhasastra. No, it's not that. The language has to be changed. IHL principles have been codified only in 1852 after Battle of Solferino, and prior to that there is no IHL at all. The entire Western IHL principles have been ignored, the entire development of international law. Like you yourself told, 2,400 years ago, we have the beautiful principles of international humanitarian law propounded by the scholars and also written into the Ardhashastra and followed by the Ashoka and the Battle of Kalinga. After that, he renounced the war and went on to preach the Buddhism and not been accounted in the international humanitarian law. The Western principles of international humanitarian law is completely ignored, and now we are trying to baptize into this Western notions of international law, ignoring the contribution of our Asian and Indian, our own Indian cultures to the development of international law. But now we are masking ourselves to look at that universality from the prism of westernization, but not from the principles of what we have. So if you can look at it from this in a critical perspective, and that will be a fantastic work. Thank you very much and all the best. And thank you, ma'am, for giving me this opportunity.
Thank you. Thank you so much, sir, for your observations and contribution to the panel. Any question, if it occurs to your mind? Yes. So thank you so much once again. And in all, if we can see to our entire panel. So total 7 papers we have presented, and if you will see the nature of our papers, so basically we highlighted the basic principles only of international humanitarian law, even though we are discussing about the cyber threats, cyber weapons, and the use of robots in the war for that matter, and also the disruption of internet facilities during the war zone, during the war. But in all, what we have discussed, it is all about the principles of international humanitarian law, mainly means and methods of warfare, proportionality, and distinctiveness. So when we discussed Russia-Ukraine war and also Israel-Gaza, Palestine for that matter, we highlighted a concern regarding the violation of the basic principle of proportionality and distinctiveness. Regarding cyber weapons also, means and methods of warfare, which we always discuss. So whenever any advancement is coming up in our routine life, you will find that obviously it will come even in the warlike situation also. We cannot isolate the war situation from all these advancements which we are having through technology. If we are using for our daily work all the technology, so obviously even during war also it will be used. So regarding all these disruptions, as one of our participant, he also highlighted about the collateral damages. So earlier, when in the list in IHL, you will find that schools, hospitals, marketplace, residential areas, they have mentioned. So why not to interpret it as all those things through which we are able to live our life very normally, including the all the internet facilities and other things. So even though it is not there, but now we are required to interpret it. And as far as I know, Professor Benaji Chakka and also Mr. Harbachan Singh, they will guide me. Amendment in international is not so easy. You may have additional protocol, you may have additional convention, but amendments are very difficult. Now, considering the role of the Security Council, so regarding Security Council role is also always, it is very challenging and it is very critical also, and whether we will get place over there or not. So time will tell us, as already sir said that Brazil, Germany and other countries, they are also in the same race. But is it so that if we will be the permanent member, our interest we will be able to protect, whether we will be able to protect the interest of other states? So that is also a question, because even if it will, the power will be divided into 1/6 or like 1/5 right now, that is what is the equation. But if it will change, how far it will be beneficial, of course, for our national interest. But is it so that there will be no war? Like after killing of Osama bin Laden also, one of the posts I have seen that is it so that terrorism has come to an end? But after that, after Osama bin Laden, some more terrorists, they have also come. So even though we will be the members of Security Council as a permanent members, is it so that there will be no wars will take place? Yes, how far we will be able to protect our interest? Of course, there will be some more benefits to us. But what about the international community? So then, why not to question on the power which sir has said that they have rewarded themselves with the veto power. So why not to have a question on the veto power through which you are violating Article 2 Clause 1, that is all states are sovereign and equal, which is given in the UN Charter. Of course, there are many things which we can discuss under international humanitarian law. And once again, all the participants, they have done wonderful work. And I reiterate the presentation given by Mr. Amit Paul. General international law, mainly it was relating the territorial jurisdiction. Actually, this is by default the first and primemost jurisdiction, that is territorial jurisdiction. But when we are developing, somehow we are moving away from the territorial interest and territorial jurisdiction. But this is also very much required, and we are required to highlight once again the basic principle of entire international law, that is the territorial principle. When we are speaking on the universality regarding the universality of international humanitarian law, application of international humanitarian law and universality principle, so again we may be able to recollect the theme of our G20, that is Vasudhaiva Kutumbakam. So through that also we have already touched upon that particular theme, that is Vasudhaiva Kutumbakam. I'm from Maharashtra, so we have Vishwaji Maze Ghar. It means that entire universe is my home. So this is what is our basic premise, and this is how we develop. So in international humanitarian law, when there are wars, so why not to think that entire universe is our home, and then accordingly you can choose means and methods. But there is a long way to go. It is very easy to speak, but it is very difficult to follow. So with this, thank you so much for this wonderful session. Yes, why not? So let's have a comment. Then once again, I will thank everyone.
Sorry, I didn't mean. We have Mr. Harbhajan Singh here, who is a friend, and he has been at the UN for 38 years. My comment and question is to you about non-state actors. Firstly, in the recent, even in the South Africa case, in the ICJ, etc., what was brought to the attention of the world and the court was that civilian spaces were being used to do military activities, that is schools and hospitals and other things. And also in Lebanon, for instance, at the UNIFIL, I recently just read yesterday or day before that the UNIFIL, soldiers and personnel, they have been influenced to remain silent, to not take action against the terrorist activity that is there. So there is a twofold things that arise from this. Firstly, how does the international community or the Security Council or the ecosystem respond to non-state actors resident in a particular country and probably getting tacit support by other countries? Like for instance, it is seen that Iran seems to be financing or whatever these activities. We recently saw in Pakistan certain groups were there. And of course, the other question being UN personnel which are resident elsewhere, and if they are failing to do their duty, how does our system respond is my question and comment. Thank you.
Yeah, please. Yes. May I also? Yes, why not? Yeah.
Can
Would you want to wait or after?
As I understand, the Security Council has both the decision-making powers and also to monitor, because the World Court cannot monitor on behalf of the Security Council. So when incidents of the kind that you mentioned arise, they are brought by other member states to the attention of the Security Council, which then appoints research or investigatory bodies, teams to go and research and report directly to the Security Council. That is the primary vehicle on how it operates. But the Security Council has the total ambit of whatever action that it needs to take or would like to take to do, if the members so agree. So it is really a call for the Security Council to make a decision on what is acceptable or appropriate or necessitated by circumstances. So that is.
Thank you so much. So we are having one more question. Yes, please.
Yes, more than a question, I think it's
Observation. Yes, please.
an observation or need for an understanding and guidance from all the
Sure,
elders here. So, like Sir was very rightly talking about Arthashastra. Actually, Arthashastra, Kautilya's Arthashastra is a chapter taught in the US Army War School. So I was very keen about understanding how we can see our knowledge is being taught at US in the Army War School. How is it that we can bring it into the light as Indians, as representatives in the UN and in the Human Rights Council? How can we bring our own knowledge into the light so that I think basically all the issues that we've spoken about today, what's fundamental to it is the ideology that we approach these issues with. What's the line between self-defense and using aggressive power in the guise of defense between nations? So I would really like the seniors' insights onto how we can bring about our own, wisdom about our Indian Arthashastra into the human rights in the international scape.
Yes. Anyone would like to respond on this? Yes, so here actually the requirement is the multidisciplinary approach, and you may be aware that at present our Indian education sector is going through a tremendous changes, and we really wanted to acquire this multidisciplinary approach. Generally, Kautilya's Arthashastra, if you will find, actually there are many things, not only the rules relating to war, but otherwise also for commercial purposes also, even though it is not a theme of our panel, but for that matter, for law of the sea, relating to law of the sea also, many rules are there. But generally, this Kautilya's Arthashastra, School of Economics, they are generally taking care of Arthashastra. But then these chapters, slowly and gradually, they are becoming the member of, they are becoming the part of curriculum. And now he has also come out with the research paper, and this is how you will find that many youngsters, they are coming up with their research, and lot of support has also been given by Indian government through UGC as also Ministry of Education. They are funding various research projects wherein they are establishing link between our ancient Indian culture as also epics and all the literature and the contemporary problems. In fact, nowadays, what is going on that to achieve Vikasit Bharat 2047, they wanted that to explore ancient Indian, literature, studies, and contemporary problems. Thereby, we can go ahead. So that is what is the process is going on. So I'm sure that very soon, in legal curriculum also, you will find a place for all these literature. Very recently, in fact, day before yesterday, I attended one national workshop conducted in Bhopal, wherein the theme of the workshop was that how to inculcate ancient Indian culture in light of NEP 2020 in legal curriculum. So the work is going on, and very soon you will get some fruits also for the same. Thank you.
I would just like to make one comment.
Yes.
The topic is 10th International Conference on International Law Issues and Challenges. I mean, in my humble submission, the biggest challenge before international law today is staying relevant. Because what we say in books, what we read in books is one thing, but what is happening around us, there is hardly anything which is taking place in consonance with any principle of international law. And I think that's why these conferences are important, that at least these things are highlighted. And somewhere, somebody, we can only hope that somewhere somebody will read it and then remember that there is something called the international law. That's what I think is the biggest challenge today.
Yes, very rightly said. Relevancy is always required, and with the relevancy only, actually international law many a times we started when we used to be a student, we used to have in first chapter that whether international law is a law or not, right? Then whether international law is weak law or strong law. So that used to be our first chapter. But when today we are going to our class, let me tell you, students are not asking whether international law is a law or not. Is it so that because they are unaware? No, because they are aware. So thus, somehow we are able to find out the relevancy of international law to resolve the issues and conflicts which are going on globally. And let's hope, as we all are trying to give our contribution, so I think there will be very good days ahead. Thank you so much.
There's one book that is published called Vasudhaiva Kutumbakam by Ambassador Virendra Rai, who was a former ambassador. I have a copy of the book. It was gifted to me just a couple of days ago. But do look for it if you can get your hands on that. That gives a lot of wisdom about our ancient practices. Vasudhaiva Kutumbakam.
So thank you so much. With this, let me conclude the panel. Thank you, sir, for your
One last comment. A very significant contribution that India makes to the United Nations is the contribution of UN forces, members of the UN forces, because the 5 permanent members do not contribute a peacekeeping force. And India is one of the leading 4 or 5 actually leading member countries that contribute all these forces all over the world, and it has such an important role that it is recognized by the Secretary General over and over again every time.
Thank you.
So thank you, and I request all the panelists kindly come over here so that we can have a group photo. Thank you. Let's have a group photo.
Yeah.
Yes.
Welcome and good afternoon, everyone, to the 10th International Conference on International Law, Issues and Challenges, organized by Indian Society of International Law. This session is on trade and investment, balancing global markets and legal frameworks. The chairpersons for this session are Mr. Ujjwal Singh Bhatia. Mr. Ujjwal Singh Bhatia was appointed to the appellate body of WTO in November 2011 and has served till March 2020. He was chairman of appellate body for 2 years. Prior to his term with appellate body, he was India's ambassador and permanent representative to the WTO between 2004 and 2010. Dr. Ali Hassan Khani, Deputy Secretary ALCO, he has served in various capacities such as Secretary to the Embassy of Islamic Republic of Iran in New Delhi, Legal Assistance, Department of International Legal Affairs, Ministry of Foreign Affairs and Islamic Republic of Iran. Now I would like to request Professor C. Jayaraj, EC member ISIL, to make the key note address. Yes.
Good afternoon to all of you. Esteemed Chairman, sir, I have to make a few preliminary statements. I was not actually slated to speak in this session. I was to speak in the mainstream investment law session, but I will not be here. So they asked me to join this session. But so just one thing. And secondly, you are right that there are no audience in the hall, but we will treat this as an expert panel on the subject matter because there are too many young people here. They are very, I think they must be knowledgeable in current affairs. So I'm just with my own perspective, I present certain views to you. Then after that, you all can join us. Thank you. So now, thought going further, I would say that you see that there is no international investment law today in a multilateral sense. What you have got is about 3,000 bilateral treaties, which more or less there are uniform clauses are there. But because they are uniform clauses are there, do you take that there is a multilateral understanding of the issues in terms of multilateral treaty, like WTO, like International Criminal Court, like so many law of the sea tribunals. So that is one thing that we must keep in mind here, that we are going to discuss only the bilateral treaties. And then bilateral treaties was not a big phenomena till 1990s. And first, I believe, the 1959 German and Pakistan bilateral treaty was the first one. But then till 1990, there was not much of a movement in that. Perhaps the investments took place under domestic laws and all that. But then 90 onwards, there are a lot of bilateral treaties have come, and they have, you see, the developing countries and even intra-European countries and NAFTA and everybody had gone for mutual foreign investments. But the pain of entering into the treaties so quickly and rapidly and in such magnitude was not known until the disputes started coming. The disputes were raised and the arbitral tribunal started giving compensations. It is not the question of law that pinched people. It is the question of the quantum of the compensation that troubled the people. It is only after getting several hundred millions, sometimes billions. I believe in one of the recent cases, $40 billion, $50 billion were given against the Russian Federation in an arbitration. So it is only after getting that pain of inability to pay or shocked by the quantum that people started thinking, what is this BIT? And even then, without clarity on that, they started withdrawing it, totally withdrawing it. For example, our own country withdrew from 70 to 80 treaties in a thing, and Brazil did it. So many Latin American countries, even within the European Union, after a particular case, they cancelled all the bilateral treaties. So, but then what remains? The bilateral treaties were made without comprehending the international law aspects or the legal aspects that could be applicable to the one, without framing the proper legal standards and procedures. The bilateral treaties were entered into. And what was the highlight of that one? The most important thing is that in any bilateral treaty, you will see the sovereign states are members. But here also in bilateral treaties, the sovereign states are parties to the bit. But actually, that sovereign country, that is, you take the host country. Then when you invest money into my country, I am the host country. But then your country will be home country. It's a sovereign agreement between two states. Now, in this one, but you as a home country of the investor is supposed to espouse the cause of investor. That was the law in 1930s. Before 1930s, when the American and Latin American countries had disputes about the alien treatment, when they nationalized some of the things, when there was a dispute of an American citizen in any Latin American country, that was the situation there. But you see what happened, at that time there were certain legal principles were there. That is, I could say that minimum international standards, international minimum standards. And then this was used to argue in post-1990 disputes that whenever the investor has got the privilege of without submitting to the domestic local remedies can straight away go to the arbitration. But it is in this context that the arbitration panels and the councils, they all argued, or the host, they argued, the investor side, that what is, you have to apply not the national standard, national treatment, but the international minimum standard. But this post 1990 application of late 80s, early 20th century is how far it is justified when the scenario of applying that standard was between the North America and the Latin American countries. And in this context, I want to bring to you a very important resistance made by Argentina. The Argentinian jurist Carlos Calvo, he argued that when you come into our country, any foreigner should abide by our laws. That's the first thing. And he also argued that is the first attribute of sovereignty, that is the territorial sovereignty. Everything under our law, under our courts. Therefore, you have to, and we cannot give a bigger privilege than what we give to our own citizens. There is a equality of treatment because as sovereigns we are equal. So when they did this one, but there was a controversy. See, at that time, even to collect the debts, the US used to send their navy to collect the debts. It is after that this argument came. And then simultaneously there was an argument, another foreign minister, I had forgotten the name, he's called Estrado, a foreign minister of one of those countries. He said, since we are all sovereign countries, there is no interference into the sovereign affairs by another sovereign. So all these things went together to resist what is known as the international minimum standard. In substance, the investors' side was arguing that what is comfortable to us, what we think is the law, will be the principle of application in the dispute. That is how it happened. Okay, one of the things of that period was, consequence of the Calvo doctrine was the application of the rule, exhaustion of local remedies. That means before you go to an international forum through your own country, before you seek diplomatic protection by your country, you should exhaust the local remedies. So the local remedies was a part of the customary international law. But minimum international standard is also part of customary international law. One works for the host country, another works for the home country. But this was not solved, despite even ICJ judgments or PCIJ judgments have said about local exhaustion of local remedy is a must, a legal requirement, international requirement before going for bilateral arbitration, but sovereign level. So therefore, now without this, so resolving these issues, the developing countries and even European, anybody who receives capital, they blindly agreed with certain format of the thing. But then the post 90, mid 2000, when the compensation was very high, everybody started withdrawing. But there is another thing. They also said, even post 2000, the tribunals brought some argument called fair and equitable treatment that should be given to the foreign investor. But what is the fair and equitable treatment? Apart from that, they demanded treatment with international minimum standards. There is no difference. It was a principle that was propounded post 2000, and they started saying that fair and equitable treatment is denial of justice. The general principles of law, even in a domestic setting, if you deny justice, that is unfair treatment. So like that, denial of justice in criminal, civil and administrative matters of an investor. Then fundamental breach of due process. Okay, lack of transparency in judicial administrative matters, manifest arbitrariness, targeted discrimination on manifestly wrongful grounds such as gender, race, religious belief, abusive treatment of investors such as coercion and duress, things like that. So they said if any of these things is found on the part of the host state, it will be treated as a it is against the principle of fair and equitable treatment. But these are all actually any democratic country, any judiciary of a democratic country will have it. But these things, I'm giving two examples of two legal principles that have been heavily argued on behalf of the investors, but they are not part of the international legal process, either by way of a multilateral treaty or by way of a judicial determination by ICJ, but only through the arbitral tribunals of ISDS, what is popularly known as the ISDS, that Investor State Dispute Settlement System. But in this one, I will immediately come to one question. Arbitration tribunals, most of the countries were members of the the ICSID, International Convention on Settlement of Investment Disputes, World Bank organized one. And you see many countries are members. China, even China is a member, Russia is a member, so also all the Western countries. But India refused to accept the jurisdiction. It simply said we will not go for, we will go for diplomatic protection, go state to state, we will go to ICC, we will go to Singapore Arbitration Tribunal or wherever, but we wouldn't go. So they did not go to World Bank process. They went to something else. But then all of you must be having, because I know this panel, except me and one more person from some university here, is full of experts from CTIL. They all know these things. But then it is better that we discuss about it, because you are all technically sound people on this matter. You are professionally doing it. But then there is another side to it, like I am speaking an academic view. So therefore, this ISDS was packed with arbitrators of Western origin, and they all have a certain notion about what is rule of law and what is due process, what is, in fact, they argued in 30s that you can never understand, that the third world countries can never understand what is fair treatment, because you have never trained yourself for that. So this ISDS was full of arbitrators who started interpreting the principles of, or the stipulations of the bilateral treaties to the advantage of investors. And then I must tell you, there has been finding, I don't have to give you the amount of every year. You see, in 2009 to 10, the average compensation would be certain amount, tens of millions. Then after the next decade is hundreds of millions. The current decade is billions of dollars has given this thing based on the same principles of law that they apply. The arbitrators accept it and it is given to you as an award, and you keep paying that one. That is what caused the withdrawal from that. But then the arbitrators are on a college. And then I have found out, I made some studies. There are certain, International Institute for Sustainable Development, the Investment Treaty News, and there are other places where they have done an enormous work to show that even a developing country like India or a semi-developed country like us, we cannot just select an arbitrator as you like. Unless you go through a law firm, then the law firm will nominate, then they will get an arbitrator or you will get a counsel. Then what happens is that you can only be an advisor to the counsel as a litigant, as a party. So the arbitration panel is coming with one notion of law. Whether today they appear for you or appear for other side, they don't change the notion of law, the interpretation of law. So you don't get anyway what you want, and your arguments are not even taken They are not considered. Most of the tribunals proceedings are confidential up to some point. It's only later. As the matter is proceeding, you don't know what is happening there. Like today in Supreme Court, you can know what is happening in the court. You don't see that there. So this arbitrators is a college, and then there is a much destabilization because of the interpretation given by the arbitrators. Now what do? Do you have an arbitrators here who can match the Europeans? No. But then there are other issues like that. Everybody should, all the capital import countries should think about it. What is the capacity building? What is the capacity you have now to match that? Or what are the alternate legal principles that you put in place for testing the thing? It has not been done. Even today, I have with me the latest of the Indian bilateral agreement with the UAE. If you take that one, I will just tell, they have they have actually neutralized the what is fair and equitable treatment. They almost neutralized it. So that is the thing. But then there is no, then the same agreement agrees with the minimum international standards. You can see that one. Actually, they are one and same. But by one name you reject it, by another name you accept it. That problem is there in the thing. But still, I feel that this bilateral treaty between India and UAE is a much way ahead than many countries because of one reason. It insists mandatorily that before going to international arbitration, there is no such thing called fork in the road. You can take this, you can take that. But once you take this route, you cannot come back to the other. That's an old law. But our bilateral treaty, it's an excellent provision, says that you have to first start your redressal mechanism locally before the domestic courts and administrative tribunals created for this purpose. That actually is bringing back in reality, but of course they have given 3 years. In the 2015 bilateral model treaty, it was 5 years. Now they have reduced to 3 years. You should appreciate this effort of the government of India to safeguard its interests and then reducing from 5 years to 3 years, and without giving up the first, you have to exhaust the local remedies. Now, that 3 years, we have to create the infrastructure. But as a principle of law, that has been very well built into this treaty. And that is, I am telling you, it is bring back the customary international advantages you had in 1930s. What actually Calvo argued, what actually the customary international said in 1930s has been brought into force by this treaty with UAE. That's a very welcome thing. And there are so many other things. Now immediately I'll come down to one problem of you see this compensation. Compensation is very heavy actually. And you see, for example, you must have heard, all of you, at least the CTL experts, that the Tetian Corporation investment dispute between the corporation and Pakistan. The investment was 150 million US dollars. And then it was a licensing of exploration of mines and resources, whatever, or minerals. But in between, the company wanted an novation that you should license us to actually mine it, no more exploration. There was a dispute. The dispute went to ISDS. The ISDS said that, no, you have violated the treaty stipulations and there is no fair under this thing, and things like that. So therefore, they said that you give $4.9 billion. It may happen to you tomorrow. It may happen to Singapore tomorrow. It will happen because it is already a precedent in the process of ISDS area. It's a precedent. The Council for Companies will argue on this is the law. But so how come this is, you have to, okay. Now, because of the lot of confusions, contradiction, just I'll take 2 minutes. Now your UNCITRAL has seized the moment to create an adjudicatory mechanism to go away from the bilateral arbitration of ISDS and make it a multilateral standing mechanism. There is a draft pending now. It is almost ready for consideration from working group to ancestral full commission. Then 2025, this assembly, general assembly in 6th committee will consider. Now it has got a document for the guiding principles for arbitrators, guiding principles for mediation and negotiation before resorting to arbitration or adjudication. And then most importantly, it also has something called, cross-cutting issues. That is that not only procedure, but what are the procedures that cuts across substantive law, substantive principles. So under that cross-cutting issues, they also have brought the applicability of exhaustion of local remedy, reconsideration of all these principles that I was mentioning you, and that is an ongoing process. So now there are so many things of they have done for the past 2017 onwards. It's, I think, 49th or 50th session is going to take place October 1st week. They are considering all these matters. So I consider that the effort is to remove the bilateral process, put into a multilateral process of bringing a mother document that will be incorporating all these 6-7 protocols as a body of multilateral treaty, single body of multilateral treaty. Then they also take this bilateral arbitration process to a standing machinery of tribunals, tribunalization from arbitration process. So therefore, I think it is proceeding in a way that should be accepted as a very progressive step. But then between what they say is that there is many a slip between the cup and the lip. But then there will be a lot of hurdles in this one. It is not easy to remove what is the entrenched dominant principles of law imposed by investors and their home countries. But yet there is a hope that there will be some balanced treaty, multilateral treaty, with all the equitable principles will be in place. Then it is an expectation. But as you all know that in international relations, you cannot make a treaty overnight. You cannot make people to become party overnight. But the subject is going in a very direct, very, very progressive and a very democratic process. And I think a lot of things will be settled in this process. And next 10 years, maybe you will have a functioning, democratic, balanced treaty. This is what. But then, as a keynote address, I just throw certain issues. That's all. And thank you very much, sir. Thank you very much, all of you. And thank you so much.
Well, welcome to this session on balancing global markets and legal frameworks. And we've just heard an excellent presentation by Professor Jairaj on the mishmash of rules that we have in investment protection and the difficulties of adjudication. Now, we have an embarrassment of riches. We have 75 minutes for this session, and we have 7 presentations, if I am correct, including, and if you include mine, it will be 8. So I think I will have to request all these speakers to economize on their presentations and to speak no more than 9 minutes each, so that we can complete. Even without any interventions, even without any questions, it will be a very tight fit. But please take it as my very gentle request. Let me just get the ball rolling by saying a few words on the larger global meta picture of global trade and legal frameworks. Now, I have a few prepared remarks. The rules-based global system today finds itself at the crossroads. The WTO has inherited a large corpus of rules from the 9 rounds of GATT negotiations from 1947 onwards. What distinguishes the WTO from other multilateral institutions is the enforceability of its rules through its powerful legal framework. Today, however, the adjudicatory function stands eviscerated. The top tier of the adjudicatory system, the appellate body, has been rendered dysfunctional by a US veto on selection of its members. As a result, several disputes filed in the WTO have been put into limbo and cannot attain finality. It is important to connect the weakening of the WTO's dispute settlement system to the larger global environment in which trade is being conducted. Geopolitical confrontations are leading to a fragmentation of the global trading system, with global value chains going through several mutations due to political compulsions. Supply shocks caused by several developments like climate change, pandemics, and regional conflicts are forcing governments across the world to question laissez-faire systems and step in to address perceived market failures. The more active role of governments through the various kinds of interventions like subsidies, tariff hikes, export or import restrictions, etc., brings into play questions regarding their compatibility with WTO rules. As a consequence, several disputes are being filed in the WTO regarding such measures. Given the weakened state of the dispute settlement system, many of them are unlikely to be resolved. The larger question, however, is whether the changes in the post-globalization trade world constitute a new trade paradigm and whether it is sustainable to adjudicate disputes arising from new global priorities based on a legal framework designed and constructed in an earlier era. With the WTO's legislative apparatus unlikely to be energized in the near future through a new mandate for negotiations based on new priorities like the digital transformation, trade-related climate change measures, supply chain resilience, food security, public health, and so on, it is unlikely that the problems of the adjudicators in the WTO will be resolved soon. In such a situation, it is unclear what the ongoing initiative for the reform of the dispute settlement system can be expected to achieve. We will have to get used to muddling along in a world with few certainties. In the meanwhile, the gap created by the dysfunction in the WTO is being picked up by rulemaking in RTAs. Several RTAs now have strong dispute settlement provisions and are being increasingly used to resolve disputes between members. But it is questionable whether the spaghetti bowl of rules and dispute settlement systems is what the world needs to address global challenges. Thank you. I will now invite the speakers for this session to come in. Let me tell you the sequence so that you can be prepared accordingly. The first speaker will be Amshule Chandran. The second will be Pushkar Reddy and Imjot Kaur. The third will be Krishna Bhattacharya. The fourth will be Advait Rao and Vashisht Malhotra. The fifth will be Rimjim Rana Singh and Dr. Sania Yadav. The sixth will be Pranab Narang and Shiva Singh Chauhan. And the seventh, the last one, will be Sarthak Raj. I would also request you, before you start, perhaps you could just go around the table and introduce yourself in 1 or 2 sentences, not more than that. Thank you. We'll start with Pushkar.
Hello everyone, my name is Pushkar Reddy. I'm a research fellow at the Center for Trade and Investment Law. It's an honor to be here, and I'm happy to be presenting here and to receive comments from esteemed experts as well as from my peers.
Good afternoon everyone, my name is Ranjot. I'm a research fellow at Center for Trade and Investment Law, and I'm hoping for a very good session. So, thank you. Good afternoon everyone, my name is Rimjana Singh and I'm a PhD scholar at Pellet University, and I look forward to your feedback and suggestions going forward in this session. Thank you.
Good afternoon everyone, my name is Sarthak. I'm a young professional at Center for Trade and Investment Law. I'm honored to be here and I'm looking forward to all feedbacks in the session.
Good afternoon everyone, my name is Shiva Singh Khan. I'm also a young professional at Center for Trade and Investment Law, and I'm here to gather feedbacks and have an insightful session.
Okay. We have another young professional here. Good. Thank you very much for the compliment. I am Murali, a lawyer, law teacher, and a mediator. So we have
I'm Vishwesh Malhotra. I'm an associate at Center for Center for Trade and Investment Law. It's an honor to be here and looking forward to good inputs and interaction.
Good afternoon everyone. I am Krishna Mudacharya. I'm also a research fellow at the Center for Trade and Investment Law.
Looking forward to the session.
Good afternoon, everyone. I'm Pranav Naran. I'm currently working as an associate at Center for Trade and Investment Law, and I am looking forward to feedback from the panelists.
Good afternoon, everyone. I'm Amshali Chandran, an associate at Center for Trade and Law. I am looking forward to having a robust discussion and also good criticism on our papers. Thank you so much.
Thank you. We can only have criticism if we have time. So, Amshila, you have the floor for 9 minutes, and I hope somebody can keep the time, please.
Thank you so much, Ambassador Bhatia, for giving me the floor. I will try to keep it around 6 minutes so that if there is any time for Q&A, because that's what's important in these research papers. It's always important to have feedback and improve upon our work. So my research paper is on geographical indications and the protection accorded to geographical indications in the present WTO regime. Hold on. Can we just have the slide up, please? Thank you. Thank you so much. So it's geographical indications with regard to Indian geographical indications and comparison of the protection accorded to Indian geographical indications with those which are in Europe. So just to begin with, because there are 2 papers on GIs, I would just like to introduce as to what is a GI. So GI is basically needs to have 3 characteristics, which is it needs to be a good, which is originating from a defined area, and the good should have qualities, reputations, and other characteristics which are clearly linked to the geographical origin of that particular good. And the significance of a GI is it basically connects a product in such a manner that it highlights the product quality, it highlights the brand of the product, and it also helps in preserving cultural traditions. So this paper addresses the issues of GI protection. Indian GIs are not effectively protected and hence are facing infringements which lead to expensive litigation that most producers cannot afford. There are also certain measures which are there to improve GI protection and how we can adopt these measures. That is what the research paper aims to look at. And with regard to protection, there are two aspects that we look at. One is with regard to the protection which is accorded as per Article 23 of the TRIPS agreement, which is an additional protection which has been provided to wines and spirits, and mostly geographical indications which are European in nature, like Parmigiano cheese, Bordeaux wine, Kobe beef, Idaho potatoes, tequila. These are all certain products which are getting additional protection as per Article 23. And can we give the same kind of protection towards Indian geographical indications or not? That is something that the research paper is looking to explore. Another aspect is with regard to the multilateral registry aspect. As of now, there is a registry for notification purposes in India, in Chennai. Now, can we take it to a multilateral level for notification purposes, for transparency purposes, for providing protection to geographical indications on a unilateral plane or not? That is something that the research paper would like to address, and this is also provided in Article 23 para 4 of the TRIPS agreement. And also it also highlights the socio-economic problems that Indian GIs face. It is important to empower the people who are making these geographical indications. We see that a lot of producers are not well off economically, and they are unable to sort of produce them and basically have the financial backing to produce these GIs, and how we can improve upon that. That is something that this study looks at and aims to evaluate further. So to explore geographical indications in India, we need to have an insight, and we need to have to tap into what is the potential in the field. We need to look at the challenges. We need to look at the socio-economic aspects of it. We need to look at what the treaties are, what relevant treaties are there, what the ministerial conferences are holding on this, what the bilateral and multilateral agreements are going to hold with regard to geographical indications, and how we can enhance their protection. A basic hypothesis addressing these issues again with regard to the inadequate amount of protection, if the ambit is of appropriate legislation is there in this area. Is this legislation restrictive in nature? We presently have two legislation on geographical indications. One is the rule and the other is the act. Is this legislation enough? Do we need to do more? Do we need to create more? That is one thing that the hypothesis looks to prove. Another aspect is, do we have the machinery to provide this GIs? Are we going to provide protection to these GIs? Will we be able to bring them up to the protection that European GIs are getting? That is another hypothesis that we're going to look at. And also, what are the international mandates on this, and with whether we will be able to achieve that? What is the timeline for that? Whether India is looking to achieve it, and where India stands in the global market. That is something that the hypothesis looks to sort of prove. And the research methodology used for the same would be journals, articles, books, case studies, enactments. Sorry, I'm so sorry. Just give me a minute. Yeah. Case studies, enactments and commentaries, legislations and international mandates, which is amounting to a doctrinal type of research. And this is just a tentative chapterization scheme. The first chapter would be to introduce GI and GI protection. The second would be to go through the existing legal framework, right from the Paris Agreement to the WTO TRIPS Agreement. Then we would be looking at the comparative analysis of GI protection, which is there within and outside India. We would also be looking at the areas like, for example, which are in dispute, like, for example, basmati rice, which is being produced in parts of Pakistan and in parts of India as well. So how do we sort of apply for GIs in these particular cases? Are two countries going to apply together? Is the protection being given to both the countries? of the same product, how is the trade going to sort of operate between these countries and globally, those issues, those challenges, transnational agreements, how it's going to apply to GIs. That is something which we will be addressing, which I plan on addressing in this paper. And then finally, what are the issues which are dealing with GI protection with regard to Article 23, which automatically categorizes certain actions as infringements of GI, and the question of why India does not have that yet and how can we reach that stage. That is something that the paper aims to look at and research further, and also how we can have a multilateral registry, what are the implications of the same, and what benefits we would have as a country within India and also internationally. That is something that I'd like to look at this paper. Thank you.
Thank you, Arjun. Excellent presentation. For me, the important issue would be how India can avail the additional protections under Article 23. I look forward to reading your paper. Any quick questions? No. Well then, let's move on to the second presentation. Pushkar Reddy and Indra.
Thank you, sir.
9 minutes.
कौन सी
Yeah, this one. Yeah, first one. I start conference call.
ये ना
नहीं, first one.
पोस्टर
हाँ.
पोस्टर है.
Can you make it? Make it bigger. Thank you. Sorry for the delay. So I'll try to remain within the 9 minutes. So topic is about jeopardizing food security through restrictions on international food aid. So international food aid regime is quite unique in the sense that it's dealt with three different international legal regimes. International humanitarian law, international human rights law, and of course trade. But this raises an interesting normative question in terms of whether trade should be governing in food aid when it's primarily a humanitarian focused objective. So the purpose of this paper is to highlight the idea of WTO exceptionalism, a term meant to refer to the WTO in terms of operating within its own unique set of rules within international law, but also tweak it in the sense that whenever the WTO deals within a specific area that was initially dealt with by a different legal regime, they seem to become subservient to what the WTO does. And that's the primary point that we're trying to make, is that humanitarian role of food aid shouldn't be missed out, and that WTO exceptionalism has essentially replaced these other regimes. So I'll just briefly explain the current legal regimes that deal with food aid. So of course, food aid falls within the larger concept of the right to food, which is recognized in the Universal Declaration of Human Rights, as well as the ICESR. And of course, it's part of SDG Goal 2 in terms of ending hunger. In terms of humanitarian law, there are limited obligations in terms of how food aid should be administered. The primary one can be found in the Fourth Geneva Convention, which is a convention on protection of civilian persons in times of war. In it, Article 23 states that humanitarian relief should be given free passage for children below the age of 15 and for women who, for maternal women as well as women in maternity. So in addition to that, there's additional Protocol 1 to the Fourth Geneva Convention, which is Article 54, which states that you cannot impose, you cannot use starvation as a tool for war. Now, in terms of the trade regime, there are three primary conventions we need to be mindful of. The first is, of course, the FAO Principles of Surplus Disposal, which were developed in 1949. And they were essentially developed with the primary intention of dealing with negative dependencies, which is the idea that food aid shouldn't be flooded within a particular market and essentially make them reliant on that country providing food aid, essentially disrupting the domestic food production process. Under the other regimes that deal with food aid, which also has a humanitarian role, is the Food Aid Convention. This was developed in 1967 and was primarily only composed of donor countries. And the idea was that they would make obligations on these donor countries to provide food aid and to ensure that it was used for humanitarian purposes, which is to end hunger. The Food Aid Convention, which was created in 1967, was replaced in 2012, but the obligations more or less were the same. Now, finally, the most important organization that deals with food aid is the WTO. And in it is dealt with under the Agreement on Agriculture under Article 10.4, as well as the Nairobi Decision of 2015. Now, the two primary issues that we see in the current legislative framework dealing with food aid is in terms of, one, the absence of obligation on third parties in case of humanitarian crisis, and the second in terms of how the WTO has achieved the status of exceptionalism, whereby it replaces other regimes that deal with the same area. In terms of the absence of obligation on third parties, while we earlier mentioned the point of Article 23 of the Fourth Geneva Convention, you may have noticed that it's fairly limited. It's not for the general population, but only for specific parts of the population, those which at the time were considered most at risk during times of war. Now, the issue with that is that it creates the ability of third-party states to now restrict food aid in case there's no clear monitoring or there's no proof that the food is being delivered to these specific sections of the population. Now, the other point, and this was also an issue that arose during the delivery of food aid in Yemen and Somalia. Now, in terms of the prioritization of WTO, which is the second issue which I'll be dealing with, now the main idea is that the FAO and the FAC, which is the Food Aid Convention, has become subservient to the WTO. Now, this essentially has replaced the primary agenda of the FAO and FEC in terms of saving lives, reducing hunger, and improving food security. While the WTO does have rules in terms of food security, it's only in terms of how to provide food security to not distort trade. Its primary objective is not to achieve food security. There is a close linkage, but it's not interlinked in terms of the final objective of ending hunger. And that's something we need to be mindful of in terms of how the WTO regime operates in terms of food aid as well as other food security related measures. Now, in terms of why the food aid principle developed in close consonance with trade, we have to understand how the FAO principles developed as well. And they were developed in terms of two primary legislations that the US had initiated in 1949, which is the Commodity Credit Guarantee Scheme as well as PL 480. And essentially these two schemes allowed them to dump surplus stock into other countries so that they would essentially subsidize that stock, flood the markets, and make them reliant on US food products. The other reason for why they're doing that was actually political. The US noted that countries in Asia and Africa that were susceptible to food crisis also were susceptible to becoming part of the communist bloc. So they realized that by providing food aid, it would essentially serve their larger political agenda. This, of course, raised multiple issues in terms of food exporting countries, particularly the EC. So during the Uruguay rounds, when there was a massive reduction in agricultural prices because of the practice of dumping food products by the US, discussions on food aid were extremely heated, leading to the FAO principles, as well as, of course, Article 10 of the Agreement on Agriculture. Now, in terms of why we state that they're subservient to WTO, there are 2 points to consider. One is in terms of how the FAO and FEC have essentially waited for negotiations during the Doha round, stating that they cannot create any additional obligations in terms of food aid till the WTO negotiations are complete, because they're fearful of those WTO obligations running counter to the FAO and FEC. In fact, the FAC also explicitly states within its preamble as well as Article 3 that they're intended to serve the WTO, and that the WTO and that any obligation of the WTO should not be derogated in terms of complying with the obligations of the FAC and the FAO. Now, in terms of how these issues come about, this requires careful analysis in terms of how food aid is administered, as well as in terms of how public stockholding is also used. Now, the primary issue that comes up is in terms of how this is read public stockholding provisions in Annex 2 of the Agreement on Agriculture, as well as in the Bali Peace Clause. The way that the public stockholding provision is read in para 3 and 4, which, just for brief context, is used in terms of excluding members from including the support for their AMS calculation, is that it should only be used for domestic food security purpose. Now, it is silent in terms of whether that domestic food security purpose can then be used to be exported as food aid. Now, in terms of the specific requirement in 10.4, in terms of not making sure that it's used for commercial transactions, sorry, I'm just walking back a little bit. Now, there is another point we need to consider in terms of footnote 5 of paragraph 3 and 4 of Annex 2, which is that for any country that has an administrative price system, the difference between the administrative price and the external reference price of the 1986-88 period should be included within the AMS calculations. Now, the issue comes out for countries that have national administrative price systems, such as India, China, Saudi Arabia. Now, the problem is, now can these governments that have administered the AMS price now be able to export that food for food aid? Now, the way that Nairobi and 10.4 is read is that they can only do so if it's completely free or if it's a cash-based form. Now, the problem comes for these countries is that in Nairobi as well, it states that the cash-based commercialization that they can impose for the food aid can only be in terms of covering transportation costs. Now, for these countries that have national administered price, these systems are usually for countries that don't have the economic means to export a large amount of food aid. And they can only provide this food aid for covering the transportation costs. Now, if they were to choose or want to export it for price slightly above that commercial price, they'll be restricted from doing so and may invite questioning in terms of whether the price at which they had bought the crops were intended for domestic food security purposes. And now, in terms of the Bali Peace Clause, now because of the entire conundrum that comes with in terms of how the AMS is calculated, if countries exceed their AMS calculations, okay, I'll quickly end it. One minute, okay. So the Bali Peace Clause essentially states that you can exceed your AMS calculations and you can impose a complete exception. But now there's a greater obligation on them making sure that that food is only used for domestic food security purposes. So in these countries that have national administered food aid, they cannot export that food for that minor amount of commercialization. And this is considering that the WFP has resources to purchase food products and are willing to purchase it at administered price because it's less than global price. Now, in terms of what we want to highlight is that there should be an explicit carve out for food aid, that the humanitarian objectives of FAO and FEC should be prioritized in terms of compared to the trade objectives of the WTO. But yes, thank you.
Thank you. Very, very good presentation. Thank you.
Thanks.
I think the key issue is essentially that even though the objective is humanitarian, you are creating market distortion.
Yes.
And how to minimize that.
Absolutely.
And perhaps the solution is in how you calculate the AMS,
yeah,
and whether it is the 1986, 88 or something like that.
Yeah.
Thank you very much. Krishna Bhattacharya.
Good afternoon, everyone. So, my topic is the contours of e-commerce. Full name. Sorry for the delay. So good afternoon, everyone. So I think we've had a range of discussion and now it goes to e-commerce. And I think e-commerce is fairly known to everybody because recently in MC13 there was some discussion regarding e-commerce. But I would like to explore what are the problems still existing with the e-commerce moratorium and what are the problems. So to begin with, the slide is divided into 4 parts. Introduction, development at JCI. JCI is the Joint Statement Initiative, which is something which is a plurilateral agreement which is also being negotiated alongside what is happening at the Ministerial Conference and various other committees of the WTO. Then the trends at RTA and the way forward. Now, the importance of RTA has been already stated at the beginning, that there are so many RTAs that have come up and countries are coming up with new solutions. So it is also to look at these RTAs as to how the countries are approaching, and maybe that approach could be taken at a multilateral level where countries can agree to something. So to begin with, the introduction, I would like to first state out what are the three elements that are most important to understand. One is e-commerce, of course. Second is electronic transmission, where the major dispute is as to what is the meaning. And the third, what is the moratorium. So to begin with e-commerce, we first did not have a definition. But under the WTO, there was a work program. And then in that work program, there was a definition of electronic commerce, which was a very broad definition, which included production, distribution, marketing, sales, or delivery of goods and services by electronic means. And in this means, the means was done through electronic transmission, and there was no definition of electronic transmission. Now, because of lack of definition, there was a room for interpretation. Now, the question became whether transmission should be considered in terms of goods or services, or whether it is applied to on the content or the carrier medium. Content would be the ultimate product which a consumer gets, and the medium would be the medium which would turn into bytes and megabytes, and how the calculation is supposed to be done in those cases. Now, various RTAs have come, and then they have given some sort of solution or some sort of hint as to what they think. And the moratorium is something which tells countries that they cannot impose a customs duty as of now. And this came in 1988, where it was adopted at the Declaration of Global Electronic Commerce. Now, electronic transmission, as I explained earlier, if we see the earlier trends, it was said that the electronic transmission and the custom duty would be charged on the medium, and it was pursuant to the customs valuation agreement, and there was a decision in 1984 in paragraph 4.1 where they said that it would be charged on the medium. But slowly as it evolved, it got changed, and in post 2015 we see there are a lot of digital trade chapters in the RTA which tells that the custom duty will be charged on the content and rather than the medium. And till now there has been a lot of debates, there have been a lot of paper submissions at the WTO, but then there is not a cohesive answer as to what it would be. Now, with regards to products and services, we can see the variation. For example, in Korea-Singapore Free Trade Agreement, we see that the electronic transmission is considered as products. But when we see Colombia-Israel Agreement, the electronic transmission is termed as services. So this is the sort of a dispute that is still going on, and discussions on e-commerce are done at the parallel two levels. One is at the multilateral level and one is at the plurilateral level. At the multilateral level, there is a working group which is working on it, and there is ministerial conferences, various committees, trade and goods committees, work programs, etc., which is happening, and the JSI, plurilateral agreement, which sort of wanted a formalized text so that it could be so that certainty could be there. But unfortunately, it's still, the way is a long road. But in July 2024, we had something called the stabilized text, in which 91 member countries of the members of the WTO agreed to something. But the journey has been long, because the journey started from 2017-19, where there was an initiation and confirmation of JSI. There was negotiation, there was a draft chair text in March 2024, and finally, we have a stabilized text now. But what is there in the stabilized text? And I will only focus on what is with the e-commerce moratorium. First, on customs duties of electronic transmission. It prohibits the custom duties on electronic transmission by parties. We all know that in developed countries, for example, India and South Africa, had been advocating that they want to charge customs duty. But this JSI text, India is not a party to the Joint Statement Initiative, but this text says that there will be no customs duty. And also, 91 members are part of JSI. It's a huge number. But it does not takes us all our hope. There is a review clause in the agreement which says that after 5 years, they will review it. They will see whether anything could be done or not. And in these, before the stabilization of text, India, though not a part to the JSI, has also made submissions along with South Africa to JSI, stating an UNCAD report which actually stated what was the revenue loss that India and other developing and least developing countries would be facing. Now, what are the implications of India? The first implication is that the parties of the agreement of JSI. Yes. The parties of the agreement account for 90% of the global trade. Now, the agreement could set a future norm and regulations for the digital economy. But however, something which will be agreed at the multilateral level is also something to be seen, because something interesting also happened at the MC13. So at MC13, it was said that until the 14th session of Ministerial Conference or 31st March of 2026, whichever is earlier, the moratorium and the work program will expire on that date. But this also has a probability that countries may shift the paradigm to say that the moratorium will not exist. It does not give us full hope that it will cease to exist. So, trends at RTA. So now most of the RTAs have, or 95% of them have a provision which says that they will not impose custom duties. This is a chart which can be seen, which was taken from the OECD report. It maps the RTAs from 2000 to 2022. And in almost all of them, there is a provision which says that they will not charge a customs duty. Now, countries have found various ways in their own RTAs to do it. So there are 4 approaches that the countries are looking forward to. One approach is contingent at the WTO. So in the RTA's agreement itself, they say that whatever happens at the WTO, that will happen at the FTA level. So for now, if WTO is saying that there should not be any imposition of custom duties, the FTA will also not impose. But as soon as the WTO says or mandates that there will be an imposition of customs duty, it will reflect in the FTA. Something called permanent moratorium, where countries are not taking the caveat of the WTO outcome. So in those cases, either the agreement has to be reviewed again or it has to be terminated if the countries want to impose customs duty, because this is an obligation which the countries have taken permanently. The third is a compromising approach. In this, countries such as EU, Singapore and Japan, what they've done is they have not taken a very hard approach. They have taken an approach which is somewhere between contingent at WTO and permanent moratorium. While having discussions with the bilateral partners, if they see that the other country is very contingent on having a provision which is contingent at WTO, they would slide with that. If they think that there could be some flexibility given, they have slid to the permanent moratorium as well. Now, the way to move forward is to analyze what a country's interest is at the multilateral level and also at the bilateral level, because we all know that e-commerce has grown rapidly and there are a lot of things where we can also benefit. And even though India says that they want to have a customs duty, but even having customs duty, there could be some products where it may be a loss for India. So we have to have an understanding of what are those products where a custom duty has to be levied and what are those products where a custom duty will not have to be levied. And whether it has to be termed on services basis or on a product basis. So India's approach has also changed. Okay, I'll just take 1 minute to conclude. So India's approach has changed. For example, in Singapore agreement, what they had done is they had taken an approach where they said that they will not impose customs duty. But in the recent UAE, they have a digital chapter. In that digital chapter, they have said that they will not levy customs duty just for now, but as soon as a decision is there at the WTO, they will start imposing the duty. Now, what are the stakes for India? This is the report and some of the findings in the report that is there. But there could be 2 solutions. One solution is there are countries, there are OECD reports also, OECD reports and other reports also which says that instead of charging a custom duty, they could charge GST, which is at the consumer level and not at the customs authorities. And the life would make them easier for them. But this is also something which needs deeper understanding because it's still at an exploratory stage. And in terms of services, since India advocates for its services, there are two companies which I have said is Zoho and Freshworks, where India provides these services to other countries. And if a custom duty is being charged, imposing on us, it might harm us as well. A possible way for categorization onto how transmission could be there is something which I've also tried to make an attempt in our paper. For example, if there is music, what could be digitalized goods and what could be services? And based upon the characteristics of the goods and based upon the characteristics of a product, it could be in the terms of a goods or services, is something which is also a possibility which can be looked into. Although I agree that there could be there is a need of lot of research, and also we have something at our customs chapter, which is HSN chapter, which we have chapter 98 and 99, where these chapters are the chapters where customs duties are not imposed, but these chapters are also formulated so that new goods could be introduced, and something of these sort of categorization could also be put in so that India can identify as to in what goods custom duties we want and in what services we want. That's it. Thank you.
Very interesting. Thank you. The next is Advait Rao and Vishesh Malhotra.
So, thank you. Very good afternoon to all. Deepest gratitude to ISIL and CTIL for giving me this opportunity, and to Advait to present our paper abstract. And I think it's a good fortune that we are presenting before Ujjwal Singh Bhatia sir, who knows the ground realities of diversity in WTO panel not only better than anyone in the room, but in the country. So there is short time. In the interest of time, I'll take you through three questions. Is there a problem that in the WTO panel itself? Is there an issue at all? If there is, what is the problem? What is the current prevailing circumstances? And third, what could be the suggestions to solve it? What are we proposing? So, why is diversity important in the panel at WTO? International Court of Justice annual report finds that bench composition is one of the key topics mentioned in the negative evaluation of the court. States believe that diversity is a good in and of itself, and that represents across various dimensions an important democratic value that itself justifies the court's exercise of authority. Diversity increases trust in the system. It gives confidence to members who have never used the system to access and utilize the system, and diversity of lived experiences may help in better appreciating of facts and better rulings. WTO cannot be made a captive of privileged few. So it is interesting to note that the DSU provisions, Article 8.2, 8.10 and 17.3 specifically deal with diversity. 8.2 provision says that members should be selected with a view to ensuring that independence of the members have a sufficiently diverse background and a wide spectrum of experience. 8.10 is a provision dealing with situations where a developing country is part of the dispute, and on their request there is an inclusion of a developing country member on the panel. And 17.3 deals with broad representative of membership at the appellate body. This is a snapshot of the first most contributed top 20 countries at the panel. The data reflects that out of 828 panelists which are indicated at the WTO, developed countries out of the first 20 countries which are contributing most in the panelist, the 5 are developed nations and 15 are developing countries. So the first look may make you look that is there a problem at all, and this seems to be that there is a lot of diversity at WTO panel. However, when we look at the number of panelists which are coming out of these 5 countries are 250 in number, and the number which are coming out of 15 developing countries are 377. The ratio or the comparison speaks a lot that there is much more than what meets the eye. If you look region-wise, panelists are dominant by Latin America, by European and Central Asia, by East Asia and Pacific countries, and there is very limited representation of South Asia, which is where the maximum world population is residing, and similarly limited representation of sub-Saharan Africa and MENA countries. As we take a deeper dip and we crack it down to nationalities which are represented, the picture becomes much more clearer. As you see, the most number of percentage contributed at the panelists is from developed nations like New Zealand, Australia, Switzerland, Canada. And as we go to 1 or 2% representation of India, Pakistan and other South Asian countries, we could clearly see that the representation is skewed. And we come to the point of gender. This is a snapshot of the last 5 years, what has been happened from 2019 to 2024. 2020 stands out as a different year altogether, where there is a 1:1 ratio of male and female gender representation at the panel. But if you look at the overall picture, there are 673 men representation and 155 women, which is coming about to 81 to 19% ratio. This tells us that there is a very skewed representation of the gender at WTO panel. Further, as we go down to the appellate body, there is very interesting fact which remains at the appellate body is that again we might find there is a lot of representation of developing countries. But if you specifically notice the G2 countries, which is United States and Europe, there has been a constant member in the appellate body of either United States or the Europe from 1995 until it was declared infructuous. So if you keep noticing, all the highlights is that no other developing country or region is being consistently represented across in the appellate body. So this is what shows us. So a consolidated view of the diversity in appellate body is that again developing countries may have more representations, but are all regions entirely represented? Is there inter-regional representation of the regions? And then a gender disparity is something which cannot be excused. It's very, very patent, imminent on the face. So what are our key takeaways? Our key takeaways are that countries which are more populous like India, China, United States find low representation at the panel, whereas South Asian region, which is most populous, finds extremely poor representations. The European and Central Asia region is also dominated mostly by Europe, and the East Asian Pacific category of region is dominated by the Pacific countries. Representation in the MENA sub-Sahara countries not equal within the region, which is inter-regional representation, because South Africa tends to dominate within sub-Saharan Africa with 42 panelists appointed in South Africa, from South Africa. Similarly, in the MENA region, it is countries like Egypt and Israel which dominate the representation. WTO has a significant gender gap in the panel composition, with only 19% of the appointed panelists being women. And no female from South Asian has been appointed in the panel. Only 11 panel have a majority of female members, and there has never been an all-female panel. So what is our suggestion? Our suggestion is a point-based roster system, which will calculate the diversity index of the suggestions given by Secretariat. Similar to the language of 8.10, where it is mandated or it is strongly worded that of a developing country representation must be there when a developing country dispute is involved. So can there be a proposal to invite to have at least one female panelist who will to contribute to be part of the panel, which is a step forward towards addressing the significant gender diversity. Secondly, it requires more political and legal solution to have a more regional and geographical diversity at WTO. One solution we are exploring is the rooster system based on point based. These points will be awarded based on regionality, interregionality. Yeah, I'll just wind up. Thank you. Interregionality, and it will be a pre-established rooster system where parties will have the full opportunity to provide their own suggestions, to give their own representations. Each member country would, for example, have 6 names, 3 male and 3 female, ideally, so that there is equal representation. We have taken the figure 3 because that's what a panel comprises of, 3. These nominations are not subject to be vetted by the Secretariat. Members have to satisfy themselves only and meet the criteria of Article 8. And by having these new rubrics, we intend to what we intend to see is that regional representation, interregional representation, gender, legal systems are diversely addressed in the panel. That's about it. I look forward to comments. Thank you so much.
Thank you. A very interesting analysis. Let me offer just 2 comments. One is you said 34% of the panelists come from Latin America and the Caribbean. But I think you may wish to look a bit deeper, because if you look at the number of panels where the parties cannot decide on the panelist and the decision is left to the DG, in how many of those cases the DG chooses panelists from Latin America?
Yes.
Because there are several panelists from Latin America who are close to the Secretariat, who are close to the United States, and can be relied upon to give decisions in particular ways. And as far as the appellate body is concerned, you spoke about the G2.
Yes.
Unfortunately, now the situation is worse. It's G3 now. And because of power politics, there will always be one member from the United States, European Union, and China.
Right. Thank you so much.
The next speaker is Rimjim Rana Singh and Sanya Yadav.
बस ये चलाना है, ये करना है। ये नहीं है।
Good afternoon, everyone. The topic of my presentation today is balancing international investment law and human rights, the challenges and prospects. It was taken
forward by Professor Jairaj in the morning, the way the foreign investors have been treated, given privileges in the international investment treaties in the past decades, and but with the growth of the global shift towards the sustainable economic development and sustainability at the priority of all nations right now, the shift has moved towards just international investment law progression for an economic development, rather than it has more becoming to move towards a sustainable economic growth, wherein the sustainability covers the aspect of human rights. So what I'm going to discuss today is that how international investors, the foreign investors, when they land up in a host state, the land of investment, how they jeopardize the human rights of the local population over there, and the human rights can be hampered in various ways, which may cover the environmental damage of that area, the labor rights of the local population, the rights of the indigenous people, and the socio-economic disbalances also created sometimes. So the research, basically my research aims to find out the ways in which the balance between the human rights law and the international investment law can be created. What are the challenges which are faced by the ISDS mechanisms while going forward towards striking a balance? What is the role of the international organizations to strike this balance between the two different domains of international law, and to propose, since the work is going a lot, there are some legal and policy recommendations which I'll be giving in my research paper. A brief review of the evolution of international investment law goes back to a lot, but I'll just briefly go to that period wherein there was in 1916, if I'm not wrong, the liability was laid down on the the state. There was a liability of the state to look forward towards the foreign investors coming in, and their liability to protect their local population. Later on, in 1919, with the establishment of International Labour Organization, the first human rights which were seen were in the form of protection of the labor forces across the globe. After that, as we all know, the 1945 UN Charter, it established the legal fundamental framework for protecting the human rights, and henceforth the UDHR, the ICCPR and ICESR followed, which the international legal frameworks which started working towards the human right protection. But there have been conflicts since the inception of international investment law and the integration of international investment law with the protection of human rights of the local population. The violations which are caused by foreign investors, as I said, can be with the respect to the environment rights of the local population, the rights to water, health, right of indigenous people, and labor rights, as mentioned by me. And the conflict arises when the arbitration tribunals, they interpret the applicability of human rights law very differently in the international investment regimes. One school of thought is of the opinion to restrict the application of human rights law in international investment agreements due to the varied functions which are offered by them. But there is another school of thought which advocates that integration of social development, environment and human rights is necessary while we interpret the investment law, and it is believed that the international investment treaties, they may restrict the state's right to regulate in public interest if they do not explicitly include human rights provisions in their agreements. As said by Sir and in the morning, the arbitration process which is taken up in the international investment agreements, the ISDS mechanisms, of late it has been seen that it has intensified the tension between international investment law and the human rights law altogether. Now, there are some cases which prove this. There were case of a famous Boulogne case. The arbitral tribunals, they just rejected the adjudication of human rights aspect, stating the human rights claims as independent claims, and they also have rejected human rights claims by the host states, citing the condition of inadequate evidence in case of in a famous Toto case, which was in the Italy-Lebanon BIT, and in the Greece Romania BIT, in the Spyridon Rosalius case, the tribunal denied the human rights aspect just on the basis that they have authority for the human rights. They have the jurisdiction only for the claims from the foreign investors and not from the side of the host states. So there has been seen that there is a persistent lack of clarity in the tribunals, which can be seen in the ISDS mechanism and restriction of the host states' right to regulate for public interests. But with changing times, as we see, we are moving towards sustainability. There have been some notable case studies which say that now there are cases where in the tribunals, arbitration tribunals are taking up the human rights aspects also. Like in the Philip Morris case, it was seen, Philip Morris is a very big giant, tobacco giant, and in the Switzerland Uruguay BIT, it was seen that the arbitral tribunal, it fined the Philip Morris company for intensifying public health risks due to tobacco consumption. And the case was, just to give a brief, just to give a quick what happened is that Philip Morris declined to give the health warning on the tobacco consumption packets. So Uruguay came up with a claim and arbitral tribunal assessed it. In another case, very prominent case in Urbasar versus Argentina, wherein Urbasar was a water supplying company to Argentina, but Argentina, due to its financial crisis in some mid-period, it could not pay up to the money to the foreign investors, so they stopped providing water to the Argentinian people. So this was the first case in the history of international investment law wherein the arbitral tribunal declared right to water as a human right and asked the Urbasar company to start the flow of water through their canals to the Argentinian population. In another Greek Creek Mining Corporation and Republic of Peru case, it was seen that the arbitral tribunal had, they urged the foreign investors and the host states to include the local populations before entering into any foreign investments, and they should be told by the host and the foreign investor that what kind of investments are going to take place. So as we all know, since ISDS mechanisms were not very sufficient, so the Hague rules on business and human rights arbitration were brought up by open-ended intergovernmental working group of UNHRC, and they have a very different kind of arbitration mechanism for resolving the issues wherein the human rights are violated in investment treaties. And it was seen in the 4 Nigerian farmers and Shell case, wherein the Hague body, appellate body, it may asked for compensation from this Shell company to pay for the destruction which was caused to the Nigerian people. So yeah, just 1 minute. UNCTAD, as we all know, is also working towards balancing the international human rights law and the investment law by coming up with designing agreements with a sustainable development orientation. India has come up with new model BIT 2016, in which we can see that there is India-Belarus BIT and India-Kyrgyzstan BIT, which talks about the protection of the rights of host people in the preambles of the BIT now. And European Union has a very, I have taken 3 economies to develop and one of India, where as in I've discussed regarding the 2016 India BIT, the European Union has a very unique system of HRIA, the Human Right Impact Assessment Mechanism, wherein the new Italy BIT, they even, they suspend or any agreement if they find that there is any violation in the human rights violations through the foreign investors. And similarly, the United States of America USMA treaties also, they have separate labor chapters which provide a rapid response labor mechanisms. So for the enforcing the labor rights in case of foreign investors coming up with the investment in United States. So there needs to be a very balanced approach, and if you want to take investment law forward, then human rights aspect has to be considered. Since it's still a working area, the policy and legal recommendations are which can be included. They are like in the European Union, we should have HRIA, the impact assessment provisions in our agreements. There should be permanent multilateral investment court which has again human right provisions in the treaties, in the agreements which are being placed. And there should be special training, as I hope with the new guidelines for arbitrators which are coming up, the arbitrators should be trained with special human right laws dealing cases wherein the violation is being taking place. And of course the ISDS mechanism should be limited to come up with claims wherein, and a creation of an appellate body to just wherein there are cases of human rights violations. So this is all from my side. Thank you so much.
Pranab Naran and Shivsengjo.
Yes, sir. Yes, with regard to this human right, environment, public health, that was a very good example.
Yes,
but then Government of India in the UAE has incorporated all those things.
Yes, sir.
That's very important development. But one complaint about Government of India is that it has done an excellent work in resisting all the Western ideas in the BIT, but it doesn't give the leadership to the Working Group 3 in UNCITRAL. We would appeal to Government of India, it should actually lead the debate on the mega cross-cutting issues of the environment, human rights, indigenous people's rights. If it does, I think we will be the real global leader on investment law.
Absolutely. I think India needs to take a proactive role in the UNCITRAL discussions.
And so I have just one 30-second suggestion, I could not include it here if I have that permission. So like as we have Article 135 of the Companies Law 2013, it says that the foreign investors, any MNC or any corporation, they can, for the CSR responsibility, because CSR covers human rights. When they do something for the nation, I think human rights aspect shall be covered. So the legislation says that a minimum of 2% in the preceding 3 years of their profit, right? So I think it should, from the profit making, it should come up to annual turnover, because that will, force the MNCs to at least give some percentage. They can play with the percentage if you need FDIs, but instead of making it 2% from the profit, which most of the MNCs and foreign investors, they in their the papers which they come up, they say that we did not get any profit from the state. But yes, what they do is they go away with royalty to their own home country every year. They, the money they earn from India, they give royalty to their own home country every year, but they're not ready for CSR in our own country because the legislation only mentions the profit making clause and not the revenue in turnover in 1 year every year.
That's a good idea.
Yeah, thank you so much.
Okay, Pranab Naran and Shivsengjo.
Good afternoon, everyone. Today, I, Pranav Narang, and my colleague Shiva Singh Chauhan will be presenting our research proposal. The topic of the research will be conflict between trademark and geographical indication, balancing the consumer interest. So our study basically starts with the background of the topic, like how the geographical indication had evolved over the history, and how the trade how it conflicts with the rights of the trademark owner at times, or like vice versa also. So and we'll be following methodology, basically mix of doctrinal study and socio-legal research, where we'll conduct a consumer survey, and further my colleague Shiva will go ahead with the presentation.
Hello everyone, my name is Shiva. So background of the study starts from the recent case in Italy, which has raised concerns regarding conflict between trademarks and GIs. That case will be covered later on in the presentation by my colleague with several other cases. So we in this study we have focused on the importance of GI and how it affects international trade. Since GI, trade of goods related which have GI, they create a lot of value to the exporters, the producers, the manufacturers, and since therefore the conflict between trademark, the already established trademarks, and GI is very significant to be studied on. So methodology, as my colleague has already informed, that we have used social legal research methodology, and we are also conducting a survey where we are collecting consumer data regarding to check the awareness and the usage of using the products which have GIs. So these are certain points which we are covering, and the survey is still under process, and the study's aim is to get a perception and the impact of GIs in the marketplace. Then we will go on to explain what is GI, and so basically GI identifies the products originating from a specific geographical area possessing unique qualities, reputation, or characteristics, which may include some most common signs, long-lasting usage, name of country, place, iconic symbols, maybe certain environmental conditions of that particular area which influences the production of certain goods, or the type of manufacturing, type of labor skill, supposedly mangoes grown in Maharashtra, the Alfonso. So because of the environmental conditions, so that is different, the taste is different. So basic all these characteristics. Now basic differences between GI and trademark. So basically the most important difference is that GI are the symbols that show up products, and the products coming from a specific region. However, trademark are particular sign or use signs that distinguishes goods or services of one company to another company. So basically their owner is a individual or a corporation. In case of GI, there is a collective ownership, and GI is valid as long as standards are met. And in the case of trademarks, the protection is given for 7 years, and which can be extended later on. So in the next slide, we have covered level of protection which are given under different agreements. So first is under TRIPS agreement, and the level of protection is given under Article 22 subclause 2, which prohibits prevents the use of any designation or presentation that falsely suggests the origin of a good and misleads the public, or that constitutes unfair competition. Then the second is Madrid agreement, and therein under Article 1 subclause 1, So this provides a different level of protection. It provides a seizure of goods which have false indications of origin upon importation in any contracting countries. Then the third one is under Lisbon Agreement, and the level of protections are provided under Article 3, which provides for content of protection, and Article 6, which provides shield against becoming generic. So the case laws will be presented by my colleague now.
So mostly we are dealing with cases involving Italian cheese product and few of the European wine products. And the recent case is on wine products. So the first case involves European Commission and versus Germany, because the Germany court had come up with a decision on infringement of geographical indication of cheese product, or of a trademark product by a generic of a GI product by a trademark owner. So the general name of that product was Parmigiano Reggiano PDO. So it is a cheese, kind of a cheese which is grown in Italy, and German companies were using a similar name as Parmesan, which led to a conflict between the trademark owner, and which had gone to European Court of Justice. That case had gone to European Case of Justice. So the court had basically held that even though there is a chance that geographical designation can over time lead to a generic name, in the sense that consumers may feel that this product has a very generic, this name has a very generic use, and it can be used by anyone, and it doesn't originate from the certain geographical origin. However, there was a view that that the laws, GI law, does not only protect the correct form in which the origin of the product is protected, but it also extends to the misuse or any imitation which can be through a similar mark or similar translation of the same word. So yeah, so that was the first case we are analyzing, and the next. So there's another case which happened in Singapore. In that it involved grapevine, and there was that grapevine was being produced through a specific plant variety, and the name of the wine was being used in the name of that plant variety, similar plant variety. So the court had basically relied on a consumer survey to how consumer perceives about whether they are aware about that plant variety exists, or whether they are aware about that plant varieties used in a grapevine production. So yeah, that was one of the cases we've been analyzing in previous slide. Yeah, and this is the recent case which has been referred to European Commission by Italian Supreme Court, because they had encountered a novel situation, novel fact scenario, where the recent amendments, recent regulation had led to conflict between how GI, what should be the scope of the exception provided for trademark, and how the harmonious existence of the trademark and GI can be there. So, and that case is being adjudicated by the court right now. Like, they will be giving a decision. European Commission will have a kind of analysis on that aspect. So the next as we have told, like similarly, the way Singapore appellate court had conducted a market, like analyzed the market survey, we are also planning to have a market survey of just one. Yes. We are kind of planning to have a market survey of handicraft goods, Indian handicraft goods in foreign markets, which oh, sorry, sorry for the mistake. Like, yes, sir. So we'll be conducting these market surveys in the foreign markets where we plan to export, where we want to expand our market presence to understand the consumer perception about the Indian handicraft goods, which can inform the trade policy in this area, like which products we should prioritize getting protection in our future agreements.
Thank you. Last word with Sarthak Raj.
Can we get some questions before or after? I think you can just finish and then we can have our. Because you were told to finish by 4 o'clock.
Yeah, hi, good evening, everyone. We have been listening to a lot about trade and investment this evening, and we gathered a lot of expert views on how investment arbitration works, how ISDS mechanism works, and how WTO dispute settlement works. But I think this house is full of experts, but lawyers at the end of the day. And that's where my paper focuses generally, is with regards to certain events that took place recently in context of Russia-Ukraine annexation, and what happened with regards to ISDS mechanism and investment arbitration majorly. Now, before I move on to how my paper looked like or what exactly I'm to contribute here, I would want to leave this room with a question at the outset. It's a question about the choice that this room will make when this room faces with a conflict between ethics and obligation.
Introduce yourself.
Yeah, sure. Hi, my name is Sarthak Raj, and I'm the young professional at the Center for Trade and Investment Law. Thank you. Now, with that question, when I move on to exactly how things look like, so my paper basically talks about human rights violations and conflicts of interest in council resignation on an ethical conundrum in international arbitration. Now, this majorly focuses only in the context of investment arbitration because that's something that we have recently faced in the light of Russia-Ukraine annexation. Now, this paper is basically divided into certain parts. The first of which basically has an intersection of ethical and moral duties of these counsels and lawyers. The second part is because we don't have an obiter dictum and we don't have a light as to where we are heading, the only two cases that are available is Hrvatska and the Rome Petrol versus Romania, which act as a binding light or a guiding light towards how things would work with regards to this. Now, taking into consideration these contexts, I have tried to suggest how ethical and procedural considerations would look like and what would be the way forward in the light of certain legislations that we have, be it under ancestral model law or be it under ICC rules. And that's how I have basically considered both the conflict of interest of the lawyers or the counsels and how things would look like in the light of the moral obligations. Now, majorly, before I just go on talking about how things would look like, let's imagine a situation where either of us is representing our counsel, our client, and our client is a state that is involved in atrocities, in the violations of human right obligations. Now, in that situation, if one day you wake up to know that it's not a bad PR day for that state, but rather they have actually been engaged in those atrocities and human right violations, would you step in for that state? Or would you just withdraw knowing that the state is involved in such violations of human right obligations? Now, in this situation, the questions or the complexity of the ethical obligation and the moral obligation towards your client comes into consideration. And that is what we have witnessed majorly after the Russia-Ukraine situation. Councils have resigned and vocalized it by saying they are either mercenaries or guns of hire, which means that either they do not consider these ethical and moral duties and rather focus on their professional obligation, or they take into consideration their ethical obligation and withdraw their moral obligation towards how society should look like. And this is majorly what leads to the intersection between ethical and moral duties, because the human right violations at one stake and the professional obligations on the other is something very dicey for a council to choose for. Although there's nothing that binds them to protect the client, at the same time, there's nothing that requires them to respect those obligations. And that's a dilemma that the councils have been living in and resigning as to their discretion. Now, these two cases that I talked about is again not in the context of how councils have resigned. One, Hrvatska, and the other one is the Rome Petrol versus Romania. This only talks about conflict of interest that the council have had in those cases, and the tribunal has exercised their power to exclude these councils. Now, this exclusion of the councils can be interpreted as a silver lining that the council may take to say that if there's a conflict of interest already with the party, and if they go in the court of the law, they will anyway be excluded. So why not resign at the outset and not waste the cost and time of the parties and the councils? And that is why the question again falls back to the situation that is there something that binds the councils to represent their client in the light of these violations? Or is it the dilemma of moral duties and ethical obligations that will take them anywhere they want? So when I say this ethical and procedural consideration that I have analyzed from my perspective, I've looked majorly into the International Bar Association's guidelines on party representation and International Bar Association's guidelines on the conflict of interest. Now, these guidelines only talk about the party representation. For example, this particular clause that you would look into is only limited to the party representation and how parties should select their councils. And the second aspect, which is the conflict of interest legislation of the IBA guidelines, only recognizes the independence and impartiality of arbitrators. And they have this whole orange list, red list to recognize how the arbitrators can be put into this list. But that generally does not apply to councils. And that is why the question again is that there is a whole void that needs to be filled as to how the councils needs to be treated in this situation. Be it you go for an investment arbitration or a dispute settlement at WTO, if at the end of the day, the whole question falls down to what choice the council can make, there's no answer to it. Now, since there's no answer to it, there are certain rules that ICC arbitration rules or LCIA arbitration rules have in them, where they empower the parties to choose their counsel. Now, in situations where the councils withdraw or resign at the last moment, it's on the parties to either appoint someone afresh, or in such situation, they can ask the tribunal to appoint one for them. But again, the question is not about whether there's a right of legal representation on the part of the client, but the question is whether there's a right or an obligation on the part of the council to represent such clients. And it is in that light we believe, or I believe in particular as a part of my analysis, is that the choice of resigning and the choice or the right on the part of the clients for a legal representation is a conflicting question that needs to be addressed at the end of the day. And that's something, in the lack of guiding lights, we basically need to look into the moral dilemmas and the intricacies of ethical obligation and figure out where to take these set of arbitration rules and these set of dispute settlement procedures, be it under the bilateral investment treaties or multilateral treaties, to even preserve those rights of the client and the right of the counsels in the light of human right violations. And with that, I would leave this room to answer the question.
Very difficult question. Does anybody have an answer?
Sir, I have
2 sentences.
Yeah, 2 sentences. Yeah. First of all, it's a very interesting philosophical question about an individual professional choice and the conflict with the client. But he is a senior advocate of Supreme Court, senior advocate from Karnataka. I myself is a lawyer. We all have this problem constantly with us. But for the first time in international investment dispute settlement, because of the conflict of interest created by the arbitrators, now the working group of Amsterdam has taken a full code on the conduct of the arbitrators. That what is their professional obligation, what is the conflict of interest, and so on and so forth. So the time already the code is there now present into the full commission of the Amsterdam. It will. I think you have begun a very good topic. I wish that you continue to work following the working group. Secondly, a professional has got his own codified ethics, but you don't have a codified ethics for arbitrators. So you have to try for codified act, and the arbitration panel should be able to, if it has an evidence, should be able to say that you get out of this case. But then again a lawyer has got his choices. That he can apply a set of case, he need not apply. But the professional ethics says you should not deny a chance to represent a client. You don't have that liberty as a professional. You should be very clinical on that. You should not be emotional. So therefore, but anyway, you raised a fantastic question.
I wonder if it is the job of the council to stand in judgment
of his client.
That is the job of the tribunal. But Mr. Rao, maybe you have a view.
You know, the thing is here, it is a difficult question because you are representing a country, and a country is at war with another country, and there are human rights violations. There are ethical considerations which do violence to your conscience, which you have to decide that whether I should go ahead and represent such a country which in your opinion perhaps, or maybe a large number of people's opinion, is a violator of human rights, a person who is just trampling or hitting civilian targets. So I think that in a situation where there is an international dispute a council is representing, you may well have to leave it to the council whether he wants to continue to represent the client or not. Because the ethical considerations of something which is so vast and large in nature, where civilians are being killed in multiple numbers, where rights are being trampled in this fashion, it may do violence to your conscience that I do not want to continue to be.
It can be very subjective.
So you can't you can't say that council should be unemotional, should be unaffected by what the party is doing elsewhere in the international arena, and continue to represent them in any which way they want. I think the council's choice must be there, because as a lawyer, I would feel very uncomfortable if such a situation.
Great.
Thank you so much. Thank you so much.
I think the organizers must be getting very restless with us. But does anybody have any last questions or comments?
I had to that young gentleman quickly. You have cited those cases, but you have not said what the conclusion and the results are of those three cases.
Okay, the whole
wine, the cheese.
He wants you to do research, but these are only research questions.
You can give the reference to him.
No.
I was just analyzing the rationale.
What were the conclusions that arrived at?
They looked at whether there was consumer deception, and they have set that standard how it will be
analyzed.
In one of the cases in Singapore case, they had relied on consumer survey.
Okay.
What was the response of the consumer when they look at those marks differently at different instances.
You are on the process and
Let me make a few concluding comments. And speaking personally, I'm actually personally delighted that ISIL has now opened a new chapter with a very substantial involvement of young law professionals. And I think the kind of questions which the speakers today represented in their presentations were very refreshing and a blast of fresh air for me personally. And I'm delighted that young people today are entering this profession of international law. And I think you will do the country proud. So thank you very much for your participation. My best wishes to all of you.
Sir, we all thank you so much for a brilliant chairing the session. Then we request you to kindly stand with us for a photograph because we feel very happy about this panel. We want to have the memory of this panel.
You can all come.
Yeah. Sir, you sit because sit, sir. Sorry. Yes. Yeah. And then all of you, they will all come.
Yeah, always say youngsters get comment. I have
Oh, thank you so much for that. Sir,
Professor Jairaj has been secretary. He is one of our senior most members of the society. And he is the guiding force, rock star, as you may call it, to all activities of the society.
Yeah.
And in the hard task, he is pleasant man, but in the working hall, he will be hard.
Are you still teaching?
Sir, I am still teaching.
All of us are like that.
Please come. Come, please. All of you.
Yes.
All the panelists come. Hurry, later on. Please come here. Yeah, please, take a nice photograph. A souvenir.
According to the laws of physics, the image can never be better than the original.
If you are smiling, it can.
Now I would like to take 1 minute. I would now request Dr. Shikhar Ranjan, Director ALCO, to facilitate Mr. Ujjwal Singh Bhatia.
Sir.
After this, there is the inaugural session in this train auditorium. I would request everyone to join there.
Thanks for organizing the photograph.
Share it with colleagues.
Please take care of that. And after tomorrow, I'm leaving.
Welcome to the 10th International Conference on International Law Issues and Challenges. This session is on climate change. I'm sorry. This session is on climate change and international law, challenges and solutions. The chairpersons for the session are Mr. Sanjay Parekh, Senior Advocate, and Dr. Luther Angrezi, the Legal and Treaties Division. Dr. Luther Angrezi is currently the Joint Secretary, Legal and Treaties Division, Ministry of External Affairs, Government of India. He was the Associate Professor, Faculty of Legal Studies, South Asian University from year 2011 to 2015. He has also served as the Legal Officer in Asian African Legal Consultative Organization, ALCO, New Delhi. Dr. Angrezi was posted as Legal Counselor, Embassy of India, The Hague, where he was a member of Indian delegation to the Kulbhushan Jadhav case and the Deputy Agent Enrica Lexi arbitration, which is also known as the Italian Marine case. He has done an LLM from the University of Pune and MPhil and PhD degrees from the Center for International Legal Studies, School of International Studies, Jawaharlal Nehru University, New Delhi. Let's commence with the presentations now. Thank you.
Good evening. Good evening. Good evening. Let's start the session on climate change and international law. Let me exercise my discretion as the chair just to give you a general roundup of the subject. I think it's very important that we all of us here know and understand that it is a problem that is no more local in nature. It's not national, but it's global. And the General Assembly of the United Nations took upon itself to adopt a resolution long back in 1988 called as the it was a resolution was for protection of the global climate for present and future generations. And I think there are a number of issues which I would not highlight, but I would expect some of you to talk on. I have seen your topics. Firstly, the topic is climate change and international law. So let's look at the problem of transboundary harm, how the entire concept came up. Some of you would talk about that, I have seen. Added to this, one also needs to look at, in a certain context, starting from the Stockholm Conference down to the Rio Conference, and when the UNFCCC was adopted, and then what was it, the principles, and why was it important to get the international community on board to have this treaty in first place as a soft law obligations, largely to tell the world that you need to stabilize anthropogenic greenhouse gas emissions at 1990 levels. And these principles were built up, and they were built more strongly by binding obligations under the Kyoto Protocol. And as many of you would know, that there were binding obligations for the Annex 1 countries, the developed countries, and then there were Annex 2 countries. A large number of them were developing countries who did not have any binding obligations or targets, so to speak. These obligations were through mechanisms, emission trading, joint implementation, and clean development mechanism. The US did not ratify this, the major greenhouse emitter in the world as regards percentage. And then countries felt that the large number of developing countries were not on board. They call them large emitters, China, India, South Africa, and others. To get these on board, you got the Paris Agreement largely as a bottoms-up treaty that provides for voluntary, nationally determined contributions. You've had COPs starting from 1995. You'll have the next one in next month in Baku. The main issue is climate finance. I think that's a key which many of us need to understand. This reduction or the degradation in the carbon budget, it is directly linked to industrialization. And who has been responsible for this historically? The climate change treaties, the Paris Agreement, and the UNFCCC says very clearly that lead has to be taken by developed country parties, because they are largely responsible for what the mess the world is now. And if you want developing countries also to be taken on board, you need to provide them means of support by way of finances, cleaner technologies, as well as capacity building, as they call. I'll end by saying that the talks are going slow and countries are not very happy. Countries don't want loans. Countries want easy grants. They don't want to be caught in a debt trap. So I think the main way to get on board many countries to combat climate change is through finance. There have also been small island states who are extremely happy with how the protracted negotiations are going on. They have approached the Inter-American Court of Human Rights on issues of climate emergency. Colombia and Chile you had the COSE states going before the International Tribunal for the Law of the Sea. There was, an order this year in May, which very clearly says that acidification, oceanic acidification is a part of marine pollution of the marine environment. It's a big, improvement in what the Law of the Sea Convention defines as, pollution of the marine environment. You have a case before the ICJ that will come up for oral hearing in the first week of December. That's a much larger one, asking, obligations of states under international law, customary and, treaty based. They have also asked for, what are the consequences if these obligations are not adhered to. So there are a lot of challenging questions for international lawyers to look at. Having said this, I'll call upon the first speaker. And yes. Somebody else is presenting something? Okay. Thank you so much.
Thank you, sir. Now I request Professor C. Jairaj, sir, to felicitate the chairperson for the session, Mr. Luther Rangresi. Thank you, sir. We can begin with the presentations. First presentation is by Dr. Ashok Kumar Pandey and Anuj Kumar Sinha and Pragalp Pandey of the topic Climate Justice for Global Order, a discerning analysis from the prism of international instruments. The next speaker is Curtis Dobler from University of McKinney on the topic Historical Responsibility.
I'll be presenting.
I'm really sorry. You can start with your presentation. You will get a time limit of 12 minutes.
And I hope my screen is visible.
Yes, sir.
Okay, and I'm audible as well.
Yes, sir.
Okay, thank you so much.
Thank you.
Good evening, panel members and the participants who are here to present their papers on the major title, that is Climate Justice. This paper has been jointly written by Professor Dr. A.K. Pandey, myself and Pragalp Pandey. And I'll be presenting this paper on behalf of all three of us. The paper title is Climate Justice for Global Order, a discerning analysis from the prism of international instruments. So moving ahead with starting with the presentation, we need to understand what is climate justice. Climate justice is a combination of two words. The first being climate and second being justice. So my focus is on the word justice. So when we talk about justice, what do we mean about justice in sense of climate change? So climate change is an aspect which is going to impact all of us, irrespective of the fact whether we are contributing to or we are not contributing to climate change. So, because this phenomena or this thing is going to affect all of us, so this needs to be addressed. So, what is climate justice? So, climate justice refers to an ethical and political framework of climate change, emphasizing on being fair and just towards climate. So, climate justice has impact on basically three major aspects, and which I also term as the importance of climate justice. That is important of climate justice for marginalized communities. Second is with perspective from equity, and third is for just transition. So as the chairperson of this session rightly said in the very first aspect, that is, we need to not only talk about what we are getting from it, but how we need to transition from it. So as of now, it is a well-known fact, and this established fact that the marginalized communities are being affected to a greater extent by climate change because of the activities of other communities. In addition to that, the developed countries are contributing majorly to climate change, but the responsibility which they are sharing is reduced or is very less as compared to the impact that they are having on climate change. So, firstly, talking about marginalized communities, when we talk about climate justice, we need to ensure that marginalized communities who are least responsible for climate change are protected and prioritized in the climate action. Second, we talk about equity. Here I refer to equity in the sense of intergenerational equity, not intergenerational equity, because we have to share the burden of transferring the environment and the climate to our next generation in the same manner as we have received, and in a improved manner. Not talking about just transition, we need to shift our focus from non-renewable energies to renewable energies, that is moving from a economy that is based upon focusing on basically utilizing non-renewable resources to an economy that is known as green economy. So moving ahead, what is global order and how global order is going to affect climate justice? So global order basically is developed upon few elements, that is through the international institutions, international law, geopolitical stability, global economy, and multilateralism. Now, what is the importance of global order in this perspective? Again, I'll refer to the statement that was made by the chairperson of the session in the very first instance, that is sharing of responsibility. Now, we all know that there is a huge disparity between the situation as existing in developed countries and underdeveloped and developing countries. But when we talk about sharing of responsibilities, it is the responsibilities have been vested more upon the developing countries than the underdeveloped countries as compared to the developed countries, which is making this issue more and more grave. So a balance of power has to be there. There has to be rule of international law. There has to be global governance and stability, security, and peace. So, moving ahead, why is global order important for climate justice? So first is global cooperation. See, we have to treat climate of one place is going to impact the climate of another. Climate of one country is going to impact the climate of another. So if we take that as a whole, then this is going to impact the world as a whole. So if we have to mitigate the consequences of climate justice, we have to have a global cooperation, and that can only be done if we have a proper global order. There has to be equity and fairness, that is not only sharing of benefits but also sharing of burdens. Legal accountability. If there is cooperation and we do our jobs properly, there is no role of legal accountability. But what in cases where these two are not followed? So in that cases, we need legal accountability, which can be enforced through different international instruments or international sanctions. So majorly there are three, as per the research that has been conducted, there are three major instruments that are relevant to climate justice, which basically are covered under the United Nations Framework for Climate Change. Convention on Climate Change, the Kyoto Protocol, and the Paris Agreement of 2015. So I will start with the UN Convention, Framework Convention on Climate Change. So basically the main highlight which I want to talk about is the common but differentiated responsibilities which has been established under the UNFCCC. Now, what is common but differentiated responsibilities? That is, while all countries must act on climate change, but their extent of action should depend upon the damage that they have caused, and at the same time their capacity to mitigate such damages, because they have to work for common good, but based on differentiated responsibilities, because their position with respect to climate change is different in terms of causing harm and also in terms of their potential to mitigate such harm. Now, moving ahead to the Paris Agreement of 2015. The Paris Agreement 2015 focused on three major aspects, that is focusing on the limiting global warming, second is climate financing, and international cooperation. So again, if we go back to the very initial address of the chairperson, he in the later half or the concluding half of his address, he talked about climate financing. Now, climate financing is one very important aspect when we talk about climate justice, because climate justice cannot be done if harms are not mitigated, and for mitigating harms we need finances. Finances are most important. So this was one of the aspects of Paris Agreement. However, whether it has reached its objective or not, that is a question that needs to be addressed, and that is a question that needs to be introspected. Now, Kyoto Protocol of 1997, this was also basically focusing on almost the same areas. But when we talk about the Kyoto Protocol specifically with respect to the greenhouse gas emissions, there were certain parameters which was fixed, and there were certain goals which were set that by the end of 2012 we need to reduce the carbon emission by 5%. Then again, in the next later half. So these are basically, there are certain parameters that were fixed in the Kyoto Protocol. However, what has happened and what has not happened is a question that needs to be checked. Now, when we talk about climate justice and the sustainable development goals, so there are three sustainable development goals that are dealing with climate justice. The sustainable development goal number 13, that is climate action, goal number 10, reduced inequality, and goal number 16, that is peace, justice, and strong institutions. Now, these three goals are also basically the pillars of climate change or climate justice. So when we talk about how these sustainable goals are going to help us in climate justice, so definitely when there is a climate action which is focusing on mitigating the harms of climate change, definitely that is going to help us in doing climate justice. Reduced inequality, that is reduced inequality with and among countries, that is sharing of burdens, and peace and justice, that is promoting like peaceful measures or resorting to something that is more renewable, that is less environment harming or something like that. Now, when we talk about the role of international courts and tribunals in climate justice, so International Court of Justice has basically been has played a very important role when we talk about legal actions on climate disputes by through its advisory opinion and state responsibility of environmental harm. The role of International Criminal Court has been in respect of environmental criminal crimes and responsibilities, climate related crimes, and corporate and state accountability. Moving ahead, I'll be focusing on two case studies with respect to this. First is the Agenda Foundation versus the Netherlands. In this case, if we all must be aware about it, like this case was filed by a Dutch NGO which was representing 886 citizens who sued the Dutch government for failing to take sufficient action to combat climate change, and the District Court of the Hague ordered Dutch government to reduce its greenhouse gas emissions by at least 25% by 2020. Now, why this case is important? Because see, this case is highlighting one very important aspect, that is when individuals or when citizens unite, they can force the state to take actions which they ought to take under the international instruments. So this case is basically highlighting the role that can be played by we individuals and the citizens of any country. Next case is the Pakistan and climate reparations case. This case basically in 2022 Pakistan faced devastating floods, and the reason for the flood was the changing climate conditions of other countries, and Pakistan faced a lot of damage, and when it was assessed, it was not Pakistan which was only responsible for it. So in such a case, the Pakistan filed a suit, and it was basically decided that there should be a fund. It demanded a fund that in the name of loss and damage fund, which would provide financial support to the countries that are facing irreversible climate impact. So this is sharing a burden, that is common but differentiated burden. Now moving ahead, with the challenges that we encounter in implementing climate justice. There are three major challenges that we encounter in climate justice. That is geopolitical obstacle, which means the power imbalances between nations. Again, the same thing because of the control that they possess, diverging national interest, depending upon the socio-economic condition and the cultural condition and so many other factors. Every nation has their own diverging national interest. Next, economic constraints.
So you have 2 minutes left.
Okay, sure. Economic constraints, that is balancing development and emission of reduced goals, climate financial gaps, and we do not have a very strong enforcement mechanism, because of which this is a very big challenge in implementing climate justice. So with this, I come to the last part of my presentation and the paper, that is what are the basic recommendations that the recommendations from the authors. So there are basically recommendations have been put under two heads, that is strengthening international cooperation, second is increasing climate financing. So when we talk about international cooperation, then enhanced collaboration through international bodies is required. The United Nations, World Bank, and regional bodies, they can come together and they can take up this task of climate justice by promoting equity in climate action. Second is creating inclusive platforms wherein diverse stakeholders, as we are also stakeholders, might be our recommendations may be taken ahead. So we can come together and we can talk about like problems of climate change, and we can enter into climate negotiations, foster multilateral agreements. And when we talk about increased climate financing, support for vulnerable nations, we saw the example of Pakistan in the the last slide. then developed countries have to take additional burden because of their financial and economic status. Innovative financing mechanisms, that can be done through like something known as climate bonds, public-private partnership, debt for nature swaps, and capacity building, that is investing in capacity of developed nations to manage climate finance effectively and ensure that the resources are utilized efficiently for sustainable development. So with this, I come to the end of my presentation, and just concluding notes, which I would like to say is that climate change is something that is going to impact the human lives, like every area, be it food security, water availability, energy resources, biodiversity, every area is going to be impacted. So this is one area that needs to be addressed at the earliest. And for that, we can go through different areas. We can go for the just transition, indigenous climate action, in addition to the recommendation that has been given in the paper. So with this, I conclude my presentation.
Thank you, sir. So should we take this questions now or at the end of the session? Okay, sir. So the next speaker is Okay, sir. Thank you. The next speaker is Curtis Dobler from University of Mahognay on historical responsibility and intergenerational equity in international climate change law. Two sides of the same coin. Thank you.
Speak from here because I have a PowerPoint. Yeah, I can start it. Thank you. I'm going to address some of the points that go to one of the issues that was raised by the previous speaker, why we haven't moved forward, what has been done and what hasn't been done, which is the larger portion probably of what has happened during the climate talks. I've been involved in the climate talks since 2007 in Bali. I'm part of an NGO. I'm an academic, but I participate in an NGO called internationallawyers.org, and we have been involved in advising the G77 during the climate talks. So part of what I say will be based on that experience. What I'm going to look at is three questions, if you will. What are we talking about here? What is it? And by that I mean, what is historical responsibility and intergenerational equity? What is the law concerning these principles and why it matters? A layman's description of intergenerational equity, which I think is adequate by a Indian writer, is that you see on the board, which is really just the moral imperative that we take care of the planet in this generation so that the benefits, he says it a bit more drastically, but that the benefits can be enjoyed by future generations. Historical responsibility, which is perhaps a somewhat more problematic concept, at least in the climate talks, or I should say more diversive concept. I don't find it problematic, but some of my colleagues that oppose it do. It's a principle that requires that states bear responsibility for their actions in the past. To international lawyers, as I know many of you are, that's not a unusual concept. State responsibility, almost all international law, when it's applied in practice, is based on actions done in the past and responsibility for those actions. But in the climate talks, it has become a somewhat controversial item. The first thing I want to point out, because as international lawyers, and if there's a value in international law, it's as setting a baseline for the actions of states. And this is where you can find the principle of intergenerational equity. I won't go through all of those, but you'll see the first few are non-binding aspirational instruments, like the Stockholm Declaration, the Rio Declaration, the Rio +20 Declaration. But the last three there, are legally binding treaties. And one of them I'll come back to is particularly important. All of these state intergenerational equity, principles of it, usually by saying an obligation for present and future generations is important.
All of these, I would suggest, are the basis of that principle. And I put the precautionary principle at the top because that, although not a treaty principle, although it is a treaty principle, I should say, it is also a principle of customary international law. And that even widens, if you will, the remit of intergenerational equity. Historical responsibility, equally, one of the resolutions, a non-binding expression of it, was already mentioned, but it has been recognized by the General Assembly. It has been recognized by states, again, in non-binding instruments as well as in legally binding instruments, and I would suggest is the basis of the principle that has now been recognized as customary international law by several international human rights bodies, that the polluter pays principle, as we call it. Most important, though, what I want to focus on is the United Nations Framework Convention on Climate Change. It is a treaty that has been ratified by more states than the United Nations Charter. It is a treaty that has a section in it, Article 4, that is called legal commitments. So it is a treaty that clearly lays down legal principles and legal commitments. The principles are in Article 3, and this is Article 3.1. Article 3.2 reiterates it, but I think it's enough to just point out in Article 3.1 that it talks about present and future generations. It says that our action should be based on the protection of present and future generations, and it talks about common and differentiated responsibilities, which I'll try to indicate is a reflection of the concern for historical responsibility. This I probably don't need to show to international lawyers because this is just a very simple slide on how international law might play a role in international affairs and hopefully in the climate talks. It can guide our decision making, but I put it there mainly for the fourth thing on the bottom, which we often forget about, particularly when we're in all-night negotiations or when we're discussing even in more casual atmospheres, international law, and that is that this law should work for people. As your Supreme Court has often emphasized when talking about international law, the ultimate beneficiary of that is not the abstract state, but it is the people in that state. And I hope that we will, using these two principles of intergenerational equity and historical responsibility, bring that perhaps back into the climate talks, because right now it is very much removed from our discussion of action during the talks, whether it be finance or technology or even carbon trading. Let's look at it very focused on the climate talks or on climate change and the international negotiations. The first I want to point out is that these are, and that's why I use the title, two sides of the same coin, these are concepts that are both expressions of equity, and they are both concepts that express the understanding of states from both the global south who do not enjoy the level of industrialization of states from the global north. So in other words, they are, as our last speaker indicated, they are an expression of a call for equity by states of the global south. In the context of climate change, on the one hand, historical responsibility includes intergenerational equity. It does that because you have, by historical responsibility, you are automatically providing, if you take it into account, for future generations. On the other hand, intergenerational equity is an expression of historical responsibility because by providing for future generations, you have taken into account the action of generations in the past. More importantly, both these principles, as I already indicated, are established in legal instruments, not only aspirational instruments, but legal instruments. But the penumbra is how, in the climate talks particularly, do we encourage states to understand that and take that into account when they articulate their positions? Well, I want to suggest that one way, although there's no perfect answer, one way has been provided to us by recent jurisprudence, and that is the case that was mentioned by the moderator, the decision of the International Tribunal for the Law of the Sea on the 21st of May of this year. And it is the first of three cases. I'll just mention the others later. But in that decision, it mentions these issues of historical responsibility and intergenerational equity in three places, and I put them there on the board. The first one is not so important in terms of the law because it's actually in a section where it's discussing science, but it is important in relation to bringing this down to the role of people, because in that paragraph 66 will probably become one of the more famous paragraphs of this decision. It is where it indicates that we have to take climate action and that our obligations for taking climate action are really based on human rights, which are the rights of people there. It's not in that site because I limited it to the one looking at historical responsibility, but if you read that whole paragraph, the context in which it's talking about historical responsibility is in the application of human rights, and it's quoting there from the IPCC report. I hope one of the other speakers will go into more detail of this case because it's one of the more interesting developments. And if not, you'll find my views on it in an upcoming book that's being published by Routledge, where I have a chapter on this case. Paragraph 77 is in the discussion of what law is applicable, and possibly the most important part there, because it says that the agreement is required to implement, that the tribunal is required to implement equity and this CBDR principle that you already heard about, combat differentiated responsibilities, as a legal principle. Now, if I said that a year ago at the climate talks, I am sure my European colleagues would be up in arms and they would say it's not a legal principle. But the tribunal, for better or for worse, has said that it is a legal principle that it must take into account. There it's quoting the Paris Agreement, where it makes that statement, but the tribunal goes further because it includes that in its section on the law that it must apply. And last, it includes it, again, quoting the Paris Agreement, it indicates or reiterates later when discussing the concrete obligations under Article, I believe, 194, paragraph 1, it reiterates the necessity to take that into account. So the point I'm trying to make here is that the principles of intergenerational equity and historical responsibility seem to be given prominence and relevance by the tribunal through the principle of common but differentiated responsibilities, which it says is a legal obligation. And I'll just leave you with this then. These are two more opinions that will be upcoming, as we already heard, in the next few months. I participated in both of them, and I hope that we will see a continuation of this direction whereby the judicial authorities, international judicial authorities, find the principles of intergenerational equity and historical responsibility to be relevant, at least through the principle of common but differentiated responsibilities, if not on their own. Thank you very much.
Thank you, sir. The next speaker is Professor Uma Autka on global energy trends looking ahead to COP29. Should be joining us online.
Good evening, good morning. Can you hear me?
Yes, ma'am.
Okay, let me see if I can share the slides I brought. Are you able to see the slides as well?
Yes, ma'am.
Okay. Thank you. Thank you very much. It is an honor to me to be able to join you for the occasion of the 10th International Conference of International Law in Delhi from afar, and especially to participate with the other esteemed presenters for this session on what's truly the global issue of our time, climate change and international law. So in the time that I have, I hope to contribute to the dialogue by addressing global energy trends, looking ahead to COP29. The prior presentations have been an excellent foregrounding. It's appropriate to begin, as the first presenter did, with climate justice. The second presentation went through some of the key provisions of law that govern here. And so this is, as we think about the 29th Conference of the Parties to the United Nations Framework Convention on Climate Change in Baku next month, it's timely for this conference to consider global energy trends and the challenges that we know in Baku, international law will again be will put the global commitment to climate action to the test. Let me see if I can turn the next slide here for, can you see the next slide?
Yes, ma'am.
Okay, great. I wanted to foreground the discussion.
Ma'am, can you show us the full slide?
Let's see.
Yes, ma'am. Thank you.
Let's see.
Yes, ma'am. It's visible.
Okay. So if you see here, it shows total energy consumption by sector worldwide. Beginning, of course, it shows on the far left, 2022 is where this began. We're a little bit ahead of this, but this is from the United States Energy Information Administration, the International Energy Outlook. As you can see, the rise over time, we're not seeing with this amount of time shown, we're seeing an increase. Where they're showing the shaded area is an indication that there is there's the possibility of a lower or higher amount in each category. And this is important because over 70% of global GHG emissions come from the energy sector, according to the United Nations Development Program. And so we see the most increase in the residential and industrial sectors. But that is where we see some increase overall. Let's see. This is a graph showing, when we think about energy, one of the most significant topics and concerns is the use of coal globally. This is showing that in the near term, and this is the decade when key climate action is most needed, global coal consumption is continuing at a high level. In the United States, it is beginning to be retired at a fairly rapid rate, but even here, because of increasing demand for electricity, some of the power plants that have been slated for retirement will not be retired on the original schedule. So this shows that although the trend toward increased renewable energy continues at a rapid pace, as is desirable under the climate conference treaty, you can see that the coal consumption continues in a way that is very problematic for climate action. If you see, this shows the trends for industrial energy that pairs mostly rising energy intensity. It's mostly rising, but it pairs with the decline in intensity of energy. So there's some hope that there's a rise in industrial capacity without as significant of a climate impact, but as you can see, this is still also very concerning from an energy standpoint. The United Nations Intergovernmental Panel on Climate Change, Sixth Climate Assessment, is very clear. So all global modeled pathways that limit warming to the levels identified in the climate treaty involve rapid and deep immediate greenhouse gas reductions in all sectors this decade. So while I am emphasizing energy because of its significance overall, it is for all sectors that this reduction is needed. So if we consider here limiting warming to the 1.5 degrees Celsius and 2 degrees Celsius, involving these rapid declines. Earlier speakers, I think the first speaker in particular, was addressing the nationally determined contributions that the Paris Agreement called on parties to the convention to submit, essentially saying, here is the best way that we can as a nation contribute to solving climate change, reducing greenhouse gas emissions. This is a very concerning graphic. As you can see, the red line, the red line is showing implemented policies, and this is wholly inadequate. It may be arresting the prior upwards trajectory reflected by the black line from the past, but it is wholly insufficient to limit warming in the way that the treaty contemplates. So you can see the line, the sort of dotted line that connects the red trend of implemented policies to the green limiting warming to 2 degrees Celsius, which was the outer edge, not the desired target of the climate treaty, is quite a gap. And so that is where, leading into COP29, this is the framework at issue for and of great concern. So 2 other things that I'll share with you here from the IPCC 6th Climate Assessment that pertains specifically to energy is mitigation options, and here they're emphasizing by 2030, where is the best potential contribution to net emission reductions for 2030 as a threshold, if we consider this the critical decade for trying to achieve the trajectory reversal that we saw on the prior slide. Here the IPCC emphasizes for energy supply, solar, wind, reducing methane from coal, oil, and gas to the extent they're still being used, which is, as we saw, to a high level. Bioelectricity, geothermal and hydropower, nuclear energy, fossil carbon capture and storage. And so they rank them in terms of the potential options here. And many countries around the world, of course, are beginning to pursue these measures to various degrees, but as we saw, the ambition must be accelerated to a great extent. Here, this is an important pairing to the mitigation options that the IPCC identified. For energy supply, there are also climate adaptation needs. Here you see energy reliability is a climate adaptation concern, to the extent that climate mitigation focuses on reducing greenhouse gas emissions from producing and using energy. We also know that climate impacts, including extreme heat, weather disasters, etc., are harming energy reliability, which, as the first speaker indicated, is known to most negatively impact people who are already facing significant disadvantage. So building more resilient power systems is another method that's considered to be very important in this regard. So as we look ahead to COP29, as noted in Baku, Republic of Azerbaijan, next month from the 11th to the 22nd. This will be the next opportunity to gather together, and the overarching goal will be increasing ambition under the Paris Agreement, as was noted from the 2015 COP21. And the key, I'll look forward to being there in person as the speaking delegate for the American Bar Association. And the American Bar Association, the ABA, is the largest national organization of attorneys and judges in the United States, which has recently enacted several resolutions regarding sustainability, environmental justice, and climate action. And the goal of the goal of that role is to the stop share. Let's see. Sorry, can you still see the screen? I guess it doesn't matter. The goal of the American Bar Association to participate as an official observer is also to signal within the United States to lawyers that lawyers have a very important role in pursuing climate action and guiding clients in a way that is consistent with climate action. Obviously, this is a kind of a tense point in time in the United States with regard to what will be the continued participation and leadership in this area, which has been mixed and inconsistent over the years. We're facing a presidential election in less than 2 weeks, which could have will have very dramatic consequences for this. So I will be attending on behalf of the ABA, but without knowledge yet of exactly what the future will hold in terms of US participation. Hopefully it will continue as it has in recent years to be stronger and consistent in a way that is in contrast to when the President of the United States withdrew from the Paris Agreement in 2018. So I guess I'd like to close by saying, this is an important point that the President designate for the conference made in an opening letter to parties and constituents, noting the multilateral system is under pressure to show it can deliver at the speed and scale needed. And this is a litmus test, as every COP is, for the Paris Agreement, for global climate action, for cooperation, and all of these issues have to be the center of our collective work. And so the goal in part will be, as noted, climate finance and fully operationalizing the fund for responding to loss and damage that was established last year. The first executive director of that fund is only beginning their 4-year term on November 1st of this year. And there's also expected to be discussions about carbon markets as a mechanism for greenhouse gas reduction under Article 6 of the Framework Convention of the Paris Agreement. So these are all different aspects that will be the focus of this conference coming up next month. There will also be a focus on encouraging parties submitting their 1.5 degrees Celsius aligned NDCs at the end of February. There's a deadline of 2025.
Time completed. Can you please summarize it in a sentence or two?
Yes. So in 2025 February, the nations will have to update their NDCs if they have not done so. And so that will have to include reductions of greenhouse gases in energy to a significant extent, as shown on the slide with the downward trajectory. So thank you very much for the honor and opportunity to speak with you. I'll turn it back over to you and look forward to the remaining presentations in the panel.
Thank you, ma'am. The next speakers are Dr. Ari Kumar and Dr. Naveen S. on climate change and state responsibility, exploring accountability in a warming world.
Thank you. Good evening, one and all present here. And I'm Dr. Naveen. I'm presenting a paper on climate change and state responsibility, exploring accountability in the warming world, along with my co-author, Dr. Arya from Indian Law Institute. So basically, to have an introduction, brief introduction, I would like to take you to the fact that we all are very aware of now. The science has established beyond doubt, and we are all now well aware that the impact of climate change will be felt locally, regionally, and globally, making it a very transnational issue and will have severe negative consequences for the future generations. So why we say it is for the future generations? Because the real fact is that even if we stop emitting greenhouse gases or discharging greenhouse gases into the environment, so whatever has been discharged so far will continue to cause the same impact for a long period of time, because all these greenhouse gases remain in the atmosphere for more than decades or more than 100 years for a period. So it's not only mitigations that is important, it is also important that we should look into adaptation point of view, because this is more important from a global south perspective. So when I talk about state responsibility, as Sir was pointing out, Kutis was pointing out, with regard to the responsibility of the past as well as the future, adaptation to the climate change makes a relevant point here, because when you take responsibility for the past actions, and if you can impose that liability upon the states responsible for those actions, especially the global north, then you can make them liable for the adaptation expenses that would be borne or could be borne or should be borne by the developing nations, especially the global south in the coming world. So so that is one important point. And then with regard to the future generations, as the UNFCCC has already specifically stated in Article 3, that with regard to that, you need to think about CBDR, and you should have the principles of equity. But when you examine how this CBDR and the principles of equity has evolved, initially when it got crept into this framework convention as well as the Kyoto, you can see that the global south, which was led by India, had played a very important role in including the CBDR and the principles of equity during the late 80s when this framework convention was being drafted. So, but you can see that over a period of time, in the name of not the per capita emissions, but with regard to the total emission point of view, the global north has been forcing or pressurizing many of the developing countries like India to come out with commitments, and the CBDR principle has been significantly diluted. If you look at the present framework conventions, the convention as well as the Paris Agreement, you can see that there is no more CBDR. There's no relevance for CBDR in the Paris or any other international climate framework that we have at present. And if you look into the Paris provisions, which talks about the obligations, you can see that these obligations are we may say that these are legally binding, but again, when you read the obligations, you can literally see that these obligations are left free from where we had a binding obligations under the Kyoto Protocol, which again, as Professor Luther sir was pointing out, how that has been manipulated through mechanisms, and rather than being reduced in mathematical proportions, they have tried to manipulate it by creating bubbles. When you take the case of European Union and many other, the global north has tried to escape it in the way of joint implementation or carbon trading, etc., etc. So, but now if you see this, the current Paris Agreement, we talk about the better ambitions, higher ambitions, etc., etc. But even though the Paris Agreement and the national determined contributions talk about the ratchet mechanism, where every 5 years you have to increase ambitions which you have set in the initial stages of your INDCs, you can see that nowhere the Paris talks about the minimum requirements of ambitions that should be set by the global north. At least they could have said about the global north. That they do not explain who constitutes the global north or who constitutes the developed or the developing world. That is a very interesting fact you can see in the Paris Agreement. Nowhere that explains who are these developed or who are these developing world. So in that context, what I would like to point us, or what I would like to take you to, is the importance of how state responsibility as an international fundamental principle could play an important role in the absence of, or even in the presence of these specific climate agreements, because that is one important development that is happening in the recent world. Actually, as Professor Kutis was pointing out with regard to the state responsibility being addressed through the ITLOS, because we have ICJ coming up in December first week, but the ICJ recommendations have been sought in March 2023. Statements and written statements are being sought by the ICJ, and now we are waiting for the 1st December, where in the light of the various international agreements, starting from the UN Charter, UN Conventions, the ICCPR, ICSCR, UNCLOS, Paris, whatever it may be, all the international agreements, what liabilities and responsibilities the state would have over a period of time in addressing the problems of the peoples, the vulnerable states, the low-lying island nations. Because as far as now, what we have is that island nations have gone to the ITLOS seeking an opinion on the state responsibility for climate change. And very interesting fact is that this is going to a very important step for the ICJ to when it comes for the open hearing, public hearing in the first week of December 2024. This ITLOS contribution or ITLOS decision is going to make some changes or some influence in the decisions that the ICJ would take in the coming December.
What are the changes?
Sorry, sir.
What are the changes?
In the ITLOS.
I'm just wondering. Hope you will deal with it.
No. The changes in the sense that what I mean to say is that, sir, this would have some kind of influence. This ITLOS decision may bring some kind of influence on the.
ICJ you were saying.
Yeah.
I'm just asking you as a scholar. What do you see as these changes?
What changes can be brought, sir? I don't expect much changes in the ICJ, but discussions can happen, because the changes in the sense that, sir, I'm not sure about the changes what could be brought. But when you look at the international framework conventions and framework convention on climate change, the Paris, these are all an attempt to bring everybody to the forum, sir, because there has been a lot of conflicts after the binding obligations in the Kyoto. But then you wanted all the global north and the global south to the same table. Then it was, in order to bring them to the same table, we have put the platform open to all of us, so that the north and the south come together and discuss something. Because this is something, because this, even though we talk about the ratchet mechanism or binding obligations on the Paris Agreement, what binding obligations that Paris Agreement could bring us in the future, when you submit your proposals or your ambitions every 5 years, it is brought to the notice of the global world. Now, unlike the earlier situations where the civil society was kept apart or aside or kept away from the plenary sessions of the Framework Convention or the COPs, now the plenary sessions are being attended, and parallel sessions are conducted along with the plenary sessions in the COPs by the participation of the NGOs, the participation of the some metro cities are also being represented, and civil society is also representing these parallel sessions as well as the plenary. They're contributing to the plenary session. So some kind of influence is happening from the civil society side, and some influence is happening at the media side. So once you publish your ambitions and your ambition gets projected and it is known to the society, some kind of influence will happen. It will create some kind of influence in the society, and some kind of pressure might also come to the countries who are submitting their ambitions over a period of time. The pressure that the civil society could create once you submit your ambitions, and once you because every time we go to the COPs and make promises, see the loss and damages, the climate finances have been discussed for a long period of time. But what has happened is that no significant contributions or changes have brought about. So, but this NDCs will expose a particular nation to the global community, how they are making their promises, how they are making their commitments in the COPs, and how they are coming out with their promises. What are their real outputs? So once this reviewing monitoring process comes to the fore, because this as somebody was pointing out, like, we need certain mechanisms for a developing country like India. We don't have the monitoring, reporting, and verification mechanisms. MRV is not so robust for developed countries. Well, whereas in the developed countries have monitoring, verification, and review process are very strong, so they are able to realize or understand how much emissions they are carrying out. So for when we come to the discussions on international fora, some of the arguments or criticisms which we may have to face is that we do not have the sufficient, we are not producing the sufficient data or the actual data, and actual data is not possible for many of the developing countries when we do not have the sufficient resources to collect where the emissions are happening, where the emissions are getting leaked, where the resources are getting depleted. So there is a issue with regard to that when we really bring this emission levels to the global fora. So that is one important point.
Sir, 2 minutes.
Sorry. So then this ITLAW's opinion, if you look into the ITLAW's opinion, you can see that the ITLAW's has actually highlighted the importance or the potential of UNCLOS as an independent, but as an institution or as an organization that could also potentially contribute to addressing the problems of climate change. So UNCLOS can parallelly work in side with the Paris Agreement to address this issue. So so I would like to stop with this, and we'll take up any issues later on when the discussion happens.
Thank you, sir. The next speaker is Suyash Kunal Joshi on synergistic approach for aligning climate change narratives and environmental laws. The next speaker is Manvi Singh on the role of tribal and local communities in mitigating climate change impacts on biodiversity, international law perspectives, and conservation strategies. My slide is on.
Thank you. Good evening, one and all. I'm Manvi Singh. I am an assistant professor of law at Delhi Metropolitan Education, which is affiliated by Guru Gobind Singh Indraprasth University. It's me and my colleague, Mr. Tarun Sharma, who have worked on this paper. Firstly, I would like to tell you that my inspiration for this topic comes from my time that I spent in New Zealand while I was doing my LLM there at the University of Auckland. New Zealand is one of those countries where the Treaty of Waitangi, they have a very unique take on environment. They preserve it, conserve it with a passion that I have hardly seen anywhere else. And the reason for that is their tribes, their tribal, their indigenous people, that is the Maori community. And so that is the inspiration behind this topic. I would like to begin. So, from anthropocentric consumption ideology, which is that human beings, the anthropocentric ideology believes that human beings are at the top and everything, all the resources we have in nature are for our own consumption. Every other species takes a backseat in this ideology. So this ideology is the one which has ushered us today at the doorsteps of climate change at a point where we are seeing complete and utter degradation in environment nowadays. The UN climate action reports, they require a long-term mitigation plans at this point to meet the goals of the Paris Agreement, which is to keep the warming levels under 1.5 degrees Celsius, to protect the population from extreme heat and also to keep ecosystems from collapsing. Climate change impacts have been felt across the globe. Bleaching of corals, frequent devastating floods, hurricanes, exacerbated wildfires and droughts have been observed all over the world. It is something nowadays, every single time you will access a news channel or a news report, you will hear about one or the other environmental devastation that has been taken place in one place or the other in the world. Henceforth, we have come to the conclusion that the global biodiversity right now is under an imminent threat, and it is upon us to finally actually look at solutions. And these solutions, we have so much advancement today in the technology, and it's my personal belief and a belief around the world of a lot of people who hold the same ideology and viewpoint with me. They share it with me actually, that with modern advancements, there is something that we need to look at. There have been tribes, there have been indigenous communities all around the world, and they have stood in the face of climate change. They have navigated climate change, even though there is a lack of scientific or formal knowledge like we have, like the education we go through, but they interact with nature and environment in a way that we don't really and truly understand. Their environmental practices have been there for eons and have been ongoing, and they have somehow managed to be resilient in the face of climate change. They adapt and they adapt and they adapt. They are the worst affected when it comes to climate change impacts, because biodiversity, the ecosystem that they live with, it's sacred to them. It's not just something they rely on for their livelihoods, but it's also something they rely on for their spirit. So I would like to talk about biodiversity. From microscopic fungi to mega forest, biodiversity is the collective term for the variety of life on Earth in all its forms. It is 4.5 billion years of evolution embodied. Biodiversity is responsible for our food, our soil, our water, our weather, even the air we breathe today. Yet, despite being a crucial foundation for our collective future, biodiversity is often lost amid conversations on climate change until recently, very recently. Now, Dr. Thomas Lovejoy had something really nice to say, that's why I've included it in the slide. He says that without biodiversity, there is no life on Earth, including our own. Even though we are often oblivious to it, this diversity of life is what provides clean water, oxygen, and all the other things that end up being a part of our diet. So, all in all, we understand that biodiversity is at the very root of all that we are. We don't exist as humans in isolation. We rely on a lot of things that we don't even acknowledge at times. Convention on Biodiversity stipulates the importance and urgency to preserve and conserve biodiversity globally, as it is intrinsic to the survival of human race, like I said. Ecocentrism and indigenous worldview, this is the main theme of the paper. This is where this is what sits at the center of the paper. Ecocentrism postulates that every living organism and its natural environment holds an intrinsic value, irrelevant of the fact that human beings place an utilitarian value in such a living organism or its environment. It is the focus on the interest and moral values of all species, as well as abiotic features of Earth's ecosystem. Ecocentrism does not focus on all living organisms having equal value, but instead on the Earth or the ecosphere as the most important central value. The indigenous perspective. The indigenous people, tribals, and local community hold nature around them in a sacred regard. Custom and culture is woven around their environment. They nurture the nature and vice versa. For instance, the Maori, the indigenous to New Zealand, in their cosmology, they believe in the principle of Kaitia Kitanga. Kaitia Kitanga means that you are a steward, you are a guardian of nature. It is not something you own, it does not exist just for your consumption. It is something you nurture and it nurtures you back. Similarly, the tribal communities of India, like the Gond, the Madhya, Pradhan, and Kolam of Gadchiroli district, who call the lush forest of the district their home, too recognize nature as part of their families and observe a sense of fealty towards their natural habitat. Their customary practices, as a result, have contributed immensely in the conservation of biodiversity of their district. Animals are viewed as equal partners. I would just review this in short. These tribes, their culture itself, every animal in their household, every plant they grow around them. The Gadchiroli district has a very huge forest cover. They're actually fighting for it right now. There are a lot of issues going on in the said area. I'm so sorry, my throat's a little off. So these people, this is by the way Gond, the Gond style art. What I wanted to display here with this art was that they infuse nature into their art also. They pray to it, they live for it, they thrive in it, and they protect it. And henceforth, it has shown with the studies, scientific studies have shown that these tribes and their existence is what is conserving the lush forest area in the district at the moment. The role of tribal and local communities, we call them the key stakeholder. The UN has been hesitant when it comes to adopting a specific definition, as it is difficult to be inclusive in the context of such a diverse group of people. The Indigenous and Tribal Convention 169, 1989, which concerns indigenous and tribal people in independent countries, of the International Labour Organization, along with the 2000 United Nations Declaration on the Right of Indigenous People, majorly recognizes self-identification, connection with natural resources, language, culture, and traditional governance systems as markers of indigenous people and local communities. While these communities are only a 4% of the world's population, they manage around 11% of the total forest land and maintain almost 80% of the world's biodiversity. Hence, they are one of the primary sources to observe and learn environmental management because of the traditional knowledge and customary practices passed down to them generationally. So they can teach us a lot that we don't know. They can teach us a lot that we might have forgotten with time. So sometimes, I'll just conclude. We went through a few case studies, and I would just take you. This is the Chipko. This is from the Chipko movement, the very famous Chipko movement from the Himalayan region, where they stopped the felling of over 20,000 trees, which was government backed. By the way, this deforestation was government backed, and these people came to hug these trees through Chipko movement, and they were like, no, we will not let you cut down these trees because they are intrinsic to our survival. They're intrinsic to our life culturally also. We had a few case studies. I will go through just one of them and then I'll conclude. The Zia pits by the Mozi people. Now, this is an innovative technique with the droughts, with the sparse rainfall, with scanty rainfall, with no particular weather pattern, which is again a direct impact of climate change. The Mosi people have come up with a very ingenious technique of farming, of keeping themselves and the community fed. They dig these small pits in the ground to enhance water retention, and they basically send the roots down as deep as they can in the ground, and with little water also they can still grow food to farm for their community. I had some international legal legislations there. We were going to talk about Convention on Biological Diversity, which has talked and finally acknowledged indigenous people, but there's still a long way to go when it comes to their representation, their lobbying, and for them to have an actual voice at the international forum, for them to have enough of a voice for specific convention and laws to be brought in their favor, for the world to actually look at them, for the world to actually acknowledge that yes, we see you, we see what you're doing, we see how you have been surviving, and we will learn from you. Thank you. Thank you so much.
Thank you, ma'am. The next speaker is Gopalam Gupta on navigating the regulatory frameworks for renewable energy production and distribution in India.
Thank you. A very warm evening to the respected chairperson and all the respected delegates present here. Everybody here has been talking about the international agreements. Let's talk about something which where international agreements have been implemented in India. Climate change has always been an issue for the past decades. To overcome climate change, during these past decades, we have moved from there has been a transition from conventional sources to renewable energy sources. For bringing these renewable energy sources into regulatory landscape, there have been a few policies and legislations which have been implemented in India. Proper utilization of these renewable energy sources require fully functional and well-developed drafted regulatory framework that meet the international standards and fulfill all the international agreements and treaties. India has set certain targets, one of which is to achieve 500 gigawatts of renewable energy capacity by 2030, and I don't think it will be possible if proper regulatory frameworks are not implemented in India. Climate change has always been a global issue, not restricted by any national boundaries. Sustainable Development Goal number 13, which talks about climate action. This can also be brought about by moving from conventional sources to renewable energy sources. As we can see, there are a few importance of regulatory frameworks, such as it facilitates investment into the renewable energy sector. It also attracts FDI from the foreign countries. Further, it supports the meeting needs of the renewable energy targets which have been set by the government. Deregularization of the energy sector allows the private players to enter into the market, and they can certainly generate electricity from the renewable energy sources, such as captive generating. What is captive generating? The huge huge industries, they can build their own powerhouses from renewable energy sector and use its own energy without relying on the other power generators. Further, the regulatory frameworks allow open access of energy to the consumers. Now, moving on to the historical development of the renewable energy in India. So, the primary focus of generating renewable energy in India was on hydroelectric power. The first hydroelectric hydropower project was the Sidrapong Hydroelectric Power Station, commissioned in 1897 near Darjeeling in West Bengal. The focus of that project was to use the waters from the nearby springs and rivers and to generate electricity to be used in the tea estates of the region. Thereafter, there has been a boom in hydroelectric power projects in India. First solar and wind initiatives were taken during 1970s and 1980s. The first commercial wind energy project was established in 1986 in Muppandal, Tamil Nadu. 1990s saw a policy rush where policies were drafted for promoting wind energy, and the governments also started offering tax incentives and tariffs for investing in the wind energy. In 2003, Electricity Act was implemented, which contains various provisions for the development of renewable energy sector. National Solar Mission of 2010 was a huge turning point in the solar energy. This mission was aimed at making India a global leader in the solar power development, solar power generation. India is also a signatory to the 2015 Paris Agreement, which aims to remove the carbon emission. India has also set the goal of achieving 500 gigawatts of installed renewable capacity by 2030, and for this, renewable energy regulatory landscape is very important. Moving on to the ecosystem of the renewable energy. So the ecosystem of renewable energy depends on the working of key government bodies such as Ministry of New and Renewable Energy, which is a government agency responsible for drafting policies for implementing the renewable energy, for generating renewable energy and developing the renewable energy sector. Also, the Solar Energy Corporation of India, which is a public sector unit under MNRE, focuses on implementing the renewable energy policies. Private sector participation from companies such as Tata Solar Power, Adani Green Energy, and attracting foreign direct investment from various countries has enabled the development of renewable energy sector at a faster pace. Public-private partnerships, green bonds, viability gap funding has also aided in the development of renewable energy sector. Now moving on to the Indian energy policy landscape. So there is a series of regulatory frameworks dealing with the investment, production, distribution and integration of renewable energies in India, such as Electricity Act of 2003, National Electricity Policy 2005, National Action Plan on Climate Change, Renewable Purchase Obligations, National Tariff Policy, etc. So first let's see what is the role of MNRE, that is Ministry of New and Renewable Energy, in policy formation. Ministry of New and Renewable Energy is responsible for formulating national policies and strategies to promote renewable energy development in collaboration with other government agencies such as Ministry of Power, Central Electricity Regulatory Authority, Regulatory Commission, and all the state electricity regulatory commissions. Further, MNRE plays an integral role in establishing national renewable energy targets and formulating policies so as to fulfill those targets. MNRE also prioritizes rural electrification such that electricity can be reached to all the rural areas and nobody lives without electricity. MNRE also advocates for innovation and research in renewable energy targets. It also plays a very vital role in harmonizing India's renewable energy policies and global frameworks and commitments. Now, what are the provisions of Electricity Act which deal with renewable energy? So first, Section 86 Clause 1 Subclause E requires state electricity regulatory commissions to guarantee that a specific percentage of electricity that is consumed by the distribution companies is derived from renewable energy sources. Under this provision, renewable purchase obligation has been implemented, which require the SERCs to direct the distribution companies to purchase the electricity from the renewable energy generation companies. Section 42 read with Section 49 provide for open access of renewable energy. So what is open access of renewable energy? Open access of renewable energy allows renewable energy generating companies to directly sell the energy produced by them to the consumers by using the already available transmission and transmission cables all over the nation. Further, Section 9 permits individuals to construct, maintain and run a captive generation plan. Section 61 and 62 authorize the State Electricity Regulatory Commissions and Central Electricity Regulatory Commission to establish tariffs for electricity obtained from renewable energy sources. Now, what is renewable purchase obligation? So, established under Electricity Act of 2003 and reinforced by National Tariff Policy, renewable purchase obligations is a crucial policy which aims at promoting the generation and utilization of renewable energy. This basically focuses on the purchasing of energy from the renewable energy sources, such that certain percentage is always obtained by the distribution companies from these renewable energy sources. State electricity regulatory commissions have the duty to set the targets, RPO targets, according to the local renewable energy potential and needs. Renewable purchase obligation is anticipated to play a crucial role in achieving the net zero carbon emission, which is to be achieved by 2070 in India. Further, there are a few challenges in the Indian renewable energy sector which needs to be removed such that the renewable energy sector can be properly developed.
Have any international or treaty charter section in this? International Solar Alliance or CDRI?
So, International Solar Alliance was developed by India recently. India has co-partnered in developing the International Solar Alliance, and it is aimed to lead India in the solar powered production. So the challenges are such that they need to be further. If the challenges are removed, various opportunities can be developed for the renewable energy sector in India. These regulatory policies have developed various success stories for India's renewable energy sector. As we can see, Gujarat has been leading in the wind energy with an installed capacity of over 12 gigawatts. Rajasthan's solar policy has developed its installed capacity of around 24,224 megawatts of solar power capacity. Tamil Nadu has a renewable energy mix with 11,000 megawatts of installed wind capacity and 9,270 megawatts of solar capacity. Further, India's global leadership in solar power with installed capacity of 90 gigawatts has also co-founded the International Solar Alliance, in which 100 member countries are now the members of the International Solar Alliance. Further, for developing the renewable energy sector, certain recommendations are to be given, such as all state level policies should be harmonized so as to improve the development in renewable energy sector. If the grid infrastructure is strengthened, then the energy produced from renewable energy sources can be properly incorporated in the grid, and it can be provided. I'll conclude in just 1 minute. Boosting financial incentives and R&D investments can solve the cash crunches for the production and distribution companies. Promoting public-private partnerships can boost the participation of the general public in the renewable energy sector. For conclusion, it will be correct to say if the proper renewable energy policies are implemented, then it is the only key to achieve the net zero carbon emission by 2017. Thank you.
Yes. Thank you, sir. The last speaker of the session is Smriti Raturi on gender mainstreaming and climate change, a study in special reference to Global South.
To hear from Manvi. That made Bachani Devi, Sudesha Devi to actually collaborate with Sundarlal Bahuguna ji and other people. And we actively participated in Chipko movement during that time. And I've heard numerous stories from my Nani. She is 103 years old, still alive, happy, enjoying her old age in Dehradun. And we have seen through our very own eyes how gender mainstreaming, because my topic for today is gender mainstreaming, where I will be talking about women contribution for bringing change in climate change. So in countries like India, we don't talk much about women contribution, but very countries like Nigeria, Vietnam, they have set a model for the world to actually talk about women participation in the climate change. क्या प्रॉब्लम हो रहा है? अच्छा, what we can do, मैं आपको मेल कर दूँ किसी को, व्हाट्सएप कर दूँ, कर दूँ, ओके, एक नंबर दीजिए मुझे. Gender mainstreaming was first introduced in 1985 Nairobi World Conference on Women. It was established as a strategy in international gender equality policy through the Beijing Platform for Action, adopted at the 1995 Fourth United Nations World Conference on Women in Beijing, and subsequently adopted as a tool to promote gender equality at all levels. Gender mainstreaming is entirely different concept than gender equality. When we talk about gender equality, we say that we presume that we are keeping men and women at the equal pedestal, and we are concentrating on both the partnership between both men and women. Gender mainstreaming has taken us, this concept has actually created nuisances when we were talking about gender equality, because here the women took a setback regarding the climate policies, because what we have seen during climate change, that we women are the people who take care of our household. We are responsible for collecting water, firewood, etc. So climate change is basically visible over a shorter period of time compared to average temperatures between 1961 and 1992. And we all know that our earth temperature is increasing by 1 degree Celsius, which can lead to many catastrophic effects for the whole world. Climate change has a greater impact on those sections of the population in all countries that are more reliant on natural resources for their livelihoods and who have least capacity to respond to natural hazards such as droughts, landslides, floods, and hurricanes. Women commonly face higher risks and greater burdens from the impacts of climate change. And this has been throughout the world, that women are more poorer than men. About 70% of world's women are poor. Women's unequal participation in decision-making processes and labor markets compound inequalities and often prevent women from fully contributing to climate-related planning, policy making, and implementation. Climate change and gender. Climate change is not gender neutral. Women in developing countries are particularly vulnerable to climate change because they are highly dependent on local natural resources for their livelihood. Women are charged with securing water, food, fuel for cooking and heating face the greatest challenges. Women experience unequal access to resources and decision-making processes with limited mobility and rural areas. Effect of women due to climate change. Effect on women due to climate change in Asia. Women, young girls and children come under vulnerable groups. There has to be adaptation by the vulnerable group for survival with the change in climate, especially in those countries where people are dependent on the climate for their crops. According to fifth report by IPCC states that in the upcoming year, the per capita calorie availability, childhood undernutrition, nutrition related deaths will have a negative impact in developing countries. And as we all are seeing, the effects of climate change are seen throughout the world, not only specifically to South Asian countries, but in other parts of the country. Gender-based vulnerability to climate change. Women are not well represented in decision-making processes, which constrains their ability to meaningfully participate in decisions on adaptation and mitigation. Though global leaders are always talking about, and I've heard in many media reports that they usually call women, they project women as that if you want to talk about something, talk to a man. If you want to get the work done, talk to a woman. Still, we are facing challenges. We women are not participating in decision-making processes. Globally, only 17% of cabinet and 19% of parliament members are women. Out of 11 Pacific Island developing economies that was studied, 5 had no women members in parliament at all. A global gender gap in earning and productivity persists across all forms of economic activity. Women between 30% to 80% of male annual income. Restricting job opportunities for women has been costing the region approximately $44 million a year. Then I have added some studies which talks on similar line and length. Climate change is a complex challenge. It represents the most complex challenge of our time. It requires a concentrated, proactive, and holistic response. Gender inequality may dramatically limit the resilience and adaptive capacity of women, families, and communities. It may also restrict options for climate change mitigation. Evidence shows that women empowerment and advancing gender equality can deliver results across a variety of sectors, including food, economic security, and health. It can also lead to more environmentally friendly decisions making at household and national level. Why women participation is important. This is what this presentation shows here, the kind of presentation women have. And the source is UNDP Asia Pacific Human Development Report 2011. Over the next decades, millions of people, particularly those in developing countries, are expected to face shortage of water and food and risk to health and life as a result of climate change. Poverty and climate change are closely related. The poorest and most disadvantaged groups tend to depend on climate-sensitive livelihoods, that is agriculture, which makes them disproportionately vulnerable to climate change. What can be done? The answer is women can be positive agents of change. Women activities in food production, community management, natural resource and biodiversity management, education of children and family care place them at the center of development. They are collectors of fuel and water for their families and users of energy to prepare food and care for the sick. In developing countries, they engage substantially in agriculture production, both paid and unpaid. Thus, recognizing and supporting the activities and needs of women is essential for socio-economic development. The conclusions are: we need to conduct an in-depth and evidence-based analysis of women's and men's roles in sectors impacted by and their struggles for coping with climate change. Integrate gender perspective throughout climate change programming to effectively address both women and men's needs and priorities. Ensure the full and meaningful participation of women and achieve gender equitable outcomes. Ensure mitigation and adaptation efforts also address sources of gender-based vulnerability, gender inequality, and poverty. Incorporate gender perspectives into national and international climate change finance mechanisms and strategies. Establishing a framework that enables girls and women to take action to protect the environment is the first thing that needs to be done in order to begin addressing the challenges posed by climate change. There are other suggestions which I have written, and in the paper I have done 5 case studies, and those case studies are related to the first case study is the Africa Adaptation Program, AAP. The goal of this adaptation program was to improve the level of knowledge that Nigerian women had in the areas of climate change. Such kind of programs are not there in Indian setup. So they actually took care of Nigerian women and formed policies around them. The another case study was the Women's Union in Da Nang City, Taiwan, where they worked on the similar lines. They asked women to participate. They asked women to be part of policymakers. And we have seen great outcomes from these 2 programs. I have mentioned 3 more programs, but because of the proximity of time, I will not be discussing them. I am so thankful for your patient listening. Thank you so much. Thank you. Thank you.
Quickly, you require food and you require food for thought. So I'll speak 3 sentences and then question answers can. One is that the international law on global climate change and how to combat is clear and it's in. Yeah. So the law on combating climate change is in place. I think the challenge is how do you implement this? The challenge is because unlike ozone depletion, mercury problems, transboundary waste, other issues, climate change, it starts from use of firewood, it starts from use of your buffaloes, it starts from gender mainstreaming needs of water, women traveling in Rajasthan, any number of places to get water. It has become a life and death issue for certain states who are, who see a real possibility of them drowning or the disappearing from the face of the earth. So it is a global problem. There's a recognition of a common concern of mankind. From that, the law was set in place, and as many of you people spoke, you have the principles, you have CBDRC, you have, equity, you have climate action, you have a new term after Paris Agreement, climate justice. All of these are extremely important. I think there is lack of love, there is lack of good neighborliness, lack of friendliness, which are essential principles of international law and relations. There is a 1970 General Assembly resolution on cooperation and friendliness among states. It's called as a Friendly Relations Declaration. So I think that was at 25 years of the UN. Yesterday was or day before yesterday was the UN Day. I think in 1970 countries rededicated themselves to the principles of the Charter to cooperate and help people who are suffering. So I think that particular cooperation is missing. So having said this, I think question answers are open. Any questions? First from the audience and then maybe the speakers. Any questions?
Yes, sir.
Yeah.
Very beautiful presentations by everyone, but particularly Spriti ma'am and Manvi ma'am. I'm so impressed, so happy to hear your papers. So just extension to what you have spoken. You've spoken about gender mainstreaming. Along those lines, I believe what our indigenous cultures teach and what our the general human legacy teaches to take care of nature, I think it should be forwarded to children, most importantly in schools, because Sir was speaking about historic responsibility. And if we include that, then the ones who are studying today, who are growing up today, are the people who are going to take it forward. Right. So even if we are talking about it over so many tables, unless it's carried forward to the young minds, they're not going to value nature. Probably they'll be behind money and more industries and mining and oil and other things. So after the seminar, I'd love to catch up with you guys to talk about implementing this into the education system. Of course, we have environmental studies, which is a 50-mark paper where children just go and write down something, but something that's practical, where they really understand, the Chipko movement, how much love they have for trees. Imagine we encourage children to actually grow trees and, like Sir was saying, love for nature. If that's there, I think we won't have to sit around tables to discuss about how to conserve nature. I mean, it's the air that we breathe that we are ruining today. So thank you all for the beautiful presentations. Thank you.
Discussion going on the climate finance, and COP27 is also discussed, but nothing has come out properly and satisfactory. So how can we mitigate, it will mitigate the finance crisis or a fund, damage fund, and how can we means that developing country like India contribute there? What is the future and how can we go on that to bring that satisfactory solution.
You want me to answer that? Yes. I'm from the government. So, I think, to be very frank and very, honest, India is doing much more than many other developing countries are doing in the field of combating climate change. Not only have we put in place international initiatives such as International Solar Alliance, the coalition for, CDRS, as they call it, Resilience Initiative. We have a lead IT program. We are also actually having a very ambitious plan to reduce our, non-renewables. We have, by 2030, we have crossed many targets. So in that sense of the term, these are what are called as no regret measures, what we are doing, despite our per capita emission being less than 4% of, the global average. So we are doing much more than, many other countries are doing. Global finance has to be seen from richer countries to developing countries. There are vulnerable countries facing, adverse impacts of climate change. All of these countries have a genuine demand. And as you correctly said, and Naveen spoke about state responsibility, I really don't know what the court may say. The advisory opinion is hortatory, it's, persuasive. States may not want to abide by that. States, see, end of the day, the court would say these are the principles on which you need to negotiate. But it is for states to sit down and say who will get how much amount of money, or how much fund would be given to in the loss and damage fund. Yes.
If I may just comment on that, because that is something, of course, as was pointed out in the question, that is crucial to COP29. And it's not a question so much of developing countries, as you point out, it's a question of what developed countries will do. But I think one thing that we need to recognize that is happening by inertia is when developed countries aren't acting, these type of advisory opinions, for example, that are coming are setting the stage for contentious cases. There are a lot of countries that are subject to the plenary jurisdiction of, for example, the International Court of Justice. If there's a principle set down that countries are responsible for, if they do not take adequate action on climate change, for the damage caused to other countries, which are going to be mainly developing countries, under international law, a developing country can claim from one state all its damages related to climate change. And if several developing countries do that, we're talking about trillions of dollars minimal on that. And the second phenomenon that's happening is one that was indicated by several of the speakers. In domestic courts, and I think you mentioned it, there are cases being brought against companies. I was involved in the Urgenta case in the Netherlands, which was a case that made the Netherlands, a developed country, do more on climate change. Unfortunately, they didn't include finance in that, but I think it would be successful if a similar case was brought related to finance on that. So if the countries will not act themselves under the negotiating regime we have, I think litigation will unfortunately be the answer, as it often is in domestic situations. When a issue cannot be resolved on political basis, then people have to litigate to claim damages for what has happened to them.
Yes, Professor, I would like to make a point to that. Will it simply be confined towards the mic? Yeah. Will it be simply confined towards as you said, the state responsibility will give rise to few litigations. Like we already have litigations based on human rights and other thought and other greenwashing, etc. But greenwashing thought and
human rights based litigations are going on, as we all know about the agenda, the Shell, etc. But will it be simply confining to the domestic litigations based on state responsibility, because it gives rise to certain kind of responsibilities in terms of due diligence, because stringency is going to be more on due diligence. Your stricter actions will have to be based upon due diligence, because as science advantages, you foresee more things that is going to happen with regard to your actions on climate and its impact on the environment. And similarly, you can see that some kind of this customary international law also coming into play when you bring state responsibility. And these things will gradually evolve over a period of time, but will it be confined simply to the domestic litigations, or There will be more scope for, in the light of what Dr. Lutherji was saying about with regard to that. Unless we have a solidarity or some kind of friendly relationship or commitment towards how persuasive this advisory opinion is going to be. So do you have a point on that, on how persuasive?
What I just said is that there'll be litigation, I think even less perhaps in domestic forums, because if you litigate in India, you're litigating against the Indian government. And as I indicated, particularly on finance, they're not the ones that have to provide the finance as much. I think there'll be interstate litigation, for sure. I'm one of the people that was involved in a group. It was an NGO initiative to bring this advisory opinion to the International Court of Justice. Vanuatu is the country that initially brought it. There later over 130 states that joined it, and then the General Assembly, the majority, voted on it to bring that opinion. But it was initiated by NGOs, as these often are. And it was initiated with the idea that we will get a statement of law from the International Court of Justice that will be helpful in interstate complaints. And I can tell you, I don't think it's a secret, right now there are some states, including your own, that are already planning cases against other states based on what they hope will be the outcome of the ICJ opinion and perhaps other opinions that are being brought. Well, that's what your climate negotiators tell me. I hope they're telling me the truth. But